if I don't do nothing else, I'm gonna talk the law. Let's talk about it. But before I get started, for those who may not know me, I'm a Texas trial attorney going on my 5th year in the game. Y'all see the law license on the wall signed by the 9 justices of the Supreme Court. I was minding my business and I was drinking my water. And they say we got some more motions to hear today. So I've been watching the trial court. I had some other stuff I had to get done this morning. Thank you for popping on. I'm going to go ahead and join into the courtroom. And right now they are going over motions for Kenneth Copeland. They haven't went over anything yet. And they're trying to see what statements should come in and what statements should be left out of Woody. So it's just the lawyers arguing right now. So let's see if we can join into the courtroom and see what they're talking about.
These gang members, and to give the court a little more context, the Little Wayne bus shooting, what we call it, is one of the acts. We've already presented evidence about this act. It occurred in April of 2015 in the midst of what we believe to be an all-out gang war with YSL. Essentially, the state's allegations are that Mr. Williams was in conflict with Dwayne Carter, also known as Lil Wayne. On an evening in Atlanta, several members of YSL went to a venue in which Mr. Carter was performing, and they created some type of ruckus outside of the venue. Later on that evening, a number of YSL members followed Mr. Carter's tour bus to essentially to their hotel or en route to their hotel and shot at their tour bus. What Mr. Copeland tells police is that Demikion Garlington told him that the individuals that shot at the bus were DK, who's also known as Walter Murphy, a YSL member, and Shannon Stillwell, a YSL member. Jimmy Winfrey, another YSL member, actually ended up pleading to the case.
Okay.
And so we believe that this will be a co-conspirator statement. So
I don't think so.
That is kind of the context of that statement here.
All right. So what Mr. Sharp was trying to sort out is, do you have, sounds like you had previously, and by you now I mean the state, had no objection to lines 1 through 10 of page 61 coming in. Is that still your position?
No objection of it coming in. Yes, we have no objection of it being played.
Okay.
Right, that was never an issue.
Okay, and it's still not. All right.
So, and I don't think we need a ruling on the intrinsic. I mean, this doesn't really further my interest, but just to be honest with the court, I don't think this is an issue of whether it's an intrinsic act, because it's pled in the indictment as an overt act.
Yeah.
Part 1. So
okay.
I don't think that's the issue. The issue is the state is just saying, well, we think he got this information from Demikion Garlington. There's 2 issues. A, we think he got this information from Demikion Garlington. I don't know where they're getting that from. That's 1. Other than speculation. 2, then it also, if they were to be able to show that he was the source and that he's a conspirator, then we would also have to, it sounds a lot like spilling the beans. So there's 2 aspects to that where the state burden is on the state, and I just don't see them meeting it.
So DK, I'm sorry, y'all. It's going to take me a minute to get all the names. DK is who in real life?
Walter.
Not real life.
And Mr. Garlington goes by D, right? Who is Little D?
There's 2 Little Ds.
Oh. There are 2 of like lots of these people. Okay.
So one will be referenced as Little D from Mechanicsville, and that'll be Demikion Garlington.
Okay. So does he go by both D and Lil D?
Primarily Little D.
Okay, and he's Garlington, but he'll be Lil D from Mechanicsville.
Yeah, he also is referred to as Scarface.
Okay.
In the indictment.
All right. And then the other little D will be,
Quindarius Zachary, Quindarius.
and when they say little D,
From Cleveland.
Cleveland. All right. So we got
And they also call him sick.
sick D, Lil D, or sick D. And he'll be from Cleveland. Okay, thank you.
And Your Honor, it's not speculation that Demekian told him this information on page 61, line 22 through 24. Mr. Copeland says, little D, that's how I get all my information through little D. Which little D?
You don't know.
D ain't, and they clarify, he says Mechanicsville, which is Demekian Garlington.
Okay.
I'm just not reading it that way.
All right, let's see.
This
So
is crazy.
maybe we'll listen to it. See, this might be one of those times when we need to listen to it.
And Your Honor, so sorry, a little earlier. I'm sorry, about 10:18:52,
Okay.
but we're going to be listening around 10:19:12.
Oh, we behind. Or Fox is behind. A few seconds. They already, because I'm monitoring it on another stream. There we go.
They were on, they say Shannon DK now. DK with DK right here, so the last name, yeah. Who's on Libby? That's how I get out my information to Libby. The Kenneth. Yeah. See, he not gonna be able to tweet all day. Twitter is, man, this how he gonna do all day. I mean, he gonna be, everybody, he'll reach everybody. Everybody, I mean, talk to him. You know what I mean? So, I would say, hey, like, I call you right now. If you know what you see right here, what's going on. So, well, I don't know the deal about this, bro. If you know you didn't even plan on killing me, bro, why you never told me? You know what I'm saying? Say you plan on killing Tit too. Shannon gonna kill Tit. Nah, dude. Why don't you kill Tit?
I can replay it, Your Honor, if you need me to.
So
Oh,
this is my problem with this argument here. Typically, in every case I've ever dealt with a co-conspiracy, in every case I've ever read involving a co-conspiracy appeal, the declarant said to witness approximately 2 weeks after the murder, while at the Exxon gas station, that it was the defendant and his friend that committed the murder, and that the person needs to be quiet about it, etc. There's a time, there's a place, there's what was said, it's who said it. Here, Mr. Copeland comes out with some hearsay, some vague hearsay information about the Lil Wayne shooting, who did it. They ask him, what about Lil D? And it seems, I'll concede, it seems they're talking about Garlington. And Investigator Dennis is the one talking, and he's clearly asking about Demekian Garlington, I think that's fair. And he just says, well, Lil D, that's where I get all my information. He's on Twitter a lot. He gossips a lot, essentially is what he's saying. There's, I don't take a general statement of, oh, Lil D, he's a gossiper, that's where I get all my information, as sufficiently specific to this particular piece of information to say, Demekian Garlington told me, and I know you don't need an exact date, but Demekian Garlington told me, about a week after the Lil Wayne, if the state wanted to bring this in, I would expect to hear, yes, Demekian Garland told me about a week after the shooting, we were hanging out at the Exxon gas station, and he told me Shannon and DK did this, but that's not what we have here. It's just a vague statement. Oh yeah, I get all my information from Lil D. So I don't think that's sufficient to particularly say that he's the source of that particular information. And then, of course, again, it's the beans when it really comes down to it too, because there's no context that would lead anyone would allow Your Honor or any of us to conclude that the state has proved by preponderance of evidence that somehow a statement that we don't even know was made, where it was made, the context of what it was made, was somehow in furtherance of any sort of conspiracy. So I just don't see how you are armed with making any sort of determination that it falls under 801 D2E, and of course the burden is on the state to arm you with that information.
Hey, what's going on? Good morning to all y'all. I try not to talk when they talking so we don't mess up the audio. But thank y'all for popping in. They ain't really talking about too much anyway. Shout out to GG. Politicking with Mel. Good morning.
Yes.
Shout out to
While
Jamal.
you're reviewing this, with all due respect, I want to renew my motion for mistrial based upon the entirety of the record up to this point. I think it's impossible for you to parachute into this. I think this morning demonstrates why it's very difficult for the court to do that without having the background of the last 6 months of testimony. We're now replowing people issues.
All right, we're replowing because everybody agrees that, and I don't mean to interrupt you, but I, want to clarify that everybody agrees that everything that Mr. Copeland testified to in front of the jury after the motion to recuse was filed on June 12th has to be redone. So that's why we were replowing this.
No,
go ahead.
Okay, but
yes, I don't know everybody's nickname yet. That's true. But this is not in front of the jury, and evidentially, I'll either make the right ruling or I'll make the legally incorrect ruling, and that's something for potential appeal. That's true in every case, and I don't ever know the facts of a case before I start to take, it to trial. I find out in the course of the trial, or I find out as the motion is being presented. So yes, it would certainly be easier if I had heard 6 months of testimony that came before this.
She mad now.
I don't think it is a basis for mistrial.
I disagree entirely. You would know the basis and the people's names and the testimony had you
been here.
The trial judge up to this point. And I get your point. Before trial, you don't necessarily know the evidence. We are way deep into trial now. You would have heard this evidence. You would understand the context, and we wouldn't have to replow the contextual basis. So I'm just renewing my motion.
All right, I appreciate it. You're not wrong about factually speaking, it is more difficult, but legally speaking, it is overruled. Mr. Steele.
As you're making this analysis under 20 OCGA section 24-8-801 D2E, I'd like the court to just denote that in a good case, that I think is a good case, Stafford, STAFFORD versus State. That is 312 Georgia, 811. It's in Division 5A as in Elisa. 865 Southeast 2D 116 2021.
Yeah, I don't know what.
And the reason I'm listening intently, I don't mean to interrupt, but the state's here is that any statement made by a supposed
I
co-conspirator
don't. No, I don't. I don't know what that is.
to another
Let me
co-conspirator
see.
who speaks with the police furthers a conspiracy.
Hold on.
And as Mr. Sharp said, that's just
Let
spilling
me see to
beans
make sure it's not
unless
nothing
it does something
duplicate.
to
Hold on.
promote the conspiracy. So even what the state just said, I get my information from Mr. Garland.
I will look through the full screens, then I will
My
watch.
point is that doesn't help.
No, but I don't know what that.
Because
Hold on,
if
hold on.
I'm in a conspiracy with Mr. Adams,
Yeah, it's something on here because when I pause it, look, it goes away. So it's something. The background noise is in the court. So when I pause it, then look.
stole the pencil
Yes, if you want to
as
come
part of
look
our
at it,
conspiracy.
you can come.
So yeah, there's something going on with Fox. Let me see.
Doesn't do anything to assist.
Yeah, everybody else is saying it on the comments on Fox.
Alibi.
They're saying
So the point I'm trying to make to you is,
it's a lot of noise.
Yeah, no, people are just.
I'm not so sure.
Let's go to somebody else's stream.
Like, I'm just telling you, I know you're.
Well, let's go to somebody else because Fox is tripping today. Who else we got?
I'm not so sure that there is a conspiracy. Like I'm just telling you, I know you're working hard, and it's all appreciated. But Mr. Nichols hasn't really been mentioned in this case. He was not mentioned.
This
in
has got
opening
too many
statement. He
logos.
has one little section on I can't remember the year, 2014, but I don't know the year. Small drug case. Otherwise, he's not mentioned.
Hold on, hold on. We're gonna get a good. Let's see.
Just getting information does not further a conspiracy. That's my point. Thank you.
Thank you.
And, Your Honor, if I can add some additional facts, because I don't want to. This is not the only time in this interview that Mr. Copeland talks about the Lil Wayne bus shooting. So this is the first time. He actually talks about the details of the shooting.
Yeah. Thank you, 313. The
At
best.
least two more times throughout the course of this interview. So this interview is 9 hours long. And so in the course of that interview, he gives more and more details about the shooting.
All right, maybe point me to the parts of that. So it's, I don't know if you were able to pull up Stafford or if you have it, if you've looked at it previously, but what it says is the same thing that Mr. Sharp's been arguing for a while about co-conspirator statements. And that is essentially that even where there is a conspiracy that has been established by a preponderance. No, I lost my place. Hang on. Here it is. Hearsay statements that implicate a co-conspirator but do not advance any object of the conspiracy, such as statements that merely spill the beans about the conspiracy, are not admissible. So if you can point me to how this advanced the conspiracy, and I understand your argument is, hey, the conspiracy is they're all members of an ongoing gang. They need to know what's going on in the gang so they can react like appropriate gang members and be prepared if somebody's coming after them. And that's a reasonable position to take. So tell me how it is that this is advancing an object of the conspiracy and not theoretically where your evidence is going to show that.
Yes, Your Honor. So during 2015, there were just a number of different events and actions that took place beginning in January of 2015, all the way through about October of 2015, Your Honor. This particular shooting of Lil Wayne's tour bus was a part of two events. So Lil Wayne, I'm trying to simplify how Mr. Carter is a part of this. So starting in 2014, Your Honor, Mr. Williams had began a musical relationship with a person by the name of Brian Williams, also known as Birdman. Lil Wayne was one of Birdman's artists at the time, back in 2014 and prior to that. Evidence has come in that members of YSL, specifically have made threats against individuals who we believe supported Lil Wayne during this ongoing dispute that they were having.
Is Birdman alleged to be in a rival gang, or he's just a rival record producer in the industry?
He wasn't a rival to Mr. Williams, so he was friendly with Mr. Williams. Lil Wayne, we believe, became a rival, and we're talking about back in 2014 and 2015, of Mr. Williams at some point. At some point, there was some friction between the two of them in which Mr. Williams made subtle threats to Lil Wayne via social media. That evidence has been entered before this jury. And we believe that the gang, when Mr. Carter came to Atlanta, there again, like I said earlier, members of YSL just converged on the compound. They left their different, I think they were at a music studio. They all came there in an effort to intimidate or threaten Mr. Carter.
Okay.
So informing another gang member of those activities is keeping him abreast of those activities. I believe that Mr. Copeland, we're going to confirm, was incarcerated at the time of the Lil Wayne bus shooting. And I want to make sure I confirm that for the record. So we believe that he was being kept abreast of what was happening while he was incarcerated. And then once he was released, he was provided this information in order to, whatever the next steps were, whether it would be to further intimidate Mr. Carter, but he was made aware of everything that occurred while he was in custody.
So do you have any evidence that then when he got out of custody, he also began to participate in this threatening of Lil Wayne and his peeps?
No, we do not have any evidence.
Okay, so then how is it furthering the conspiracy of being in the YSL gang and not just, hey, guess what happened today?
No
Because
evidence.
it fosters cohesiveness, the fact that this YSL gang could literally shoot at a bus of a famous individual. It made the news, it promoted the notoriety of YSL.
Yeah, the shooting might have, but how is telling Mr. Copeland doing anything to further it?
Because he then can claim notoriety as being a member of YSL.
That helps him? How does that help the gang?
Because it promotes their notoriety, the fact that YSL themselves had the ability to shoot at a famous person. That promotes the gang across. It made headline news. It made news.
That may be. Again, how does then apprising Mr. Copeland of it further the purposes of the gang?
Because it furthers his involvement, because he's still in the gang. He can still promote himself. He still promoted himself as YSL, as being a part of the group that shot at the Lil Wayne's tour bus.
Do you have any evidence that he does that?
No.
Promotes himself as YSL?
That specific act.
Hey, I'm part of the group that shot up the bus.
I don't have evidence of him saying I have evidence of him saying he's still part of YSL and claiming affiliation with YSL, because collectively they shot up the bus, not the specific individuals, but collectively as a group, they shot at.
Does he post or brag about YSL shooting up the bus?
Nope. She said twice, I have no evidence.
No, we do not have any evidence of him
3 times.
posting on social media YSL shooting up the.
Oh, that's funny.
All right, so we are then looking at 61, line 22 through 62, line 14, where he says, I get all my information from Lil D. Because everybody's talking about it. He knows what's going on. And I don't think y'all have sufficiently satisfied the co-conspirator exception there. I'll keep that part out. Let's move on to the next one.
So, Your Honor, then there's, and this is where I'm not sure what the state's, 62, the beginning of, I'm sorry, the beginning of 62, they just talk about Lil D from Mechanicsville just being a gossip. Now,
Yeah, that's what I just excluded.
well, you excluded, in my understanding, you excluded the part where he talks about the Lil Wayne bus shooting. And then after that information he gave, there's a section, and I don't have a strong
No,
opinion.
y'all all said nobody cared if that came in 1 through 10. Nobody cared.
Yeah, 62, 1 through 10, I agree.
That's
I don't
lit.
have a strong opinion. I was just trying to understand if the state had an opinion about that, if all of that was coming out or all of it was coming in. The 1 through 10 on page 62. I don't have an opinion.
No objection to it?
Yeah, no. 62, 1 to 10, the state is okay with coming.
Okay.
Okay.
I'm just trying to clarify. So
All right.
But then starting at 11 on page 62, there's another aspect of this where it's not the same issue. It's something about Kenneth Copeland talking about potentially Jeffrey was going to have Tick, and Tick is a gentleman named Trontavious Stevens, who is also known as Slug, who is he entered a plea in this case.
Your Honor, that portion is redacted.
Okay,
62, line 15 through 22 will be redacted.
Okay.
All right. Next.
Next. Jill's not playing.
I believe the defense wanted next page 62, line 23 through page 70, line 16 out.
Tell me again, 62,
Page
line
62,
23.
yes, line 23 through page 70, line 16.
16, okay.
Yeah, this is crazy. They need to let this go. Let it go. All right, y'all. Hold on. Let's Why they got a break going on? I want to I want to take this time to say a big thank you to Ken Goddess. Thank you so much for that nice cash app you just sent me. I'm going to post it real quick so we can have, I ain't going to post your information, just the cash app. Thank you so much for the $100 that you just sent me. To say for blessing and thank you. That's really kind of you. You always supported the channel, so thank you so much for that. I just have to do that real quick. We're not missing it in the courtroom. And I know you didn't have to do that, but that was really kind that you did. Y'all don't mind putting King Goddess' name up and down the chat. That was really nice.
All right.
Your Honor, my recollection of this, and I'm not saying that the state's misrepresenting anything, but I don't think I don't recall having a blanket objection. Now, there's certain parts in this transcript as a whole, and they're coming up not to 72, but a little bit after 72 that go back to Lil Wayne's bus shooting. And our stance is all that is covered under your last ruling. I mean, all of it's the same general situation. But regarding these pages 61 to 72, what I have is I objected to 70 page 70 lines 16 to 19, where it's just investigator Dennis identifying, it's not Copeland talking, but investigator Dennis says,
If Shannon is a shooter.
Shannon is his, meaning Jeffrey's shooter. Why would he put these?
Yeah.
I think that's inappropriate to have the investigator, just put that out there. And then after that,
I'm gonna get it right. Come on, there we go.
and then line 72, lines 5 through 13. Again, it's investigator Dennis kind of giving his theory on everything in the relationship between Kenneth, Jeffrey, and Shannon. And it's not needed to add context to anything. It's just kind of him giving his theory.
All right. So does anybody have an objection to pages 62, line 23 through, I thought you said 70, line 16?
That's what I
Anybody have an objection to that?
Hey.
No.
Nobody has an objection. Speak now or forever hold your peace. All right, there's no objection to that.
And as it relates to what Mr. Shar just mentioned, page 70, lines, we have
Six, yeah.
17 through 19, we have no objection to
To
that.
redacting that?
No.
Okay, so 17 through 19 will be redacted. Page 70, lines 17 through 19.
And also, I believe what he just said, page 72,
Lines 5 through 13.
no objection to that as well.
All right.
Oh, 72.
Yeah, 313. I told Slick that you was a woman.
Okay.
You've been up here
Next.
before. But Slick kept saying, no, that's not a woman. I said, bro, she been up here before. He argued me down.
The next portion that I had initially was page 70. The defense wanted redacted was page 72, line 14 through page 73, line 21.
All right. Does the defense still have an objection to that?
And also, thank you to 313. Last time you had,
No, 72, 14 through 21.
last time you sent me,
72, line 14 through 73, line 21.
Okay.
she ain't gonna let me talk. 313, last time you sent me a cash up, you had logged out before I got a chance to see it. So thank you so much. 313, the best side, not the op side.
God bless you.
Okay. Anybody, any of the defendants have an objection to that portion? Sounds like a no.
Okay. Then you're on the next portion, I believe would follow under your previous ruling, which
Yeah, he kept saying she was somebody else, and I was like, no, she's been up here on the stream before.
redacted, which would be page 73, line 22.
Whole
through
camera.
Page 78, line 16. So
Okay.
Right.
I don't think there needs to be any further discussion.
All right.
More than one time she been up here. I don't know where he got that from, but he said it was somebody else got the same name, I guess.
Look at us making progress.
Somebody trying to steal your name.
Your Honor,
Yes.
can I briefly, having read Stafford, just address something briefly related to the case item?
If you talking to
Your Honor,
Mike,
in regards to Stafford, it's quite distinguishable by the mere fact that it appears from reading this that this was a co-defendant's statement to the police, and that co-defendant did not testify. So what they were arguing was a co-conspirator in furtherance of the conspiracy was what this individual told the police. We have Kenneth Copeland here on the stand who can cross-examine, so it's not what he said verbatim to Detective Dennis, it's obviously what he stated other co-defendants.
Right.
And so I just think Stafford is quite distinguishable from the facts at hand, because there could be a situation where a co-conspirator is trying to throw off the police, tells them a lot of lies, which furthers the conspiracy, but that's not the situation we have with Mr. Copeland, who's live and cross-examined.
Okay. I appreciate that. And when I made that reference to Stafford, I wasn't actually dealing with the facts of Stafford are influencing me to make this ruling. I was actually reading a quote from an entirely other case that's cited in Stafford just for the legal proposition. So, but thank you.
Yes, Your Honor.
All right.
Your Honor, that wouldn't, respectfully, that wouldn't be correct anyway. That would be a confrontation clause violation. What the
Right.
attorney's talking about.
But that wasn't what I was using it for anyway. So
It's hearsay.
yeah. Thank you. All right. So what's our next portion of this statement?
The next portion that we have, Your Honor, that the defense wants out is page 140, line 11 through page 143, line 16.
Ms. Hylton,
Yes.
I have 89, page 89, 3 to 25. Did you guys agree to that?
You said page 89.
Lines 3 to 25.
Yes, and I believe the full redaction that we agreed upon last time. I have it correct. Is page 88, line 23 through page 92, line 20.
So y'all agreed that that's out.
Yes.
All right.
Yes.
There's a small portion that we can play, which was page 91, lines 20 through 21.
91.
Lines 20 and 21.
Everybody good with that?
I don't know. I mean, in reality, I don't know how. Yeah, I'm fine.
Logistically, they're gonna
Yeah.
do that? Well, they can figure that out. All right, so then we're looking next at what line, I'm sorry, page 140, line 11 through, did you say 143, line 16? Or did I get that
Page
wrong?
140, line 11 through page 143, line 16. Yes.
And I'm sorry to keep doing this, but just so I'm certain, the other three before 140 is the 112, 24 to 114, 25. We agree on that?
Page 112, line 21 through page 114, line 25?
Yes.
Yes,
Okay.
And y'all agree on that being out?
out. Yes,
Okay.
Your Honor. And then we also agree upon page 122, line 20 through page 124, line 10. Being,
22, 20. Okay, I'm in concurrence. And then 129, I have 129.20 to 130.20 approximately.
I have 129, line 18 through 131, line 25.
Is out by agreement?
Out.
Okay.
131 line 25.
Yes, sir.
Okay, great.
Yes, sir.
I'm sending.
Okay.
All right, so now I'll read 140, 11 through 143, 16.
Thank you, Mookie. For hitting that like.
All right.
So you're right. For this part, I want to give a little bit of a brief context.
All right.
So after the January 10th murder of Donovan Thomas, there were a number of retaliatory shootings.
Right.
One of those retaliatory shootings was on February 19th, 2015, in which Mr. Copeland is coming out of his home with his daughter and his child's mother. At that time, a some members of the opposition gang drive by his house, shoot at him. He shoots back at them, and he's able to find safety. He goes to the police that evening, and when he goes to the police, they ask him for the gun that he uses. Initially in February, he tells them he'll get the gun. He'll give them the gun. He'll give them the gun. Of course, he never turns in the gun. Now in June, he is explaining to them why he did not turn in the gun. And so I wanted to give the court that context before we go into argument.
Okay, and so what's our issue with this portion of the transcript?
Defense counsel, the state believes it should be played. We believe that this is intrinsic to that act from February 19, that it completes that particular story in which this is now the answer as to why that gun was never turned in. And so that's the state's position, that it is, if it does places we don't think it's character, the fact that Shannon Stillwell had this gun. I believe that was the previous argument, that the fact that Shannon is a convicted felon and has a gun is bad character. We don't believe it's bad character. And if it is character, it's incidental character. But this explanation of where the gun is intrinsic to completing the story of what happened on February 19, 2021.
Couple things. To the extent that the shooting on February 19, 2015, where individuals shot at Kenneth Copeland, the story, the full context, individuals allegedly drive up, shoot at Kenneth Copeland while he's holding his baby, and he's with the mother of his child. He shoots back. He hits people, causes their car to crash. They're charged with this crime. Mr. Copeland's brought into the police station immediately and is questioned about things. He's never charged. Number one, if I concede that the incident itself is relevant to this case, the back and forth, that's fine. I'm willing to do that for the purposes argument. But I don't know what happened to, it's unclear to me what happened to Kenneth Copeland's gun or the gun that Kenneth Copeland fired. That is not relevant. It has no probative value to this case. My client, the fact that he is to be in possession of a gun, he's not charged for that. It's not listed as an overt act. It does place his character at issue. It's very similar to cases that he's charged with in this indictment. I believe he's charged with 2 different counts of possession of a firearm by a convicted felon. So the fact that he's charged with that exact same offense that would be implicated here increases the prejudicial value of this information. But in addition to the 401 and 403 issues involved, Your Honor, it's also based on hearsay. He's not claiming to have been there when he's saying Shannon came and got the gun. My understanding of the sequence of events, my understanding, and I'm not revealing anything my client has told me, I'm just going by what the discovery says. Shannon wasn't present. Mr. Copeland's goes to the police station. He's just been in a shootout. I don't know that he's basing any of this on firsthand knowledge. I think he's just heard this, and it's hearsay at this point. I don't think he's ever saying that I saw Shannon come in and take the gun. That's not the way I understand what he's saying. So I think there's a hearsay issue as well.
I'll hear from the state. So we've got relevance and hearsay.
And 403.
And 403.
So for relevance, Your Honor, I think it is relevant. Well, let me start with the hearsay first. I don't believe it's hearsay. I believe I'm going back through the transcript, that Mr. Copeland explains that when the police came to the house, Mr. Shannon Stillwell was inside of the home, that he left before Mr. Copeland leave. So I don't think
That's my reading of the transcript too. I mean, whether that's true or not, who knows? But what he seems to be saying is that when the police came by to get the gun, Shannon actually was there. And when Kenneth said, all right, let me go get the gun, by that time, Shannon had actually gone and gotten the gun himself and left the house. And so he was like, I can't get you the gun right now. Give me another day or two. So that's my understanding of it. So that would not be hearsay. So the hearsay ruling, the hearsay objection is overruled. How about relevance?
So as far as relevant trial, we believe that the simple fact that he gets the gun from Shannon, or it's Shannon's gun, that he has to shoot back at the opposition gang, shows one, that YSL members, they interchange guns, Your Honor. You're going to see that more evidence is going to come out that we have certain YSL members who may purchase the guns for other YSL members. So this, again, is a part of what the gang does as a part of their enterprise or conspiracy. They pass guns around, so we believe that it's relevant for that purpose. And then as it relates to 403, Your Honor, Mr. Stillwell is charged with 2 murders in this indictment, both murders by handguns. So the fact that it comes in that Mr. Copeland got this gun from Shannon is not going to, the probative value is not substantially outweighed by its prejudicial effect, given that the jury is going to hear, at least on 2 occasions, that Mr. Shannon used a gun, alleged to have used the gun, both in the Donovan Thomas murder as well as the Shamel Drinks murder. Additionally, Your Honor, when Mr. Stillwell was apprehended on March 17th of 2022, is the state's allegations that he threw a gun out of the window of a vehicle to dispose of it. So, Your Honor, we don't believe that the probative value is substantially outweighed by prejudicial effect.
If we assume the allegations to be facts, A, we would need a trial, but B, I agree, it wouldn't be prejudicial if we assumed, oh yeah, well, Shannon was in possession of a gun as he rode down the street on January 10th, 2015. But that's not what we do. That's the issue before the jury. So that's exactly what makes this excessively prejudicial, is because that's the issue that they need to determine. And this story, which really adds nothing to the state's case, the idea, it's evidence of passing guns around. I mean, they're going to have direct evidence of when Darius Zachary saying he's a straw purchaser of guns at Arrowhead Pawn. So they don't need that. And gives it to, and has distributed them to people in this courtroom or in this case. But that's exactly what's so prejudicial about this, is they're bringing in propensity evidence that is going to be prejudicial to the issues at hand, which is whether Mr. Stillwell was in possession of a gun and shooting at Donovan Thomas, whether Mr. Stillwell was in possession of a gun and shooting at Shamel Drinks. I submit to you, Your Honor, if Mr. Stillwell was charged with stabbing individuals, this would be less prejudicial.
All right, so you're now making a 404B objection also?
Well, it's 404B, but it dovetails into 403 as well. It's just the
okay, because it really can't be 404B if it's intrinsic. And you just said you agree it's intrinsic.
Well, no, I agree that the shooting itself, the shooting involving Kenneth Copeland, it seems they've argued it's intrinsic, and I don't think that my argument one way or another really makes a difference, but there's a separate incident, which is Shannon's possession of the gun. I don't believe that that's intrinsic.
Okay. All right, thank you. I find this evidence to be relevant and its probativity not substantially outweighed by the danger of unfair prejudice, so I'm going to permit that. What's our next section?
The next section that I have, defense wanted out was page 188, line 9 through page 189, line 9.
What's going on, A-Rod? He said the circus is back in town. 313 says it's giving struggling. This judge gonna patch this case together as much as she can. She ain't going nowhere. She not going nowhere.
So, Your Honor, this discussion, the context of this discussion is committing crimes. And so whatever he says, he does. And the context, in the bigger, larger context is whatever Jeffrey says, she does. That is a broad character statement in and of court. Whatever crimes Jeffrey says Shannon commits, that's a broad character statement that would violate 404B, bad character evidence, and 403, Your Honor, as well. But then, you know, they get into how much Shannon's getting paid, and it's saying nothing. Well, guess who told me? Guess who told me that it's getting paid nothing? D. So.
Well, no, then Kenneth Copeland says no.
Oh, I'm sorry. You're right. And then they just talk about
How Kenneth Copeland can't flex because he doesn't get all this stuff.
right, and how Shannon's broke is
Yeah.
so I just don't see the relevance of this. I think it invites it's speaking in very broad terms, and it's just broad bad character evidence about Mr. Stillman.
All right, so it looks like Shannon told Copeland this, so it would be a party opponent statement, because he says,
Shannon told Copeland he doesn't get paid.
correct, for the stuff, but what, more importantly, not even to get paid or not getting paid, but that Shannon does anything Thug tells him to do.
No, the Shannon told me that is about Shannon not getting paid.
No, yes, Your Honor, let me be clear.
Please.
Shannon tells Copeland that he doesn't get paid.
Right.
Yes.
Okay.
We're focused on the other portion
Yeah.
of what he says in here, which is he does everything that Shannon tells him to do.
That Thug tells him to do.
That Thug tells him to do. We have charged Mr. Williams with a leadership charge, which is count 56 of the indictments. And so we believe that that is relevant as it relates to Mr. Williams being the leader of the gang, and now a co-conspirator, member of the gang, is now telling law enforcement this other co-conspirator, this other member of the gang does everything the leader tells him to do. So we believe that that portion is relevant. What is surprising to Kenneth Copeland is that he doesn't get paid to do it, that he does it for whatever reason that he does it. And so we believe that that entire section is relevant for, one, to show evidence of the leadership count, Your Honor, and that Mr. Stillwell has conversations with Mr. Copeland about his role in the gang and why in the gang.
I'm sorry, I'm not tracking, and I think I might be missing. Where are we getting that Shannon is the source?
Because if you watch the video, and maybe this is one of the ones where you might have to watch the video, he kind of whispers to him, and on page 189, detective says he said Shannon. Shannon's telling him, but you have to see the video to see it in context. So we can play that portion.
Mr. Don Cato.
Yeah, but again, that part was about the getting paid.
Yes.
And so what Mr. Shart is asking is, where's your information that Shannon is the source of Mr. Copeland's knowledge that Shannon does whatever Thug tells him?
So Shannon, so a few things. Mr. Copeland, Mr. Stillwell, and Mr. Garlington have all very close relationships.
Mhm.
They have known each other.
Yeah, that's established in the evidence.
Established in the evidence. And so really that is his personal observation of what he notices
Mhm.
between the interactions of Mr. Stillwell and Mr. Williams.
All right.
So that's what we believe that's his source of now. That's his lay opinion about what he's observing.
Anything else, Mr. Short, on this?
No, no.
All right. I am going to permit this over the 401 and 403 objections. And I don't believe, I mean, it's not improper character evidence. It's Mr. Copeland's firsthand knowledge, and it may be damaging to your client, but sometimes the state's evidence is damaging to the defense. All right, what's our next one?
Your Honor, the next one that we have that the defense wanted out was page 202, line 14 through line 20.
If we are in agreement, Ms. Hylton, 197, 14, 199, 4.
Yes.
Did I get it correct? For your notes, the exact line?
Page 197, line 14 through page 199, line 4. And that will be redacted, Your Honor.
You said 202, 5 to 19?
14 through 20.
Okay, let me ask a question that is entirely irrelevant to what we're doing right now, except for the fact that we're all sitting in this courtroom. How's the temperature for everybody? It seems a little hot for me.
I was gonna say the opposite. It seems a little.
Dang. All right, well.
I agree with myself.
Darn it. Okay, I'm just gonna have to get a fan up here. Well, it's not up here. Okay.
And Your Honor, heat does rise, so it may be hotter up on the bench.
Okay.
Your Honor, since we called it higher elevation, we have a.
Yeah, we can have a convenience break. Sure, let's break for until 10:30. That's down as far as it'll go. It needs to be adjusted.
All right, let me get this thing set up right. Of course, she denied everything. Anything that's gonna stop the trial is gonna be denied. He said, "This is insane." He said, "The judge got." All right, y'all. So right now we're on break. Just taking a 10-minute cool-off break. She said it's hot in there. She said it's hot. I mean, she the only one sitting in there with a robe on, so it could be hot for her. Chubby says hot flashes. What y'all think about the judge so far? Y'all think she's fair? What's going on? Shade 46. He said, what's going on 305? Can Woody still plead the fifth? I mean, no one can physically force him to talk and force his mouth open and make him say the words. But on the flip side of that, we all know what the consequences of pleading the fifth can be for him. and obviously that's jail. Well, I mean, we already know she was going to deny anything that's going to stop her trial. The judge wants to be on TV. She might want to run for a statewide office in the future. Fulton County is just the kickoff. And a high profile case like this might help her out along the way. What y'all think? It'll help her. Because she's doing her best. And that's why I said deny anything that's going to stop her is deny. Regina said the 19th is when the jury come back. I don't know if they're going to go that far. And actually, I think the 19th is the week they have off. They already was given that week off. So depending on how fast they go today, and we're keeping an eye on the courtroom, depending on how fast they go today, the jury could be coming back next week. Breaking it down with B says she with the state. I don't trust her. Well, I think she did today. She ruled on a few of the defense motions. I give her that. Oh, India said not the 5th, the week after. Okay. Well, I think they want to see what they can get done now, today. They want to see what they can get done today. And depending on how long it takes them, then she can have an accurate determination for the jury. There's no sense in trying to bring the jury back Monday, and we might still need Monday to go over more motions, to go over stuff like we're going over now. So I don't think it'd be smart to tell the jury to come back right now. But I know the original goal was the week of the 5th. May not be exactly the 5th because we got to see what we're doing today. But we might get the jury back on Wednesday, Tuesday or Wednesday, and then they can work the rest of this, the rest of next week, the rest of the week of the 12th, and I believe the 19th is a week they were already granted off. All right, Tia said the rumor is the week there was no court, the judge was meeting with Glanville in the state in regards to this case. That's the rumor. So the judge was having a secret meeting. The current judge was having a secret meeting with the old judge. The new judge in the back room with the old judge. Wow. That's too much. That's too much. And this is all allegedly they were in the back room meeting. Wow. Glanville, you can't be that busy. I know it ain't that many blue pills and honey packs in the whole state of Georgia. Allegedly. Oh man. Car Global, how are we biased? If you have a different opinion, you're more than welcome to come up. I'll drop the link, Car Global. Car Global say we he said we started unbiased, now we a cult. What? Hold on, Car Global. What was your first comment? You said here we go with the judge hating. You mean we're hating on the judge, or is the judge hating on YSL? Do you want to come up, Car Global? Don't pay me no mind. Half the time I don't know no better. Not the blue pills and honey pack. That's what I'm saying. All this backroom dealing, he meeting on the weekend. Y'all saw what Love said in the secret meeting we just found about. She had said, I don't want to bother you with this Monday morning or Saturday morning or Saturday evening. Or was it Saturday night? She said, I mean, what in the world are you talking to the judge with on a Saturday night? Tell him, welcome, have a seat. Come in, drink the Kool-Aid. Y'all funny. He said, I'm not getting on the grill for y'all to cook. No, it ain't like that. You can have your own opinions. Nobody gonna grill you. What they say, Woody, you better not testify. They're gonna hammer you when you get on that stand. Don't do it, boy. Don't do it. Oh man. For the people popping in, we're just waiting on the judge to come back. Probably about 2 more minutes. They on break. Yeah, so we wouldn't do that. He said, y'all don't play. Dream Josh said, this is so political. Right. And I was thinking, Fonnie Willis would see that she losing and just pull the whole case, but she filed motions herself. She filed a motion her own self and signed it her own self, saying that her prosecutor shouldn't be, disqualified. So in my mind, she just as delusional as the prosecutors in the courtroom, as Love and Hylton. Car Global sound me here every day. Yeah, I see you popping up. Anybody gonna bother you like that? We just be talking. We talking that low. Three or five say, Miss Simply Top, are you in the building? Yeah, she was in here earlier. I'm not sure if she's working and she's popping in and out. But I do want to thank y'all, the ones that did decide to pop in. I know y'all could be watching this any other stream, but y'all decided to come by here. So I appreciate that. If y'all don't mind hitting the like button. And if I don't talk about y'all people too much, if y'all live in Georgia and y'all don't want me talking about Fonnie, if y'all don't want me to tell the truth, then I dare not tell you to hit the subscribe button. But if you say, you know what, everybody got their own opinions, and if I don't agree with him, I can come up on his stream and tell him I don't agree with him, then you're more than welcome to hit the subscribe button. Come on back. And that way you don't have to be watching from behind the scenes. Or somebody say hiding in the bushes. Tell Car Global join us. All right, y'all, we about a minute past the break time, but we'll give them a few more minutes and we'll start back up. So what we've been seeing so far, the judge is going over what she thinks should come in and what she thinks should stay out for trial purposes. 313 said, I love and hates that she starts on time. Yeah. Thank you, Regina. And from my understanding, Brian still had asked for a certificate of review to get the whole case throughout because the indictment was defective. The language in the indictment wasn't correct. And the judge denied that as well. She said, I'm not going to give you her certificate to go to the appeals court because the appeals court might shut my whole trial down. And obviously she don't want her trial shut down. So no, she's not going to grant a certificate of review, which is something I think Georgia should take a look at. If a lawyer wants to appeal or needs to appeal, they shouldn't have to get permission from the court to appeal. Right? Oh no, you got to get a certificate. That's like if you're complaining about somebody, and I always go back to my restaurant example because most people go to a restaurant or go to a grocery store, and you complaining about the employee, and you tell the employee, I want to talk to your supervisor, I want to talk to your manager. But in order to do that, that employee has to give you permission. They got to give you a certificate to go talk to their manager, to go talk to their supervisor. You think they're going to give you that certificate? Do you think they're going to give you that certificate so you can go talk to their boss to get them in trouble or get them throughout the case or get them throughout of work? I mean, it don't make sense. That's something that Georgia has going on. Let me see if I can pull up the legal definition while we got a little time. All right, let's see. For those popping in, we're just waiting. And we're trying to pull up Georgia law on certificates of immediate review. Yeah, I was trying to pull it up, but if I pull it up on my screen, then it's going to take away the court screen. So we won't be able to see when the judge come back. But yeah, that's pretty much exactly right. It's like a certificate of immediate review. So you're asking the appeals court to come in right now to right a wrong. But going back to my example, a lot of judges don't want to do it. You don't want nobody to go to your boss. But let's say you can go to my boss later in 30 days or in a year. It'd be too late then. We want to get it done right now. The judge got that ponytail in. We need the mic, Judge. Can't hear you. No, she denied it. Still can't hear you.
I have 519. That is my opinion.
What's going on with her microphone? Can y'all hear her?
If you're amending what you did before, that's fine, but before I have for you, page 202, 14 through 20, what you're saying is.
I have 202, 5 and 19 in my, but either way.
Okay.
Oh, judge helping her. I mean, her staff attorney helping her with the mic. And I think we need Max Shaw to use his mic too. Hopefully somebody in the court tell him. So we can get it all.
Okay.
There we go.
It's just a off the cuff, not referring to any specific incident of Kenneth and Shannon getting into arguments and then people coming to shoot at them. And then Kenneth saying Shannon doesn't stand for people shooting at him, is my interpretation. And then where does Shannon keep his guns at? Kenneth Copeland says, shoot on him. And that man got a gun every day. He gonna run though. And we're not talking about a specific incident. We're not talking about an overt act. We're just talking about character. Shannon keeps a gun on him. Get into arguments with people and they shoot at us. Again, not talking about a specific act. Just generally, and Shannon ain't going for it when people shoot at us. I mean, all this is just.
All right, so
very
let's
prejudicial and harmful.
kind of take it piece by piece. So there's kind of like the 5 through 13, and then the kind of 14 through 19.
Yes, Your Honor. So first with 5 through 13, Mr. Copeland talks within this interview specifically about another retaliatory shooting that occurred in January of 2015. Again, after Donovan Thomas's murder, there's an incident in which Mr. Copeland, Mr. Garlington, and Mr. Stillwell, I believe they're all in the car together when and they're driving on the highway somewhere near University Avenue and I-75, and the opposition gang shoots at their vehicle. Either before this portion or after, Mr. Copeland tells the detectives that Shannon was upset with him because he didn't want to shoot back at the other car. So I think when you think about that part of the transcript in context with this, what he's saying in lines 5 through 8, but what I'm saying, me and Shannon get in an argument plenty of times because these N-words done came, shot at us, or did something. And what I believe you hear him say, I never did shoot back at him. And so he's talking about that particular
And
incident.
Shannon didn't like that. Yeah, I saw that in other interviews. Okay.
Yes.
And
so we believe that that's relevant, that furthers what he just said earlier in this interview about Shannon not liking the fact that he was not retaliating back against the individuals shooting at them. Now, when you go down to 14 through 19, Your Honor, we do not believe that this is bad character, incidental character, Your Honor. We have a case that I would like to cite for the court, which is Lyons v. State, 309, Georgia 15, which is a 2020 case, Your Honor. And this case specifically talks about the defendant in this case thought that the trial court abused its discretion in admitting a photograph showing the defendant in possession of a gun because it improperly placed his character in issue and was highly prejudicial. And the Supreme Court disagreed, and I'll just go to what what they cited,
309 Georgia.
15.
Yeah, I mean, is it basically just for the proposition that owning guns and having guns isn't character evidence?
Correct, Your Honor. And what we've also, and it won't, owning or frequently carrying a pistol does not impute to him generally bad character, Your
Okay.
Honor. And so the
All right.
fact that his friend knows that he keeps the gun on him would be relevant, especially in this overall conspiracy and gang indictment that we have before the court, Your Honor.
Anything else, Mr. Sharp?
I'm trying to
Okay.
look at Lyons
Sure.
real quick because I have a suspicion.
If you have a,
Lyons a convicted felon?
Your Honor, I don't know if Lyons was a convicted felon, and I have not found a case in which the court distinguishes if a individual is a convicted felon, that imputes more bad character than not. And I don't know if that's the argument that Mr. Sharp is about to present to the court.
Well, okay. So I'm reading Lyons very quickly, but it seems that in Lyons, there was an argument that the gun in the picture could have been the weapon used in the crime. I mean, that's not what we're dealing with here.
okay, but is it standing for the, well, whether it stands for it or not, there is a general proposition in the law in Georgia that owning and frequently carrying guns isn't bad character evidence.
Unless you're a convicted felon.
Do you have evidence? I mean, not evidence, do you have case law on that?
I don't, but
Maybe let's put that issue on pause then, and y'all do some research and get back to me on it, because that is maybe potentially a different issue than just in general. So we'll have y'all take a look into that.
But I'll also point out in Lyons, Your Honor, it says the photograph was relevant to show that Lyons at some point possessed the type of gun used in the crimes at issue. The probative value of this evidence was not substantially outweighed by its prejudice. So we don't have the same probative value here either.
All right, well, how about we come back to the 14 through 19 portion of this page with the gun.
And I never argued about the first part of 5 to 13. I don't believe I did.
Go ahead.
But it's, again, we got an intrinsic act of them being shot at that's come out in trial. Mr. Copeland and Mr. Stillwell being shot at.
Right.
I don't know why. I don't understand the relevance other than propensity to show that Mr. Stillwell's a quote unquote hothead. I don't know what the relevance of him being upset that we didn't fire back or retaliate or do something. I don't understand. I'm not following how that's relevant.
Okay.
Your Honor, it's not relevant to show he's a hothead. It's irrelevant to show that he wants to retaliate against the opposing gang in the middle of a gang war between these two rival gangs. And so that evidence that while one YSL member didn't want to retaliate, this one wanted to retaliate in this ongoing war between YSL and YFN. And he's also charged in another retaliatory shooting later on in 2022 as still part of this ongoing war between these two rival gangs. So from 2015 to 2022, this war is going on, and Shannon is one of the members who wants to retaliate. And I think this is evidence of that.
All right. Well, I mean, it also shows the relationship between the two of them, which I would think is relevant to sorting out his basis for. Okay. I am going to permit the 5 through 13 portion in over the objections and don't find it substantially more prejudicial than probative under 403. And y'all can get back to me with any law you can find on 14 through 19. So we'll remember to revisit that.
You want a case, Your Honor?
Yeah, if you've got one now, that'd be great.
So Hall, Hall, versus State. It's old. It's 180 Georgia Appeal 210.
I'm sorry, say the first three, 280?
No.
What did you say?
180.
180, an oldie.
We're going back.
180 Georgia,
Appeal
oh, app, okay,
210,
okay.
and it's 348 Southeast 2D 736. It's 1986.
Okay.
And Your Honor, what it says is the defendant stated on direct that he knew what was in the bag. At worst, he admitted only one of the elements of the crime of possession of a firearm by a convicted felon. The simple rule announced by the Phillips court clearly states that character is not an issue until a defendant admits any prior criminal conduct. However, no criminal conduct could be shown until after is italicized, the prior conviction was admitted into evidence over the objection of defense counsel, because possession of a gun is presumptively lawful. Allowing the prior conviction into evidence in order to place the defendant's character in issue demands circular logic and defies even the broader parameters of the simple rule in Phillips. Here, I'm telling the court that there's an exhibit, I don't know the number, that Mr. Stillwell is a convicted felon.
And additionally, he's charged with possession of a firearm by a convicted felon several times in this indictment. So that increases the prejudicial value because it goes right to a substantive charge.
And
I
to say that he runs around with, I'm sorry, did I interrupt?
Go ahead.
To say that he runs around, he being Mr. Stillwell, runs around with a gun at all times, his conviction is back. It's in this case. Somebody, please help me, but I'm going to tell you it is before the supposed conspiracy even started. The conviction's back to like 2012, I think, but I'm not sure on that. I don't want to make that right.
The trial, Judge Glanville allowed the state over my objection to actually admit, I think, 5 prior convictions of Mr. Stillwell to establish he was a convicted felon.
Okay. All right, I'll take a look at it over the lunch break and give the state a chance to come up with their own case law on that. And so, I mean, are y'all kind of arguing that this is, and by y'all, I mean the defense, are you arguing, I mean, I know you're arguing, so this makes it really prejudicial because it makes it more, well, I don't know, I don't want to rephrase, but are you saying, well, this evidence makes it more likely that they will find him guilty of possessing a firearm as a convicted felon as charged?
Right, he's charged with, I think, 2 counts. Maybe
Okay.
3. And essentially, Mr. Copeland saying, hey, he always illegally carries a gun as a possession, as a convicted felon. And of course, that is, in our estimation, very prejudicial and shows propensity, which should not be considered by the jury when they consider these specific charges.
So on the propensity issue, though, are you saying this is like 404B evidence?
Well, they haven't given 404B notice.
Right, because all of this is intrinsic. And so I'm thinking if it's going to be out on the basis of its, illegal propensity evidence, it would have to not already be in as intrinsic evidence.
Well, my understanding, and I know Your Honor has a long background in appellate law, so I could be wrong. My understanding is intrinsic evidence we're dealing with specific acts. This isn't dealing with a specific act. This is just a gentleman saying, oh,
this man is known to carry guns.
This man always carries guns. He always has one on him. So, I mean, it would be like if someone's charged with murder and then like someone just says in a tape, oh, well, this guy's everyone knows he's the biggest killer of all time, and it's just like, well, that's a problem in front of the jury.
Well, okay. So, I mean, this is essentially, to my knowledge, by me, I mean, at this point, Copeland saying, hey, as far as I know him, and I know him, He carries a gun on him all of the time, which obviously y'all would not like to come in because it does make it more likely that he had a gun on the instances in which he's charged in the indictment with having a gun. But why does that get excluded? So y'all find some law and then we'll take it up after you've presented whatever you have and after lunch. Because I'm not sure that being able to say, I know, from my own personal knowledge of him, that he typically carries a gun is excludable simply because it makes it more likely that some of the charges against him might be true. That makes it relevant. So I don't know. Y'all come up with something, hand it to me later. Let's move on to the next thing. We'll circle back on that one.
The next one.
Ms. Hylton, are we in agreement on 21320 to 21416?
Yes.
You agree, we're in agreement.
Yes.
That it's out. Okay. All right.
And I just want to confirm, we're in agreement 22011 to 21.
I have 22012 through 15.
Well, 11 just says overlapping conversation.
You said to 15?
Yeah, 12 to the half of 15, so we stop after.
Either?
Yes.
Okay, all right, we're in agreement. And then 22217 to 223.6, is that what you have as next?
Yes, 222. Yes, 222 last time, 223 last.
All right, let me get to that.
The court reporter be dressed every day. She be ready.
Sorry, I was reading the wrong page.
She ready for whatever.
What do we want to?
All right.
Your Honor, I'm just going by the transcript I have and the amount of writing I have on it. I don't know if the transcript, this might be one that we need to hear the
Okay.
audio.
Do you want to tell me what your objection is or objections are?
Well, from my notes, I believe that Mr. Copeland is claiming that the game was, something involving the game was shot up.
Mm-hmm.
And that Jeffrey supposedly told Shannon to do it. Now, this doesn't go to admissibility. I don't know of anything involving the game being shot up, first of all. So I think this is just a big lie. But that being said, the game had nothing. I mean, this is not listed as an overt act. The game is a gentleman named, I think his name is Jason Taylor. He is not, to my knowledge, we've heard no evidence that he's affiliated with Lil Wayne or anything else. This is just like a completely separate incident that's uncharged in count 1 and uncharged in any other count as well.
So, Your Honor, as I mentioned earlier, during the period of time when there was the conflict between Mr. Williams and Mr. Dwayne Carter, a number of other artists took sides, and we believe that the game took the side of Mr. Carter. And during that portion of time, we actually have entered into a video in which Shannon Stillwell and Quindarius Zachary are in a video threatening the game. That, you know, if he comes here, he gonna have to come see me, and he's threatening him.
Right.
Now, what they're discussing in this portion, my understanding, but we'll play it, is Detective Dennis asks, well, how is the beef with Game and them? And Kenneth says the Game was fixing to get his ass shot up, and Thug, and would have, if Thug would, and Thug would have and told Shannon to do it. Shannon told me out of
probably
his...
says if Thug would have told Shannon to do it, because then it says Thug told him no.
Right, and he says Shannon told me out of his mouth he was up.
Where does it say Shannon told me?
When you hear it, so when you hear where it says indiscernible, so I think the last time we heard this portion, there was a lot of dispute in the courtroom as to what it said, so we need to play it.
All right.
And
I also
we'll believe that's the context that's right.
Okay, but so this is essentially somebody not doing something. Maybe y'all want this in. Well, you wouldn't, but
Right.
Mr. Williams might.
But
so why is it relevant? Because
so it shows that Shannon's ready to do anything on behalf of YSL is
All right.
why we believe it's
all right.
and that's exactly why it's problematic.
Okay, it's problematic. Why is it evidentially inadmissible?
Well, because it's showing what type of, I'm not asserting this, but the state's asserting is showing what type of person Shannon is. Not that he did this or did that. It's just, as far as the charged acts, it's just showing, oh, he's a hothead that's ready for action. And
Okay.
that's what-
Why is that evidentially inadmissible?
Because it's propensity.
To say this is somebody who stands ready to act.
Well, yes. Well, not only stands ready to act, but wanted to act. On it's just like,
All right.
it's bad character, and it's he's not charged with these events, and they're just essentially Mr. Copeland saying he's the type of guy that would do these events. And I just don't think that he's the type of guy argument. I think that just gets to bad character, and I think that's the essence of bad character and propensity. I respect it.
Okay, well, maybe you want to come up with some law that shows me that it's inadmissible, evidentially, character evidence to establish in a gang RICO case or something similar that somebody who's essentially charged with doing tasks for the alleged leader is ready to do such tasks or anything that the alleged leader says.
And Your Honor, also, I'm going to defer to the the tape when we hear it, and I've been notorious for mishearing some things on tapes, but I'm hearing was shot at. And if that's what's being said, I would ask that the state provide us with
Okay.
some reports about something happening to the game at some point. Because I don't know anything about that.
John, can I add
Yeah,
flavor when you get a chance?
I'm listening.
Okay, thank you. I also think it's important for the court to be aware that the state did not call Mr. Carter, Mr. Dwayne Carter. He's on their witness list. They said that they were going to call him. They did not call Mr. Brian Williams. He's on
Okay.
their witness list. They stated at one point they were going to call him because we have a short list. And evidence came out that, and I don't know how familiar the court is, but when people are in the entertainment business, they advertise themselves, promote themselves, drum up interest by doing things that are, I'm promoting an event for young children, or come to my concert, I'm going to kill somebody. It floods the internet, and it's a marketing tool.
Mm-hmm.
So you're being told like it's proven. It's not proven that there was this feud and Mr. Stillwell is going to do this. There's zero evidence. I've interviewed these people that the game, it's a band. It's a musical band.
That's a stretch.
Game is GAME. That they were shot at, that they were bothered, that there was any issue. This is all the theory of the state. It's also, their real theory is that there's this gang war. I'm just repeating a term, between a alleged gang of YSL and alleged gang of IF. These other people have nothing to do with that. I heard you ask earlier, so this was involved in the, there's nothing. This is just what we've been dealing with in this case. It's just everything has come in on a state's theory without the evidence backing it up.
Yeah.
And then the gang experts, quote unquote, come in and they say, well, this is what we said, and we found out. And I asked, well, who'd you find out from? And they say, I don't know. I don't have a file. I can't give you a report. And that's what we've been dealing with. Ms. Hylton said earlier, oh, and Mr. Winfrey pled guilty to this. That's a subject of a motion that I don't think you touched on yet, but I did an attorney proffer. I sent it to you once you were announced as the honorable court taking over. I sent you 8 attachments. And what happened in that is Mr. Winfrey did plead guilty. He was charged in another county, Cobb County, before the Honorable Judge Staley. And he pled guilty. He was charged with a RICO violation, gang act. It was a long indictment. He was indicted alone with the shooting on April 26th of 2015. You've been referred to it today as Lil Wayne bus shooting.
Okay.
What the state did, though, was rather shocking. They had Detective Reese on the stand. Over objection, they played a recording from jail of 2 people who are not testifying in the case, saying that when Mr. Winfrey gets out of jail in Cobb County, there's $250,000, $250,000, and a Porsche waiting for him, a Porsche vehicle waiting for him. The state took that with Detective Reese. It was under the directive of Ms. Hylton, and said, well, that's his reward for not folding and giving testimony against the gang. And then Ms. Hylton asks Detective Reese, and within a month, Mr. Winfrey pled guilty. So I asked to approach the bench. There's a case. It's Winfrey versus State in the Georgia Supreme Court. I could get to the site. That vacated that guilty plea. That guilty plea was found to be coerced by the Honorable Judge Staley, and it's void and cannot be used. I raised that with Judge Glanville to say, well, how did that happen just now? Judge Glanville would not let me ask Detective Reese about the fact that Judge Staley coerced the plea. It was not a plea. The state comes back after that and compensate, and then within the next year, was there just, for whatever reason, another guilty plea entered by Mr. Winfrey? That wasn't true. It was 5 years later And Mr. Winfrey entered an Alfred plea, specifically said, I do not admit guilt. This is on the record.
Yeah.
And he had the Honorable Steve Sadow, which is S-A-D-O-W, representing him. And he specifically said, I'm going to trial, except I've been in jail for 5 years and I have a time served sentence. The point I'm trying to make to you, and thank you for allowing me to speak long time. I didn't expect to go into all this, but it is, you know, you need the lawyers to tell you what went on because you're catching up and accurately. And just to say that this is intrinsic, this is extrinsic evidence. This is not dealing with the gang war. This is dealing with an issue that arguably it's up to the jury. I understand that. Arguably is all advertising or puffing. And to act like this is reality without giving you the other side is just wrong. So that's what I want.
All right, thank you. I understand that a lot of this, portions of this case, the state's theory is, hey, they may be saying this in the context of promoting or of singing even, but they're talking about real life and we can use it as evidence. I know that the defense position is, and I assume you're going to argue to the jury if we get to that, is y'all, this is a music industry kind of, this is how the business works. And that's all it is. And that's not up to me to decide. That's up to the jury to decide whether, you know, which theory they think is the convincing one and whether the state has proven its case beyond a reasonable doubt or not. So I appreciate the background and I understand that. With regard to the guilty plea that at the time, I mean, he did enter a guilty plea. My understanding is, and I read what you had filed, I didn't know that there was anything still pending in terms of anything for me to decide because that's already happened in this case. And even if his later plea was an Alford, we all know that an Alford plea is this, I mean, he may not be admitting guilt, but it can be used. He's saying, I'm pleading guilty because I think it's in my best interest. Man, I've already basically done the time. I might as well plead guilty and have this done and in my past, but it still can be used as evidence against him. So, you know, I may have, I don't know what I would have done with regard to whether I let you probe that issue or not with this witness. But that already happened. So is there anything still pending that I need to rule on with regard to that?
Yes, and this has happened a lot. So Mr. Winfrey, to my belief, is not going to testify either. He's charged in this case.
Okay.
He's in the Fulton County Jail. As I'm going to say has counsel, but now I'm not 100% sure. I believe he has counsel, but I'm not sure. But there's a case. So he's not here. We can't cross-examine him. The tendering of an Alford plea or a guilty plea or a NOLO plea. NOLO plea can't be used. So
Well,
ignore that.
right.
A guilty plea or an Alford plea. The person, Mr. Williams, has the right. That's a confrontation clause. That's a statement made in court for purpose of prosecution. That triggers a confrontation clause.
Mm-hmm.
And that's under Overstreet, O-V-E-R-S-T-R-E-E-T versus State. It's 312 Georgia, 565. Your Honor, it's in footnote 8, 864 Southeast 2D 14, 2021. And in that footnote, it argued a case called State versus Jefferson, like the third president. And what it says is a co-defendant, co-indictee's guilty plea, when they're not testifying, is a confrontation clause violation to be used against, in this case, Mr. Williams.
All right.
So
Let me ask you something. So what he is indicted for in this case, this
RICO.
Right. This, you know, this instant case, that's not what he pled guilty to before Judge Staley and then entered a Galford plea to later, is it?
He did, because it's also an overt act.
All right, he pled guilty to something that's alleged as an overt act as part of RICO.
That's true.
Okay,
He being, I'm not.
he Winfrey.
Yes, that's exactly
Okay.
right. But, you know, when saying, yeah, but he pled guilty and it came in, none of it, in my opinion, this is my argument, should have come in because you need the person, in this case, Mr. Winfrey, so he can be asked, why did you plead guilty? The jurors have no clue. And the state did not put in his guilty plea. So it's all oral over objection. So I want you to understand this. When the state is telling you, and I went backwards, I guess, but you know, the man already took responsibility, pled guilty, we proved all that. They really didn't prove it. They got hearsay evidence, which I objected to, and therefore it's an objection. Judge Glanville disagreed, but it shouldn't have come in. Judge Glanville let it in for a statement against a co-conspirator, a statement against his interests. He's not here. That doesn't apply either. That man's not on trial.
Okay, so I'm asking what's pending before me to decide.
What's for you is going to repeat. The state constantly is putting on guilty pleas of people who are not here, who are not going to testify, and then they use it as a weapon against Mr. Williams. So that's one thing. And then the second thing that you really, why I stood up, I just want you to understand, it is not like this has been proven. You know, the game and that they were shot at, it's just a theory. And I understand you're saying, yes, then they have to prove it and it's up to a jury. I agree with that. But I don't want you to just buy into like, oh, this is so important because it's already in evidence and the state needs to, you know,
Okay.
evidence and prejudicial.
All right, thank you. Okay, so I'm not even sure where we were
I
with
think we were
regard
gonna
to this.
play it. because
Yes.
we're just-
Exactly. Okay,
Your Honor, we're going to start.
Oh, we actually gets a video. That's good.
We're at 12:16:45.
Wake everybody back up.
And this will probably be somewhere around page 222, maybe around line 1.
Well, Kenneth, she not taking no shit. She not taking drugs, not taking no shit from nobody. Well, nobody else care about nobody else. You know what I'm saying? Drugs take shit from nobody.
How did the beef with Game in it?
The game nigga did shot up his dog with told Shan do it. Shan told me his mother was up that way.
Just give me the word.
Yep. And dog told him no. Say some the GD, I can't Nipsey Hussey, something like that. He ended the beef. You know what I'm saying? He stopped. I mean, I ain't here to play. You know what I mean? I just don't want to go to jail. I mean,
And we're going to stop it at 12:17.
all right, if y'all want me to figure out what got said, then I'm gonna have to have that tape. I'm gonna have to slow it down. I have no idea what he said. I mean, I know a lot of it, but the little part that y'all don't know either, I'd have to listen to it a couple of times. So, I don't know.
Come on. Y'all heard what she said.
You want to play that?
Yeah.
No, don't. She still ain't
Yeah.
understand it.
Not the whole thing, just that part that is kind of hard to, like line 19, the game fixing to
That's
get the
funny,
ass shot
man.
up, as I think. But after that is what the,
That's wild. She said she don't know none of that vernacular, and then the
Before you
audio.
play, is
the
the
audio
sound
is
coming out of
terrible.
that little white speaker? Is there any way I could get any kind of a speaker closer to me?
Somebody said, "Thank you, me too."
I mean, is that where that's coming from?
I can't Nipsey Hussey, something like that. He ended the beef.
It may not move far. In which case,
Oh, this is funny.
I think that's about as far.
it's not gonna do much. So
This is-
just put it back where it was. Thanks, though.
I don't know if we can play it slower in evidence review, but I can
Well,
play it multiple times as evidence reviewer.
That ain't gonna help.
Who trying to do that? Well, she not taking no shit. She not taking no shit from nobody. Well, nobody else care about nobody else. You know what I'm saying? Don't take shit from nobody.
Well, how does the beef with Game again?
The game league is shut up and do it with Shan do it. Shan told me
All right.
probably resort that win.
What I hear them saying is the gang fixing to get his ass shot up. If Thug had told Shannon to do it.
Oh my
Okay.
God. Not the judge.
Just give me the word.
Yep. And do it to him. No, say turn on and do it. The game league is shut up and do it with Shan do it. Shan told me probably resort that win.
Just give me the word.
Yep.
Shannon, nobody's something
The
like that.
game league is shut up and do it with.
If Thug would have told Shannon to do it.
Well, how does the beef with Game again?
The game league is shut up and do it with Shan do it. Shan told me probably resort that win.
Just give me the word.
Yep.
I hear
A theory?
They told me out of his mouth.
Okay, well, I assume that matters. So
Doesn't matter.
I will listen to that in my chambers where I can actually hear it a little better. So we'll have to revisit that as well, but go ahead.
I'm not trying to beat a dead horse here. I think that when it comes down to it, my objection is that, first of all, anything involving the gang is not charged, is not in the indictment at all. So it is extrinsic in my estimation. I don't know how this fits into the story or is needed to complete the story. In addition, it is bad character evidence about my client. It's a prior, if it's extrinsic, it's a prior bad act as alleged. And also, I'm not hearing the told me out my own mouth. So there's speculation involved as well, or, I don't know what the source of his knowledge is, but he's not saying that he was with Shannon waiting on the game. So there's that issue as well.
Okay, so with regard to that issue, they probably are not doing police questioning, thinking I need to establish exactly who everybody. It may be that through this, we don't know. And if it comes in, you may just have to ask and maybe establish, or maybe beforehand, what was the source of your knowledge when we have Mr. Copeland and not the jury, and we can find out, is it total rank hearsay or is it not? I don't know.
As long as we're allowed to do it outside the presence
Yeah.
of the jury.
Okay, and then with it being a prior bad act, there is no act here, so it can't be a prior bad act.
Well, the act is
Being willing to do what
Well,
Bug says.
Mr. Stillwell is, according to Mr. Copeland, is waiting, I don't know where, waiting somewhere to shoot another individual. That's an act.
I'm not sure it's a crime to be willing to do it if you don't do it,
No,
unless.
I'm saying waiting, not, I heard waiting, like he was in, I don't know, I'm just making this up. I'm speculating, but an alleyway or something. I hear he was waiting.
Okay, I don't think that's what it said, but I'll re-listen to it. Okay, let's move on to the next one.
The next one. We agree with, based on, of course, prior ruling, cover back, page 231, line 5 through 233, line 22.
I think it should start at 230, line 20.
Yeah, 230, line 24.
Well, 230, line 20 says, this is Mr. Copeland speaking, that car that they're saying shot the tour bus. That seems pretty clear to be hearsay.
That's fine, right? Page 230, line 20.
And where did you say it ended?
To 38, line 20. Really, 239, line 2.
Somebody say, "Love, mighty quiet."
All right,
We're in agreement with that.
all right.
Anyway, she gonna get through all that.
Next, I have that we agree upon page 243, line 9, and page 256, line 7.
I have 241, line 3. Where we get there, to 242, line 21.
That would be.
It's talk about one of Pee Wee Longway's people shooting up a club named La Cura, which is on Metropolitan, and Kenneth Copeland was initially blamed for it, but it's just talk about that shooting, and then there's talk about Tick, which was Trontavious Stevens, robbing Bentley, who's known as OG Bentley, who is Kelvin Treadwell. It's just a bunch of, I presume, rumors, because I don't think Mr. Copeland was there, about completely unrelated things that he's heard.
Okay, so 241, line 1 through 242, line 14.
I have 242 line. Yeah, that's fine.
All right, so y'all agree that's out? Yes, no?
Oh,
Okay.
yes, I'm sorry. And then, the next one I have is 243 line, I'm going to say 1 because I don't have a line. 243 all the way to 248, line 11.
All right, so I'm glad we're doing this. What I want y'all to do is get together beforehand, and everything that is agreed to, y'all agree that it's agreed to, so that we spend the court time talking about the stuff that's not agreed to, okay?
Yes, Sean.
And I know y'all are doing the best you can, but try to do better.
So the next one that's not agreed to, that I can move on to, that I think is page 321, line 21 through 23.
All right, let me get there.
So.
Okay.
Slick, you funny. You funny.
Is the objection speculation?
Yes.
So,
Like personal knowledge.
so here, Your Honor, he's repeating, this is a parte co-conspirator. This is the night of the shooting.
Mm-hmm.
Murder Donovan Thomas.
Okay.
And he's repeating what Demekion told him regarding what happened with the murder. And specifically that line where he says, I guess that's where Thug went.
Mm-hmm.
When you listen to Kenneth Copeland, it's not speculation because this is what
This is just the way he talks.
Because even when you look at line 24, he says, and when Thug was at Bentley's spot, which was more of an affirmative, this happened based upon what Demekion told him. So this is all in relation to what we argued the other day regarding co-conspirator.
Where is the state getting that he got this particular information from Mr. Garlington?
Because throughout here, he talks about, this is what Demekion told him when he got into the car with him and explained the murder to him once they got to the car.
I thought when they got in the car, all they had time to say was they shot nut. And then like some other little tiny bit after somebody else got out of the car again.
And then that's when they drove up to
Sky House or wherever.
And Nard got out the car. And it's our understanding that's when more detail came in. That
Okay, and maybe you're understanding, where is the evidence that all of that got said in the car? You might need some time to come up with that.
I'll look again, but what we do know is that he says in this interview that Demekion told him everything that happened that night. Now,
All right,
happened
well,
in the car or not,
I mean, if you show me the part where he says, D told me, what's his name? What's his Lil D from Mechanicsville, told me everything that went down that night, then we're in a different situation.
So, visiting.
20. All right, so I see if we go up a page on 320, around line 9 through 13, or really 17, 18, that he's at least saying, D told me this is all the people that were involved, and he personally knew it because he was with them.
if we go to page 318, Your Honor.
Okay.
Line 10.
Right.
And he says, this is what Little D broke the story down. He said, and then he goes into what Demekion said, which is all the way to the Sky House, and said they rolled past and met outside. They went somewhere to change cars, and that was it.
Mm-hmm.
I dropped Shannon B off at Thug's house, and he could continues to elaborate.
Right, so that's all what happened beforehand.
Right.
And I think,
That's why I didn't object. No, I'm-
Right.
I'm objecting
So,
to the co-conspiracy.
I understand, so, I understand. So where's the part where we have any kind of foundation that, and I mean, maybe it's just in context, it's clear he told him the whole thing from start to finish. Maybe, but y'all show me where that is. I mean, I guess Lil D broke the story down, maybe.
So our understanding from this interview is that the breaking down happened in the car.
What doesn't matter where it happened, as long as it did happen, as long as you have some evidence that shows he told him all of it.
This, yes, from
Okay.
everything he says to, the detective in this interview, everything about that murder that night is what.
This is, okay, this is him saying, here's what he told me. Okay. All right, I'll take a look at it more in context over the lunch break. But that seems to be a pretty good basis for arguing that.
And he says it early, so this is the second time he's telling the story, so for the purpose of this interview, Your Honor.
Okay.
He tells the story initially early on in the morning to Detective Gaither, Detective Dennis.
Yep.
And Detective. And then later they bring in Detective Thorpe, who was the homicide, the lead detective on the Thomas case. He reiterates the story again with a little bit more detail in front of Detective
Okay.
Thorpe. So he's telling them all.
All right, and he's already said, I got it all from Lil D. Okay, all right, I mean, I think that is satisfactory, as, yeah, he had a source for this.
The next.
I have 341 to 341, I think 19 to 350, 17.
Is that the whole BB?
Correct.
Yeah, that's not an issue.
Okay.
So that is out by agreement? Okay,
And then 356, 9 to 19 was the same issue, I think.
Yes, I think it's. I have the full redactions, 341 line 19 through 350 line 13.
What about 356?
Yes, 9 through 20.
Yes. And Ms. Hylton, the next one I have is 361, line 1 to 362, 10. I don't know if we had agreed to that.
What I have as the final is that we were going to take out 361, part of line 16, so line 17, where it says Shannon shot up that tour bus.
Say the lines one more time.
Half of line 16 and a portion of line 17, the sentence reads Shannon shot up that tour bus.
Yeah, they really just wasting a lot of time.
all right, so that's out by agreement. There may be another part we need to take up, right?
Right, well, part of that, Detective Thorpe says lines 7 to 10, which was included in my objection.
I'm sorry.
I guess the state doesn't do it that. Thor, but you said a key piece of stuff we've been asking you. You said without a hesitation, without a doubt, Shannon the one who shot the gun. And then Kenneth says, y'all keep thinking I'm doing stuff. And I'm not 100% certain on the context as I sit here now, but it's right after discussing the Lil Wayne.
Well, what I believe is happening in this portion, Your Honor, if you go back to 361, Kenneth is elaborating that he's not the problem, it's Shannon. And so he goes on and he's saying Shannon is doing everything. Specifically, he says Shannon killed Nut. Shannon shot that tour bus. Based upon prior ruling, we know that should come out. Then he continues to go on. And he's saying, I ain't retaliate one time, now I'm on 362. And then Detective Thorpe, I guess, is trying to clarify, I said, because you just said a key piece of stuff we've asking you, you said without a hesitation, without a doubt, Shannon the one who shot the gun. Because, and this will be speculation on my part, but I think because he's the investigator of the Donovan Thomas murder, that is what he is focused on. And then Kenneth Copeland doesn't even respond. He just says, y'all keep thinking I'm doing shit. I'm not doing nothing. I'm telling you, I'm fixing to go back to jail. I'm not trying to hurt anybody. So he doesn't even respond to Detective Thorpe.
So maybe we could just take that part out then?
It's right.
The Detective Thorpe part?
Well, without a hesitation.
Yeah, okay. So why don't we just take out 7 through 11? So 362, 7 through 11. Or 10 or whatever. 10, I guess. Okay.
Yes.
All right, next one that we have dispute about.
The next one we have this.
Yes, because y'all can spend your lunch break talking about the ones you agree on. And then you can come back and put it all on the record. I guess if you don't know, then we have to talk about it now.
Look at 365 lines 6 through 8.
$365. Yes, that's in this. That's in dispute.
Okay, so, John, on 365, 6 through 8, the context of this is Quindarius Zachary, also known as the other Lil Woody, from Cleveland. He allegedly would buy, he's not a convicted felon, he'd allegedly buy guns. At some point, he bought a gun for Kenneth Copeland. Kenneth Copeland, allegedly, Kenneth Copeland ends up getting arrested. Then he wants to get the gun back, but then wants to get rid of the gun. And it's a gun that's later, my understanding is later, Kenneth is arrested for because he's carrying it to the Dunbar Rec Center and leaves it in the bleachers. Kenneth is saying that Jeffrey told Quindarius to buy the gun back from Kenneth. However, Kenneth was incarcerated throughout that period, is my understanding. So I don't believe he's speaking on firsthand knowledge. He's just speculating or passing on hearsay that Jeffrey instructed Quindarius to buy the gun back from Kenneth. I don't believe he has any firsthand knowledge.
So I have a different analysis. I believe that they are talking about initially buying the gun from the pawn shop. So if we go, but they're talking about the fact that Quindarius buys the guns, specifically most of the guns from Arrowhead Pawn Shop. And for the reason that Mr. Shard stated, the state believes because he was not a convicted felon, he would purchase a number of the guns on behalf of YSL members. And what the detectives are saying to Copeland is, you told him to buy the gun.
Right.
And he said, no, Thug told him to buy the gun initially. And then later on, there is some conversation about Mr. Copeland was arrested and he was going to try to sell the gun, which when he got out, and that's how he ended up.
Yeah, this looks like the buying it to begin with, not the buying it back afterwards.
Well, either way, Your Honor, it's, I don't see any indication that it's anything but hearsay. And here's the other thing. Quindarius Zachary's apparently going to be called. So Quindarius Zachary would certainly have firsthand knowledge of who told him to buy a gun. And right now we have Kenneth Copeland on an out-of-court statement, possibly speculating or passing on hearsay. And it seems to me that we would have a live person on the stand that could answer that question pretty clearly.
My position is, one, if this statement comes in, it'll be contingent upon us asking some foundational questions on the stand first. And then depending on what his response is, this would probably be a prior inconsistent statement, depending on what his answer is. I don't know what it will be, but we can lay more foundation as to when, how did this come about? How does he know Doug told him to buy the gun or not?
All right.
I would just ask that the foundation is laid
Outside the presence of the jury. Yeah, absolutely. Outside jury. I just wrote that down. Okay, so we'll need some foundational questions on that. Assuming you can lay the right foundation that he actually knows it, then he ought to be able to say it, but we don't know that yet. All right. Hang on just a second. Miss Winfrey.
Shout out to Miss Winfrey, the court reporter. Y'all want Weaver or Winfrey? Y'all want the old court reporter or the new one? We don't really kind of know Miss Winfrey yet. We know Weaver gonna show up to court ready with them chucks on.
Portion.
Now you know Law Malcolm, he gonna have his same talking points.
There was a portion of so page 375, line 17 to page 376, line 9. The state only had an objection to page 375, line 17 through 19. Defense counsel wanted that line out. That Mr. Copeland says Doug is connected to a lot of people. We wanted that portion in.
Law Malcolm gonna come in, he gonna say they guilty.
With that. And then 375.
All right, so hang on. So all of 375, 17 through 376, 9, there's no objection to. Is that right?
Then he gonna say Miss Love cleaning up the streets of Georgia.
Is that right? Okay. Wait, coming out or staying in? Y'all seem to be saying,
We're agreeing that it comes out.
Wait, hold on. 375 lines 1 through, you said 1 through 9, Your Honor?
no, I'm saying what you said.
Oh, I'm sorry. Yeah. I thought I
You
heard
said
that.
375, line 17 through 376, line 9. Are you agreeing that all of that is in or all of that is out?
Everything from 375.20 to 37, everything from 375.20 to 376.9 is out.
Out, okay.
Nice.
All right,
The whole case needs to be out.
all right, what's next?
I would go to lunch.
I have 378, 1 through 8.
You said 378, 1 through 8? Yes, that is.
Agreed, out.
No, that's in this.
Oh, okay. All right, tell me why that's in. Oh, I see, that's not the detective saying 7 through 14, that's Mr. Copeland.
Yes.
So then, Mr. Sharp, tell me why that's out.
Well, two reasons. First of all, it's speculation about what other people will say. And also it's to comment on individuals' right to remain silent. I mean, they're asking, if we call people in here, who's gonna tell, who's gonna give it up, and then he just speculates. And I don't think that's relevant. I don't think that's appropriate. So I don't know why it would be a big.
What's the state say?
Your Honor, so this is a portion, if you look at right before, on page 377, the detectives are asking Copeland, specifically talking about the murder, who do you think we can call in, who will speak to us about the murder? And what Kenneth Copeland's response, beginning on page 378, line 1, put it this way, Thug and them already knew those 4 right there, they're not going to tell. He's talking about Yak, Nard, Shannon, and one other, and it's slipping my mind, who's the 4th person. And he says, I don't know about doo-wop, but them niggas not gonna tell. That's why they not saying it. You feel what I'm saying? I understand why everybody doing this stuff, but I at least want to make a way to be like, well, Woody told us, you feel what I'm saying? This is a YSL member who knows the individuals in which he is around. He knows who will come and talk to the police and who will not. And so who will protect the enterprise. And that's what we believe he is telling them. Like, these people are not going to talk about our activities. So there's no use in you trying to speak with them because they're just not going to talk. And Thug knows that they're not going to talk as well. As it relates to commenting on pre-arrest silence, Your Honor, I'm looking at an 11th Circuit case, United States v. Reeves, REEVES 742, Fed 3rd 487, which is a 2014 case. And
Sorry, just tell me that whole site again.
Sorry, and if I went too fast, I apologize. United States v. Reeves 742, Fed 3rd 487.
Okay.
And the key holding that we have is the government may comment, and it's really on a defendant's silence if it occurred before the defendant was in custody and given Miranda warnings. In this case, at this time, none of the defendants were in custody at all. They were still investigating the homicide. At this point, no arrest warrants were even taken out. During this interview in June of 2015, warrants were not taken out until October of 2015 for the murder of Donovan Thomas. So this would not be commenting on any pre-arrest silence, Your Honor.
Okay. So aside from the pre-arrest silence objection, what other objections do you have?
Well, it's speculation, and it's also, I guess, relevance. Like, why is Kenneth Copeland giving why would the jury hear an out-of-court statement by Kenneth Copeland about whether my client will give a statement to the police or not?
All right, so y'all had pointed me as the objectionable portion to 379 lines 1 through 12.
No, 378. I'm sorry.
Okay. That makes a lot more sense. Okay. All right, I don't find it to be any kind of a pre-arrest silence kind of potential violation. And this is his opinion as to how strong they're going to be with backing up and keeping silent about what the gang is or is not doing. I think that that's permissible for him to say. I don't think, it's only speculation to the extent that anybody's opinion about anybody else is speculation, but it's valid to come in. So I'm going to permit that in. What's next?
The next portion that I have as in conflict was page 386, line 20 through page 387, line 12. And
Is that in dispute?
yes, yes, Your Honor.
Okay.
I don't I don't have the dispute quite as broad. I just have the dispute over 387 lines 6 through 13. And it's just simply hearsay.
So, Your Honor, the state would say that this is not hearsay. We're not offering lines, page 387, lines 6 through 12 for the truth of the matter asserted. When you go back to page 386, Mr. Copeland, I think it's around here, he starts to explain that he never had an issue with Donovan Thomas, like that they've had conversations with each other. And some of the subject of that conversation was Mr. Copeland's relationship with Mr. Thomas's brother, Kelvin Watts. So when you get to page 387, lines 6 through 12, he's telling them about a conversation that he had with Mr. Thomas prior to his death. Now, whether or not Mr. Thomas said, I'm going to go holler at them, or whether or not Mr. Thomas did go holler at Kelvin is not what we're offering it for. It's solely being offered for the fact that they engaged in conversation that was amicable prior to his death. And so we're not offering it for the truth of the matter asserted.
All right, so it's on 386 where he's talking about actually having the conversation with Mr. Thomas, right?
Yes.
Okay, and that's fine. That's not objectionable to the defense. So the part that they're objecting to is the part where, I guess, who is it that's walking up and saying this? Shannon, right?
No, so when we go to 6 through 8,
Yeah.
he's saying that Shannon was right there in the presence when the
Right.
conversation was happening. With,
And it's Shannon who says, if I'm understanding it right, man, what's up with you and Kel, right?
no, it's Donovan Thomas.
Oh, and he was like,
And he's referring to is Donovan Thomas. So
And I agree with her.
okay, all right. Okay, and so you're not offering it for the truth, you're offering it for the fact that Kenneth Copeland and Donovan Thomas are cool with each other.
yes.
All right.
Well, I mean, that already comes out in 386 that they had a conversation. My objection is when Kenneth says what Donovan Thomas said, allegedly said, which is, man, I'm gonna holler at N-word and I'll let you know what's up.
Mm-hmm.
Because it's giving the impression that, and it is coming in for the truth of the matter asserted, that Mr. Thomas was playing the role of peacemaker.
All right.
And
So I'm sorry, I don't mean to interrupt, just for purpose of keeping the record clean. So now what we're really talking about is just lines 10 through 12 of 387, right? Okay. So in that, they're saying, hey, man, you got to be offering that for the truth.
I mean, they make their point without, the point that they're claiming to be trying to make is made without that last part.
But sure, I think that gives context when you continue to go further down that page. And when he says, that's what Nut said. And then Kenneth says, yeah. So when me and Kel seen each other, I believe he says, when me and Kel seen each other at the skating rink, Kel was like, well, he wanted to see what Thug got to say. So I called Kel on FaceTime.
Okay.
But give us some more history. In the week leading up to Donovan Thomas's murder, there are a couple of events that
Yeah,
occurred.
I actually am already familiar
Yes,
with the
so-
skating rink event.
So it appears that on that Sunday, Kenneth believes, based upon his interactions with Donovan, that him and Kel are cool. And matter of fact, they actually do talk and have a conversation. And then the next day is when Kenneth Copeland gets beat up at the skating rink. So all this is in context of what is happening or developing those days leading up to Donovan Thomas's death. So I think it puts the second part of this page in context.
Oh.
But the only way it provides context
Is if it's being offered for the truth, right? I was about to say, so now you're conceding it is being offered for the truth.
Not whether or not he hollered at him, but the fact that they just had this conversation, whether or not, because we don't know if he hollered at him or not. We just know that something may have occurred, then they saw each other the next day. Donovan might not have ever talked to his brother that day before. We don't know. We're not saying. He definitely went and spoke to Mr. Kelvin Watts once he left that meeting. We don't know. We're not offering to say he did talk to him. We don't know. What we know is the results, whatever that conversation was, there was an amicable meeting between Kelvin and Mr. Thomas that Sunday
Even to the
before.
extent of the discussions about his own brother, it was amicable.
Correct,
And
whatever.
it-
Whatever.
Okay. But not for the truth of whether he's actually going to holler at him. Right. All right. Well, that seems like it's then not offered for the truth. So, all right, that can come in. All right, let's take a lunch break. I know the lunch is here for the defendants, so let's be back. Will it be enough time, you think, to get everybody fed to come back at 12:20? Not 12:20. No, that will not be enough time. 1:20. 1:20, will that be enough time? I'm asking the deputies. Yep. 1:20. Yes.
She talking about 12:20. That sure won't be enough time. All right, let me see. She talking about 12:20. That sure won't be enough time. Getting the echo from the other stream. All right, y'all. So what y'all want to do? Y'all want to go eat lunch and come back? Oh, hold on, let me clear this link. Let me drop this just in case somebody has something they want to comment. If y'all got a camera and a mic and y'all want to stop in, let me know. So I did not think she's a better judge than Glanville. He say both or all of them in that room are trying to capitalize off this case. Even the judge, this is why she's been stubborn to declare mistrial. Yeah, I've been seeing a lot of different comments. Some people saying money. He said, no, we won't mail with her in. Let's see. I want my tax money back. Somebody else said it was about race. I mean, I've seen a lot of different things of what they think this is about. I don't know. I mean, I don't really know like the race angle, since most of the people in there. She said she might have to hit up Nathan Wade to get that money back. Nathan and Fonnie ran off with their little change. They got their little million. Ron Bourne said the state has no idea where they are going for now. They're just throwing things just to see what will stick. What did she say? She said, why do they bring up I'm not sure what particular part that was brought up and what the context was. This trial is losing a lot of people's attention, right? We trying to hold on so bad, like, okay, when is the big moment? I did see something on here from Thugger's Dailies. This was a motion filed by Young Thug's attorney Brian Steele. And he basically wants the jury to know why Glanville has been kicked off the case. They said, don't lie. Tell him why we have a new judge. Tell the jury why, when they come in, hopefully next week, why they have a woman sitting up there that have long hair and they had a man up there that had no hair. What is the difference? So this is the jury instruction. Shout out to Thugger Daily. And it's just like a screenshot. I think he said it was just this one page. Or let me say they said it was one page. Comes now Mr. Jeffrey Williams, Young Thug, biting through his counsel, Brian Steele, Keith Adams. And they're going to show the court as follows. Young Thug is innocent of all charges. So let's not get lost in that. Number two, in light of the recusal of Judge Glanville, Young Thug respectfully requests that this honorable court provide the following instruction to the jury when they come back. This is what he wants to tell them. This is what he want to say. Oh, thank you so much, Till. Talk that law. Thanks for your coverage. Go have some lunch. Thank you so much. That was kind of you for that contribution to the cause. Yeah, we have like an hour and 10 minutes, so I might take a break in a second. Let's go through this right quick, though. This is what they want the jury to hear. Ladies and gentlemen, Judge Ural Glanville is no longer the judge presiding over this case for which you have been selected and sworn to try. Judge Glanville was removed as the presiding judge in this case. You are not to concern yourself with this change. Okay, that sounds pretty reasonable. In a trial, none of the decisions of the court and nothing that any judge says is evidence. The decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in this case. You are to disregard any comments made by Judge Glanville that were disparaging of the defense lawyers in this case. To maintain the integrity of the jury system, I remind you that you must decide this case based only on the evidence admitted during the trial and the law I will explain to you. So this is what Brian Steele wants read to the jury when it gets back. There may be some issue with that one line. You are to disregard any comments because they're going to think that the comments when he was talking bad about the defense attorneys are the reason he's gone. So, I mean, they're not slick. I mean, they worded it like that intentionally. Brian Steele, and I'm assuming that's why DA Love said in the beginning that she didn't want to, let's go back to that part. She didn't want to have the jury hear that part. She wasn't with that at all. Let me see if I can go to that part.
That's it. That's the okay. Thank you. All right. So obviously, I think the first thing I need to say is my name's Judge Whitaker, which I'll do, which really has nothing to do with this particular charge. But so I think the first sentence, Judge Glanville is no longer the judge.
All right, hold on. So it looks like Law and Crime started their stream late because that was not the first thing I heard this morning. So let me go back to let's see, Fox. All right, hold on, y'all. Let me go back to the other one because
of lawyers. That's not evidence. It's nothing. There's nothing wrong. If you want to think of some different language, I'll consider it, but that's what I'm thinking right now. I mean, he did make comments disparaging of lawyers. That's not evidence. It's nothing. There's nothing wrong with me saying disregard that. So that's where I am right now. If you want to propose something else, then propose it.
Orally or in writing, is the court mind oral?
Sure. Go ahead.
You are to disregard any commentary, any comments that you deem commentary on counsel for either side.
So instead of disparaging,
Yes, that's assuming that there were disparaging.
well, that's why I'm saying that may have been. So that may have been commentary? Well, I mean, right. He shouldn't, it's irrelevant whether he said, you are doing a fantastic job today either. So, all right, maybe craft it a little bit more. And I understand what you're saying. So if you want to come up with a word that kind of encapsulates disparaging or complimentary, let me know. Anything from the defense, or y'all just want to wait and see what she comes up with and then talk about that?
I don't have an objection to the part that you said about what you said.
All right.
I do not see the need to add also complimentary.
No, I don't think we should either. I wasn't suggesting that. I'm saying if we don't say disparaging, then let's come up with a word that would encapsulate any kind of commentary whatsoever, whether it's flattering or non-flattering.
It should be disparaging.
Maybe it might stay like that, but
And I think that I heard what you said, but I would continue to ask if you think it's appropriate to reconsider about the Judge Glanville has been removed.
okay.
Other than that.
All right. Okay, so we'll leave that for now. And if you, Ms. Love, want to propose another word or phrase, let me know. Otherwise, it'll read as I read it.
Yes, Your Honor.
All right, thank you. Okay.
Excuse me.
Yes.
May I bring up a brief issue? Before,
Absolutely.
You continue. You
Uh-huh.
mentioned this morning about that the court had several rulings that you put out yesterday.
Yeah.
I have not received any of those rulings on honesty. I haven't received any of the submissions from Ms. Steele that came through honesty.
Okay. So yeah, so we got the gist of it. We got the gist. Now, see, in the beginning, it seemed like the judge did say it was some disparaging remarks, but then she tried to say that's why she said it might have. Let me go back real quick.
If you want to think of some different language, I'll consider it, but that's what I'm thinking right now. I mean, he did make comments disparaging of lawyers.
Okay, so she said it. She said, Judge Glanville, she said he did make comments disparaging of lawyers. But then after that, when Love kind of like pressed back, then the judge switched it up and she said he may have.
That's not evidence. It's nothing. There's nothing.
Just moving forward.
So that may have been commentary. You're doing a fantastic job. I understand what you're saying. Just anything. You are doing a fantastic job. So that may have been commentary. Well, I mean, right. He shouldn't, it's irrelevant whether he said, you are doing a fantastic job today either. So, all right, maybe craft it a little bit more. Well, that's why I'm saying that may have been.
Oh, they may have been disparaging.
Well, that's why I'm saying there may have been.
So she walking it back, but she kind of already said that Judge Glanville did make some disparaging remarks. We all know it. I mean, he talked about the defense like a dog. He talked about him like a dog. He said, you unprofessional, you unprepared. What you doing in my courtroom? That's what he said. Judge Glanville, if you in the chat, show yourself. Show yourself, Glanville. I know you popped in the other day. come back and talk to us so we can get it on the record. If y'all don't mind hitting that like button, appreciate it. And if you want to come back, subscribe. While Glanville outside walking his dog. He walking his dog with his phone in his hand, watching us over here. Let's see what else. Is there any other motions that that was posted? I think we had the motion where let me see if I can find it. Judge denied. So I can open it in a new link or a new tab. And this is just a denial. And this was August 1st. What's today? August 2nd? So yeah, this is brand new. She filed this at 5 o'clock on the 1st. And on August 1st, 2024, defendant Williams Young Thug petitioned the court for a certificate of immediate review of this court's order. Having considered the request, the court denies defendant's petition for a certificate of immediate review. Signed Judge Paige, Reese, Whitaker. So y'all see it. She said, I'm not going to give you permission to go talk to the appeals court. You can't go talk to my supervisors because I can't get kicked out the case. They can shut down the case. So you can still talk to them, but you're going to have to talk to them when the trial's over, which can be 2 months, 3 months, 4 months, a year. And that was my example I was giving earlier. Imagine trying to talk to someone's supervisor and they say, I'll come back in 30 days. In 30 days, Slick say, great news, guys. I'm no longer on child support. Slick, who had you on child support? And how did you get off? Did the child turn of age? Or did y'all come to an agreement? What the? Y'all. We're gonna rebuke that, Regina. Say must be nice. Regina say simply show yourself. Y'all funny. Let me see if there's any other motions. Hey, since we got a little time to kill, did y'all see the interview that I believe it was the National Association of Black Journalists, and they interviewed Trump? Oh man, that was wild. Like you could tell they wasn't checking for each other at all. She tried to tell Trump, "Can you just answer the question that I'm asking you?" And Trump was like, first of all, you was 35 minutes late, and now you're trying to rush me." Oh, that was funny. She said, "I sure did. It was hilarious." Regina, you was trying to come up? That was wild. See, I didn't hear he was an hour late because that would have been a good rebuttal had that been the case. Because when Trump told her, y'all were 35 minutes late because y'all couldn't get y'all equipment working, I didn't see any pushback. She didn't respond and say, "No, but you were an hour late." And then he said, "In fact, y'all equipment still not working." He said, the only person I can hear is the one I don't want to hear. That's what he said. Some of y'all watched it. I had went virtually. I say virtually, since we didn't have court yesterday. We had the funeral service for Congresswoman Sheila Jackson Lee, straight out of Houston. So I'm glad we didn't have a court today. That was a good service that they had. I remember when I first became barred and got my license, or even before I got my license, graduation, somewhere after that time period. Said it's very honorable of you. This is a noble profession. We got to talk briefly. That was good. Yeah, and Harris came and spoke at the service, and they sung "God Bless America" with a gospel twist. I ain't never heard it like that before. Y'all have time to go listen to that? Whoever that boy was singing. I don't know if that, everybody got their own opinions about her, but I know, from the Houston area, you can see what they do more than people, maybe perhaps from Washington or outside areas. But she was always on the scene, though. I don't care if it was a toy drive, a food drive, you had a problem. Yeah, it was, yeah. So rest up to her for sure. Oh, you got a chance to listen to it? Yeah. What's going on, Amy? Amy Slates. I still respect elders and political officials, politicians, even if I don't agree with their policy. Yeah. Everybody policies are, they all got their own way. I hope you get well, Amy. Thank you for still pushing through and just popping in just to say hi. Oh, thank you. That's so kind of you. Amy. Amy Slate's in the building. Somebody said, hope you get better soon. Yeah, hope you get better soon, Amy. All the way from the great state of Michigan. She said, oh, if it's hot in Michigan, just imagine in the South. Oh, okay, there you go. She said it feels like Texas heat. Yeah, this Texas heat will wear you out. And while we wait, I did want to take the time to thank Tiff again. She said, have some lunch. And also, I want to thank Ken Goddess again for the $100 cash out early when we first started streaming. So thank you so much for that. That was really kind of you. Y'all didn't have to do that. And for the ones that support behind the scenes by hitting the like button. I'm gonna let that scroll for a minute. Thank you, Politicking with Mel. So for the people popping in, we're on a lunch break right now. If y'all had anything y'all wanted to say, let me know. I'll drop the link one final time. If not, we can all come back in about 50 minutes after the lunch break. If y'all got a camera in the mic, let me know. If not, let me get that banner ready. Yeah, so hopefully they start on time. But what I can go do is get a little work done, check some emails and stuff, so I don't lose the whole day. I mean, because today's been a slow day in court. It's been slow. Okay. Do you know when that's going to happen? Law Malcolm say would not be a mistrial. He say Love worked too hard to clean up the street of Georgia. Slick, you ain't coming to no Houston. You know you love that Atlanta too much to leave. Slick wanna be in Fulton County. Who is the scam Nesto? No way. Y'all put it in the chat. Y'all trying to cover the Nesto? Yes or no? I don't even know who. And what is he accused of? Let me Google this. Nesto. Let me see. Is that Florida? And what is he? What he accused of? Let's say, go get some to eat. I'll eat it. Yeah, if y'all can give me some information about that. I don't even know what he's accused of. Oh, it's Atlanta case. Oh, it's at Atlanta RICO, so it's Fonnie Willis. It's a Fonnie case. Florida has too many. They probably everywhere. Who knows? Oh, he was stealing, allegedly. All right, I'm gonna take Miss Deborah C. Advice. Oh, I didn't know he had all of that. Politicking with Mel. All right, y'all. So let's just pop back in around 1:20 Eastern time. And I'm gonna put a banner. All right. All right, and I'm gonna put the court link back up. Refresh the link. Just call it the Who Not to Marry. See, I'm gonna have to go and see. Slick. Now we already talked about this. I haven't gave out any of those yet. That might be a while. I haven't even looked into none of that Slick. What's going on? Thank you for popping in and showing some support in the chat. He said Mel is another blocker for real. Mel be blocking people. See, a lot of people not as lenient as me. So that's why, but I still could control it for the most part. It ain't like it's out of control. I don't have like thousands of comments where it's just crazy. We can say, bro, don't get caught up in these YouTube streets. What's going on, Mr. Christopher Robertson? Thank you for the kind words. But I'm gonna go and come back in about, I don't know, 40 minutes. Who said I'm a blocker? See what I mean? Slick. Somebody said it up there at the top. Hold on, let me go to this right quick because I don't be. Hold on, let me do it like this. Let me do it like this. Said we said bye. Go eat. Are you covering this trial? This- All right, let me go. But thanks again for popping in. Definitely appreciate your support and the kind words. All right. All right. For those who are popping back in or just now joining, we're coming back from the lunch break. The lunch break. And if you are just now joining, guess what you missed? Absolutely nothing. Absolutely nothing. Just the lawyers going back and forth, talking about stuff they should have already had figured out. Kimberly says she don't know what she gonna do when she go back to work next Wednesday. All right, it looks like the judge getting ready to come back out. We're a few seconds behind this other stream, but she should be walking out. All right, let me take the other feed volume down.
All right. So over the lunch break, I did not get a chance to do any of the things that I told y'all I was going to do. However, one thing I did do was work on the further revision of the jury instruction. I saw that the state had sent over a couple of different proposals, and I thought a part of those were good. And I'm just going to tell y'all, I'm just going to read out what I've come up with, which is a little bit from here and a little bit from there. Ladies and gentlemen, my name is Judge Whitaker. Judge Glanville is no longer the judge presiding over this case for which you have been selected and sworn to try. I will be the presiding judge in this case moving forward. You are not to concern yourself with this change. And I propose to say, and to calm any concerns, Judge Glanville is fine. Because if I don't say something like that, they're going to be like, oh my God, did he have a heart attack? Or, so that way nobody's searching on the internet. Okay, then let me remind you, as I assume presiding duties in this case, that none of my decisions and nothing I say during the trial is evidence, just like none of Judge Glanville's decisions and nothing Judge Glanville said during the trial is evidence. The decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in the case. I am only interested in seeing that this case is tried fairly based on the laws and the Constitution of the state of Georgia and the Constitution of the United States. You are to disregard any comments that may have been made by Judge Glanville about any of the lawyers in this case. To maintain the dignity of the jury system, I remind you that you must decide this case based only on the evidence admitted during the trial and the laws I will explain to you.
I like that. I like
Thoughts, objections?
The statement, I like it.
Ryan, anything inconsistent with what Mr. Williams filed yesterday, which I know was part of the file, we would object to. I think that it's important not to say that don't worry about it, Judge Glanville is fine.
Okay, well,
yes,
I just mean, if you want to come up with another way to say that, that's fine. Do you not want to say anything at all? Just.
I'd like to say what I wrote. He's been removed from the case. That's it. It's not disparaging. It should be disparaging, but it's not. It just says he's been removed.
Well, he is no longer the judge presiding over the case. I think pretty much says that.
That's my.
All right.
Can I also ask just a procedural question?
Mm-hmm.
You were very kind in emailing us transcripts like June 7th. Is that, can I ask you, do you know if that's in the record?
It is not yet because it was the rough. Are you talking about of the ex parte? No, when Ms. Weaver sent it to me on request, she said at the time, this is still rough. So as soon as it's ready in final form, I can ask her to file it, but it's not yet.
Okay, thank you. It's just that we've been referring to it.
Sure.
In an appellate court opinion.
Now, it will get in the record.
Thank you, Your Honor.
All right.
Your Honor, with respect to the instruction that you are to disregard comments that were made regarding any of the lawyers. The only concern I have is that, of course, the judge ruled on objections, and in the ruling, I don't know if anyone could perceive any of that as comments. I know it's kind of silly, but it's plausible. And I would ask that the court, with respect to the pattern or the altered pattern instruction, instead read the decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in the case. The court is only interested in seeing that this case is tried fairly based on the laws and the Constitution of the state of Georgia and the Constitution of the United States, rather than
I am.
Oh, thank you, Tasha.
Is that the change you're talking about? Instead of saying I am, say the judge is?
correct that, and instead of saying disregard the comments that the judge has made, instead read the decisions and remarks of a judge do not mean that the judge favors or leans to one side or another.
So you're saying just say that, don't say disregard.
Right.
Okay. I'm overruling that.
Okay.
So neither side's happy, so that probably means I did a good job.
Well, the court, is the court considering, instead of saying I am, saying the court is? I didn't know.
That's fine.
Okay.
I don't think that's a particularly substantive change.
Oh, TT, thank you for stopping in.
All right. So that takes care of that. And we were on I think we had finished the 387 lines 10 through 12, and we hadn't moved on to the next thing yet. So let me know what the next portion is.
Yes, Your Honor. We will actually have to go back a little.
Okay.
Mr. Shard and I had the ability to meet during the lunch break, and we did discuss those redactions that we agreed with, and there were a few early on that we realized we still disagree with. So the first, Your Honor, is page 266, lines 14 through 24.
You ain't missing nothing.
Okay.
My stance, my belief is that this goes back to the issue of the hearsay about what he believes, quote unquote, Mr. Williams said to other people. And so really the key part of this is the last section. So Doug was like
yeah,
that gun, you know what I mean? And it just
it looks
we need to know
that, yeah, that's definitely nothing but hearsay at this point, and we have no idea. So that we need a foundation. And that also outside the jury. Agreed. All right.
Your Honor, page 270, line 4 through 18.
You know, I stand by my objection to this, but in candid to the court, I can't say the page number, but previously stated that Mr. Copeland's statement said Shannon was in possession of the gun would be admissible over my objection. I think this falls under the same.
Okay. So you're just making the objection to this part as well. All right. Thank you.
So the next, Your Honor, I think we're back on track, and we're at page 389, lines 1 through 17.
let me read it. Give me just a second.
This is crazy. This is a lot of time wasting. Golly.
Okay.
Okay, so if you go to just the last line of 388, back it up.
Yeah.
It says, they're asking who's talking about Donovan Thomas case. And he says, I never heard Shannon talk about it.
Mm-hmm.
He says, I heard Nard talk and laugh about it. You know what I mean? And he doesn't say what Nard says. So there's
Right.
there's no statement. The fact that I've heard Nard laugh about it, we don't know the context of it, but that may be admissible against Nard, who his name is McMullen. He's on the indictment, but he's not sitting here with the rest of these gentlemen here today. So we think it's inappropriate to talk about how Nard has reacted or McMullen has reacted to this.
Can I ask, so it's either in evidence or going to be in evidence, all of the people that the state alleges committed this particular alleged crime, right? I mean, the jury's gonna know they think Nard did it, that they, the state, think Nard did it.
Well, I would say the state thinks Nard did it. The state in their opening statement has stated as much. I'm standing by my objections about Kenneth Copeland's testifying about what Mr. Darlington said. But that's their stance that Nard was there and involved in the car. But so yes, I would say that's their theory. I don't know what the evidence is going to show or how strong the evidence is going to be, but again, his reaction to this and laughing about it is prejudicial to our clients and irrelevant because he's not sitting here with us.
All right, I'll hear from the state.
Your Honor, we do allege that the person he's referring to as McMullen is a member of YSL and one of the individuals who shot and killed Mr. Thomas back on January 10, 2015. And so what precedes this conversation or this portion of Mr. Copeland's, what he tells police is that they ultimately brag about the fact that they killed Nutt, either by laughing or Mr. Williams' sister. We believe that that's a person by the name of Max. We believe that she is an unindicted co-conspirator in the YSL gang enterprise. We have put in evidence already phone records of Miss White, specifically with the Lil Wayne bus shooting, that she was in the vehicle following that bus, so actively being part of the enterprise. We believe there'll be a jail call that's going to come in regarding some comments that she made specifically about the murder of Donovan Thomas, basically claiming that they were the ones responsible for killing Donovan Thomas. And so these statements corroborate that ability for this gang to be cohesive regarding a crime that they have committed, and talking about it freely amongst themselves, we believe would show cohesiveness with the gang, would show, and that would be in furtherance of this gang cohesiveness.
Okay.
So now I understand that the statements, the argument for admission is J1B2E. I don't understand how it's arguing that Nard, according to Mr. Copeland, saying, laughing and saying, man, F that B, circumstances around when he supposedly said this, who was around, or how that would be speaking for anyone other than Mr. McMullen himself. And then when we get to Max, who, she allegedly said something about, and I guess this was afterwards, according to Mr. Copeland, I don't know. You better not play with my brother. We're really leading to the conclusion that these are statements in furtherance of conspiracy. These seems to be individual statements, just what they think about things. I don't know, maybe Max doesn't like Mr. Thomas, maybe Max doesn't like Mr. Thomas, was mad, but Max is not, it's not a statement by a co-conspirator, it's not furthering anything. Max and NAR do not speak for Mr. Stillwell. Mr. McMullen laughing is not an indication of how Mr. Stillwell feels about anything. And neither of these two individuals, Max or Mr. McMullen, are seated here today. So I don't know why it would be admissible against them.
Okay, so, well, because it's alleged to be a gang and it's alleged to be RICO. And I mean, it's, you know, kind of good in contrast that your client never laughed or said a thing about it. And these people are, you know, it's not true. And you can point at somebody not here if you want to or not. But I think under the state's theory, and given that you're telling me evidence that these people are going to be shown to, at least by a preponderance, be part of this gang or associated with this gang, and this is kind of bragging on the gang.
Well, Your Honor, regarding the association with the alleged gang, I just want to make sure I'm clear. Max is not indicted.
Right.
She's not charged.
No.
Really, this is the first time I'm
Hearing that she's an unindicted co-conspirator?
Yes, I've heard her on jail calls talking with me. But I don't believe I've ever heard that she's an unindicted co-conspirator.
Now you know.
And I believe you did during the entire Lil Wayne bus shooting.
Mr. Steele corrected me and said that they have.
Okay, all right. So, yeah, I'm going to let that in.
Okay, what's up?
For Part A, we're complete. I know Part B is probably going to be handled by Mr. Adams, I think. So we have
Part A and Part B. I don't know where you are now.
So Mr. Shar handled some of these redactions previously, and then Mr. Adams handled
Okay.
the rest of those.
All right, take it away, Mr. Adams.
Oh, yeah, let's sub in
So
somebody else.
give us the next portion we're going to be contemplating.
Come on the camera so we can see you.
Go from page 413.
Okay.
The end of the transcript.
Ooh, that's a lot.
It was good news. And I believe that I'm really just going to be reciting for you.
Come to the front. We can't hear you.
What we've already argued, discussed,
Okay.
and agreed to.
All right.
I don't, and Ms. Hylton will correct me if I'm wrong, I don't believe there's going to be any disagreement about what I'm about to go. But if I can have about 30 seconds just to check one.
Sure. All right, so you're just going to put on the record the stuff that's agreed to.
Yes.
Okay.
There you go. There you go.
Sounds good.
Yeah. She kind of like Max, you know, but they need to call in the sub because she kind of ruling against him. She let some stuff come in. They need to get another lawyer up there arguing it.
Pages of lines. Might I ask if it's already in writing anyway, and y'all can sort out that you do agree to it, if you might just file it instead of reading it out for the next 20 minutes?
I could. What you're actually seeing me flip through our email exchanges between
Okay.
Ms. Hylton and I.
Okay. Well, you don't have to file the emails, but maybe that might be a better use of our time and easier for you?
I'm happy to do that if
All
that's
right.
the court's preference.
Let's do that. Okay,
One
so
moment,
y'all,
if I
okay.
can, though, let me just make sure we agree on one point.
See, they can have at least a civil conversation with Hylton. They refuse to work with this one on the end right here. Yeah, I don't care what side of the case you on, guilty or not guilty, but I think we all can agree this is getting ridiculous. Like what? What are we even doing at this point? Pink Adjuster, I would like to know what is her motive to keep this going? It's going to be overturned on appeal, so why waste the time? I think to save face, maybe they don't want to be embarrassed by withdrawing the case. So maybe they think that they can still get a conviction somehow, some way. They don't want to let the families down. They've been making promises to the family. So some of the people, we're going to get justice. We're going to get them now. But now it's the only thing that's favoring the defense team is that in the event of a not guilty verdict, then it's over with forever. So I think it favors the defense more than the state to keep going, because the state can't appeal a not guilty verdict. But the defense can appeal a guilty verdict and have a redo. So this way the defense get 2 bites at the apple. If this jury somehow, some way find them guilty, then they get another shot. So it actually benefits the defense more than the state to keep going. Yeah, you must have Breezy Barbie, you must have clicked off. We done been to lunch and back. you way late. And some people were saying Kamala Harris was in Atlanta, but her and Fonnie didn't make any public appearances. So I don't know what that's about. But it wouldn't be best right now anyway, because if you get a picture of Fonnie and Kamala together, Trump will say, "Yup, see, I told y'all Kamala using Fonnie to put me in jail so she can win the election." She's prosecuting me for her friend.
And speak, and I will follow the court's instruction.
Thank you.
I think we can very well go ahead and I can put an email together that outlines what we have agreed to in terms of the redactions. There is one portion that we may or may not have agreed on.
Okay.
And between checking the transcript of that and also just talking, we can go ahead and resolve that. We don't have to do that right now.
That sounds good. All right. So, and you can just file, I mean, it doesn't have to be in email form. You can just print out here's what we've agreed to and file that.
I'll do that.
All right. So what's our next statement we're moving to?
What? See, I missed this. When was this?
Apparently. Mr. Adams got the easy part. Wow.
So we have the on the 21st,
January 21st?
February 21st, 2015.
Okay, right. We've got January 11th, January 28th, February 20th, February 21st, and June 10th, right?
I didn't know Megan was
Right.
So
twerking.
this is February 21st.
She was.
All right, let me get that transcript and y'all can switch to that video to the extent we might need to ever watch a portion of that video.
She was what, twerking for votes? I know y'all lying. That can't be right. I gotta go find that. I ain't heard that. Yeah, at a rally she had. Let me see. Said the blind man. Let me see. Let me go up here and see. She twerking for the U.S. Y'all know what? Don't do her like that because she from Houston. Shout out to Meg.
Okay.
Hold on. Hold on, I'm gonna look it up right now.
Your Honor, and I apologize. Never mind.
Okay. All right, so for the February 21st statement, what's our first portion we need to look at?
For February 21st, the first thing I have is page 13, line 19, page 14, line 3.
Okay.
Do you have timestamps for when you said page numbers?
So this, I have 3:59:50 to 4:20, 4 o'clock and 20 seconds.
Okay.
All right, what's our issue?
Ms. Hylton, I'm sorry, Ms. Hylton, could you say now that I have the time, I wanted to make sure we were talking about the same thing. What, page 13, line,
Line 19 through page 14, line 3.
we got different transcripts.
So is this with Detective Gaither starting, you have it in your mind, we can't do nothing about it?
Yes.
Is that a different transcript? I can email you what I got. I got
Let me see.
whatever I got from Miss Weaver. Okay, Laura, can you? Yeah, no, that'll be crazy if we're not working off the same transcript.
This StreamYard is acting crazy, so I don't know if it's freezing y'all, but it's freezing me. Yeah, I don't know. I gotta figure out what's going on with that. But yeah, y'all let me know if y'all wanna take a 10-second pause from here and we can go watch it. We ain't talking about nothing. We ain't gonna miss none. Cause I can't believe, I can't believe this can't be real.
And Your Honor, what I'm going to try to do to keep this moving a little bit, I have.
All right, y'all don't want to see it. I ain't gonna play it. I ain't gonna play it. Y'all ain't saying that.
Yesterday by the court.
Okay.
Oh my God.
Regarding my prior arguments about some of these issues, and I'm just going to try to go with the transcript and reiterate what I've argued in the past. So it should be the same.
Okay.
And you have the transcript.
I do. So let me pull that up. Can you tell me what date?
February 21st.
No, I'm sorry. The date of the transcript for this trial where the February 21st statement by Copeland is argued.
It is June 21st.
Okay.
2020.
So apparently they saying that Megan Thee Stallion was
All right, I
at
have that up.
at a rally for Kamala Harris. I guess it was a political rally, and they said she was dancing.
If I seem to be arguing something that's not consistent,
I'm not saying nothing wrong with it.
let me know when it's not intentional. It's just I got too many transcripts going on. But
I just never seen it. I never seen nothing like that.
Is Investigator Gaither is prodding Mr. Copeland for information about who shot at him. And in this context,
it won't be an ad,
February,
Mr. Don.
it's February 19th or 20th shooting that they're prodding information about and asking Mr. Copeland to tell them who shot at him and his child and his mother's child. And Investigator Gaither goes through an extended, I'm not going to say monologue because it is broken up, but she is attempting to extract information from Mr. Copeland, and she's talking about the need to protect the community, to keep babies safe, and just essentially makes an argument in that interview that would draw an objection, at least for me.
Okay, we get a break.
To make the argument in closing arguments. So I don't believe, I think, the focus, if we're admitting these statements in part, if they are admitted, they would be because they're inconsistent statements by Mr. Copeland. And I don't know how that somehow opens the door to Investigator Gaither to give basically her, thesis on why her job is important and gangs are bad and the community needs to be kept safe by her and her coworkers. So that's our objection, 403, 401. And it doesn't fall under prior inconsistent statements.
So it was maybe a free concert to get the word out to vote. Maybe not a real political rally. Whatever it is, that's funny.
Okay, I'll hear from the state.
So previously, Your Honor, when Mr. Copeland was here in court, his testimony in court was essentially, and I'm going to paraphrase, I didn't care about snitching. I didn't care about telling on police. I didn't care about telling the police who did the crime back in 2015. And so this portion of the interview was in contradiction to what he was saying on the stand, because in these 2015 interviews, especially early on, January and February, he would not tell the police who shot at him and his child. And so this portion of the transcript, he's explaining, if I tell you, you can't protect me, you can't do anything. And so Detective Gaither is having a conversation with him about some of his concerns, because this interview, Your Honor, is immediately the day after his first interview regarding this shooting. So he's interviewed on February 20th. And then either in the morning hours or late at night, he's arrested on a probation violation. And then he's brought back in again to further, they're trying to find out who shot at him and his children. And he has extreme concern about telling the police who shot him, actually admitting to that. And when we were in court, his testimony in contradiction to that was, one, that the individual that he eventually says shot him didn't shoot him. He says that in court. And then he also says that he wasn't concerned about snitching.
Meaning I didn't have any problem with that. I was happy to tell them what happened.
Yes. And so
if he testifies consistently to that, or if y'all decide that you're going to stipulate any part of the testimony, then this would become relevant as a prior inconsistent statement.
Yes, Your Honor.
Okay. All right. But that wasn't the objection from Mr. Sharp.
So even in going to I give that context because their conversation here is the effect on him, what she's trying to tell him in order to get him to actually tell her who's the person who shot him.
Right.
So we're not really worried about her. We're not offering her commentary for the truth of the matter asserted, but we're offering it for her, what she's saying, the effect that it has on him in order for him to come forward and finally tell who shot at him.
Mr. Sharp, I'll give you the last word.
Well, I mean, I understand the state's argument, but I don't think necessarily the need to provide context opens up the door to investigators just going in long.
Okay, well, I mean, it may be that there are other portions of this that we're going to take up. Right now, I'm looking at 13 line 19 through 22, and then basically 14 lines 1 through 3, where she's saying essentially, hey, buddy, you got to tell us what's going on, which is pretty much the beginning of any
Shout out to the lead
conversation, interview, interrogation between the police and anybody. And it shows that Mr. Copeland is very hesitant to do that. And so if he ends up testifying, man, I don't have any problem with that, then this, I would think, can appropriately come in as a prior inconsistent statement. I don't see any real other kind of like 403 or anything issues with it. So this is in assuming obviously the
we got more action in the chat than in the courtroom.
For getting it in as a prior inconsistent statement is like
not retirement.
So the next portion, Your Honor, is page 25, line 15 through page 26.
You think so,
line
Jiggy?
3, timestamp 40840 to 40940.
And Your Honor, last time we discussed these, this one, the one we just discussed, the one we're just about to discuss now, and the next one, we discussed all together because they're the same issue.
Okay, well, I'll look.
And you, I think you'll see, I hope you'll see that that Gaither says more and more, investigator says more and more. They're all the same.
Oh, all right.
He wore his famous blue. She owe him some money. He it's copyrighted. Oh my God. I might say, well, hell, how old is still? Retired. Oh my God. I'm dropping someone on the next.
So y'all said 26 line
She
3?
denied the motion for mistrial.
So page, no, starting at page 25, line
Right,
15.
line 15 through 26, line 3?
Yeah, it's probably more like line 7.
Yeah, okay. That's what I thought.
Tasha, that'd be weird for him to stand up though. If he's sitting there doing a live. Because if you stand up,
This one looks okay also.
you won't be able to see
me.
him on the camera.
I'm gonna let this in.
Y'all be talking, boy. Y'all say
I mean, she doesn't
anything
seem to
in
be
the
saying
chat.
we're the heroes. She seems to just be saying, God, tell me something if you want it investigated. All right, what's the next one?
Page 28, line 7 through 14.
Y'all say, I'm gonna play with y'all. They say Megan Thee Stallion stole that man's suit for a political
41055 to 41105.
for a political rally.
Any additional argument, Mr. Shard, on this?
I mean, it's the same thing. It's just we care about the life of children and those sort of things, and we're trying to put an end.
They definitely silly, and I ain't gonna play with them.
All right. Any response from the state?
Yeah, I think it's the same thing. She's just trying to get him to tell her who is the person who shot at you. And
All right. Now, if she ends up standing up in closing and starts saying, look at how great the police are, they love this guy's baby, then we'll have a different issue. But just as a part of the interrogation technique going through a statement, I'm going to overrule that objection.
the next, Your Honor, is page 29, line 9 through.
How did y'all just go left? I don't know what y'all talking about.
I have page 48, line 11. I think that's his perfect.
We done went from her stealing, Megan stealing his style to I don't know what y'all on now.
Okay, I think it's page 29, line 9 through page 30, line 18.
The judge is so
All right,
team
and what's our issue with this?
I ain't got nothing to do with y'all side conversation.
Is this the same
I ain't in
concept,
that.
or is this moving on to some other evidentiary issue?
They said my name Bennett, I ain't in it. My name West, I ain't in that mess.
And I believe
The
Mr. Shaw wanted it out
judge is
initially.
yeah, I don't know what the judge is doing now. I mean, at this point, who cares? Let it all in. Woody can just come up there and say he was lying. Yeah, I lied on that one, I lied on that one, I lied on that one. The jury don't even care at this point. Her blue suit was tailored to perfection. He said, come on, my name Paul, and that's between y'all. Yeah, they said she flip-flopping, going back and forth.
This is more side conversation that is, at this point, I don't believe Well, I know our stance is that just because if the state successfully lays the foundation for specific prior inconsistent statements, our stance, my stance, I believe I stand for everyone, speak for everyone here, is that if prior inconsistent statements are included on a tape, that does not necessarily
Jiggy, they say stand up.
mean that the state just gets to play the tape. What they play still has to be linked to prior.
B and Jiggy, y'all been called to the front.
And here, we're just kind of going and talking about things that are not subject to prior inconsistent statements. Of course, I don't know what a prior inconsistent statement is right now.
Right.
But I think that there's a lot of fluff in between.
Right.
No,
Okay. And is the state proposing to, I've got a prior inconsistent statement somewhere in this 30-minute interview. I'm gonna play the whole interview, or are y'all?
So the state's position, again, depending on what we do with Mr. Copeland's testimony, he denies, and I think that's what we talked about yesterday. What he says is, I spoke to the police, everything I said, but it was all a lie. I finessed it all. So we're at a position that I don't know if we have to go line by line, because his general statement here in court is, I may have said everything that you said, I said, but I was only saying everything that I said because I was trying to get out of going to jail, because I was trying to get out of getting in trouble. I was trying to get out of trouble. And so a part of it is we believe that we don't have to now go line by line, looking at the Scudder case, going, I think it's Scudder, I'm citing the wrong case, going line by line. But specifically as it relates to this portion, we asked him about being a snitch, and this is her trying to explain to him, you need to tell us, it doesn't matter if you're a snitch or not, you need to come forward. When in court, he says something opposite. He says something inconsistent with what he said in his interview.
Okay, so if he ends up saying, I don't know what I said before, but everything I said was a lie, then you can't necessarily just play everything he said. But if he says, everything I said was a lie and I just said it to get out of jail, and then you say, aha, this shows right here, you were willing to go to jail and keep quiet, then that's a prior inconsistent statement to what, if we assume he says that on the stand. But no, you do not. I mean, it still has to be, and it may not be, it has to be like every line, but you can't play an hour-long video unless at least most of that video in some way is inconsistent to what he's saying on the stand. So I don't know if I can, I mean, this is pretty theoretical right now, but.
I think we just need to see what he says while we're, because a lot of we believe two things, not just a prior inconsistent statement, but he's also contradicting what he says. So he'll testify, at least previously, that he'll testify, they were trying to force me to only talk about thug. They were trying to force me to do these things, and that's inconsistent.
That would be, so this would show that's not true. Okay, so yes, potentially then, I mean, obviously for all of this, we have to, but I guess what I'm asking is, Mr. Sharp wants to make sure that y'all don't operate under a theory that something in this, and I'm just making it up, I don't know how long the video is, but 30-minute video is an inconsistent statement. We can get the whole video in. Y'all know that, I mean, is that your position?
I think it depends on when he testifies.
Okay, so, yeah. Okay, so then assuming that, I guess we don't have an answer to that right now, but I would not think the entirety of something can come in just because one sentence in it is inconsistent.
Don't run.
So for y'all's edification. That would probably be my position. However, assuming that all of this is going to get used as prior and consistent statement because of whatever he says, we have to assume it for now. Like, that's why we're going through this. Then what other evidentiary objection do you have to it?
Well, I mean, I just keep going back to the same question, which is if the purpose. My problem is all the talking that's, Mr. Copeland isn't really saying anything. It's all investigator gate, and I just don't really understand how we're just giving investigator, and I know Copeland said something, so I'm not trying to mislead the court about the transcript. You have the
Mr.
transcript.
Christopher from
But
the
I
West.
don't know how we're giving basically Detective Gaither the mic when the purpose is to be impeaching Mr. Copeland with his prior witness.
Okay. Well, I mean, I think we got to have the context of what questions he's answering or relating.
To the extent that other people's words may give context.
I'm just making it up.
So, I mean, I would think.
All this is made up at this point. This can't be real life.
I think that in terms of evidentiary issues, then assuming, which we're doing for the sake of this entire exercise, that it comes in as a prior inconsistency, then there aren't other evidentiary issues that would keep this particular part out, 29-9 through 30-18. All right. So what's our next spot?
He said we can get jiggy. Shout out to the play on words. He said we can get jiggy with it. He said he hitting the clock in 30 minutes.
I'm sorry. The next section is page 47, line 9 through page 48.
He said, Doug, say, take me back to my cell. Well, Malcolm, he didn't get out. He still got another year. I think they moved him to a halfway house. So I don't think you can call that out. He said, how are you today, Miss Todd?
All right, what's our issue?
She got the hair laid.
We won't object to this motion being redacted.
Okay.
And I think it,
She just said she's fine with it being out.
right, I'm not sure. You said it begins at 47-9 on your transcript.
So I'm taking a note that I believe I got some.
He on his Twitter arguing with Shannon.
Okay, you're at 47-9. Okay, I got you.
Okay. Next.
So the next is page 65. Line 1 through 5. That's what I had.
Okay. Any memory about why this was objectionable?
I think it may have been the programs that were used that was confusing. I'm looking at the transcript.
Y'all. Anybody know?
All right, we feel like I haven't got anything done, right?
Oh, okay, I know what it is.
All right.
This is my objection. Listen, it was, okay. It was, I think it's likely to
Weinstein chilling.
confuse the jurors. This is a very poor transcript, but essentially, and you can't really tell from reading the transcript, my understanding is, investigator Gaither is asking, when's the last time that Shannon and Demekion were hanging out together? And when it comes down to it, the answer is, his answer, it comes down on page 65, line 5. It says, since they shot at the call, they call. And when I hear that, in that context, it seems that he's referring to
They as in Shannon and.
Shannon as shooting in a car. I believe what Mr. Copeland meant by that is it was an incident where they were all shot at. But I just have a problem with this being played and putting that perception in the jurors' mind.
Okay. All right, and is there a redaction that could be made? So what is it that you potentially want this for?
Jiggy said he was at work.
If it comes and it gives a lot of context. So Mr. Copeland, in this interview, this is now his third interview that he's had with APD, his second with Detective Gaither. So, and excuse me, this is his fourth interview, and I'm saying this in context. In the January 28th interview, he talked to Detective Gaither about the shooting in the car with Demekion and Shannon with him. So when he's discussing right now in February that the only people he hangs out with is Little D and Shannon, and that the last time that he's really seen them is since they shot at the car, that's going back to what he's already talked to Detective Gaither.
All right, in this particular interview, have he and Detective Gaither just been talking about that particular shooting where the three of them were the ones who got shot at?
He's talking about collectively everything that's been happening since January 10th.
So no then? Like if you're the jury listening to it, you might be confused when it says they shot at the car.
But this is the only car incident that when you look at all the interviews.
All right, hang on. So y'all have alleged, I don't know how many different acts in furtherance of a conspiracy, and you've got 8 or 9 different incidents, I'm sure some of them involving cars, where people are getting shot. So it is entirely possible if they hear this that they, the jury, will be confused into thinking, here's Mr. Copeland saying Shannon and Mr. Garlington are out shooting at a car. And that would not be fair to the defense. So is there a way that maybe we can redact out that little part about they shot at the car? Since nobody knows who the theys are if you don't listen to the whole 4 interviews in their entirety to know the context of it so that we don't confuse the jury.
No, they say you be somewhere else,
Yes, there is a way to do that.
You be
Is your
somewhere
answer.
else, Jiggy.
Later on in his answer, you're saying,
Let me see if I can find it.
Yeah.
That's where they say you be at.
That confusing sentence really
Adds anything to it.
Yes, there's a way we can redact this, Your Honor.
So y'all can just redact out that part.
Yes.
All right. So that is 65 line, is that 65? Yeah, 65 line 5, the part that says since they shot at the car. So the rest of it's fine.
You ain't in
Right?
no office,
It's the rest
Jiggy.
of it's fine, Mr. Sharp, essentially. Okay. Next.
Jiggy say he in his office. They say you.
The next part we have, Your Honor, is
Shout out to Cat Don Williams. We had fun
page 155.
the last chat. I think it's
Line
page.
1.
Oh, my bad. Got a alert.
Page 156, line 7.
Okay.
What tripped me out with these alerts, sometimes they be making it seem like somebody bit kidnapping the whole time they with their dad or their mom. And they kept them over their custody deadline. Like, what? We needed an Amber Alert for that? Somebody stole it back. Oh, my God. All right. You say first day out party. And for those of y'all watching behind the scenes, y'all don't mind hitting that like button.
All right. I'm ready for argument.
And if you want to come back, hit the subscribe button. They been saying, "Oh, your chat, y'all crazy, y'all be crazy." He said, "This is my first and last day coming over here." Oh, thank you, Miss Danny. Still.
The issue, Your Honor, is, so, little context.
Funny
There's a shooting at a gambling house, where by this time, Mr. Copeland has determined that an individual by the name of Kelvin Watts, as well as some of his friends, I guess, were responsible. And I think Mr. Copeland was allegedly shot out. I think Mr. Williams was allegedly shot at or present in the gambling house. maybe some other individuals as well. Mr. Copeland tells a story, and it's tough to really grasp from the transcript, but no one knew who did it. According to Mr. Copeland, no one knew who did this shooting. It was supposedly, and everyone thought it was another group called NBC who had jumped Demekion Garlington on that same day at a club somewhere. So the thought was NBC was responsible for shooting the gambling house. Now, by this time on the interview, Mr. Copeland has determined it was Kelvin Watts. How did he determine it was Kelvin Watts? What's his basis? Well, Kelvin Watts was apparently dating a lady named Trivia, who Mr. Sledge also dated. So the flow of information, as I understand it, is Kelvin Watts, according to Mr. Copeland, Kelvin Watts tells Trivia that he was responsible for shooting up the gambling house. Then Trivia tells Mr. Sledge, and then Mr. Sledge tells Mr. Copeland. So these are not observations based on Mr. Copeland's firsthand knowledge. These are, it's like game of telephone at this point. And he was under the impression that it was NBC based on speculation. So, you know, if Mr. Copeland gets on the stand and starts talking about what he saw at the gambling house that night, that's one thing. My understanding he was there, but to say who did it and all the rest is just layer and layer of hearsay. And then on top of that, he's talking about Mr. Garlington being jumped at the club by NBC. And my understanding is Mr. Copeland was at the gambling house and not at the club. So I don't know what his basis of knowledge on that is either. So he's talking about two different things that he doesn't know.
Okay.
What's going on in court?
I'm not sure what the shark said. He doesn't know about the shooting. He does know about the shooting because he was present at the shooting. So the shooting.
Right, for that, it's who's responsible for it might be hearsay on hearsay on hearsay. What do you say to that?
Well, what he says here now is that Gucci, he found out from one person, which was Gucci Red, and that is not Trivia Smith. That's two different people. Gucci Red and Trivia are two different people.
Okay, so where's the part where he says, here's who I knew it from?
So if you go to page 156, it says unintelligible, so you need to hear it. But it says Gucci Red. I can play that portion for you.
What part of what? Give me a line number.
Line 17.
Okay.
And if we skip to line 15, says, "Goddamn! The next night we at the gambling house. They ain't putting no picture. We in there gambling. They taking pictures and shit. Then they came up and shot at us. Only reason we found out it was Kel. He had got into it with Gucci Red, and then she talked to them, and she came back and told us, like, man, that was Kel and them that shot y'all. Make it seem like they did because they shot it up.
Okay.
And then they went and shot at another spot. And then Monday we got into it with NBC, and then he goes on to talk about whatever happened between them and NBC. So whether or not Gucci Red told them that Kel shot at them is irrelevant, because what this incident at the gambling house does is kind of form the basis of other events that happened after the gambling house. So some key incidents early on in this conflict between YFN and YSL is there's the gambling house shooting, and that becomes important because after the shooting, I believe it's the next week or the next day at Cascade Skating Ring, Kel, who's the person who shoots at them, and Mr. Williams have a phone call in the presence of Copeland, in which Mr. Williams wants Kel to pay for his car window. So this, whether or not Gucci Red told him doesn't matter. It's what happens afterwards, which is the impetus for this conversation about paying for the car that was shot up at the gambling house.
Okay.
In other parts in in the discovery, it's the flow of information is described as different, but either way, if it comes from Gucci Red, it's still hearsay.
Well, it is, but they're saying they're not offering it for the truth. Right?
Yes, Your Honor, it's the effect on the listeners, which everything that happens after it derives from them knowing that it was Kel who shot at.
All right, so if that's the only objection, then I'm gonna overrule that objection. Okay.
Next, Your Honor, is page 173, line 7 through page 174, line 2.
He said Hylton been using the same piece of paper all day. Oh.
Okay.
we shout out to G. And Jiggy want me to put y'all in timeout. What Jiggy say now, Miss Tasha? Oh, shut up, Jiggy. Y'all funny.
All right, Mr. Sharp, you
And I thought it was
wanna
me.
articulate your argument.
Please.
And Ms. Hylton, you said it ended at 174 too?
Yes, sir.
Jiggy, I'm trying to go and read some of these comments. But they,
we'll withdraw that.
All right.
Yeah, next is page 181, line 8 through 12.
All right. Can,
And
any
we-
chance we can just get rid of that?
Yeah, we
Okay.
have an objection to that.
There we go.
And the last one we have is page 185, line 17 through page 186, line 19.
I ain't even see a leave. No, earlier you said you didn't want to see it, TT.
And you're right, we're okay with redacting.
Entirely? Just trying to get clear what you're saying there.
Yeah, Amy, I agree.
Okay, so that'll be 185, line 17 through 186, line 19 will be out by agreement. Okay? What's our next
changed my mind.
portion of this transcript?
That's the conclusion that we have.
Oh, okay, well. Okay, what's our next statement we're moving to?
We can do February 20th.
Okay.
Somebody sent me the same transcript.
And is there an associated trial transcript where y'all are arguing this that might be beneficial to look at? I mean, we didn't end up using that other one very much, but.
So you want some from McDonald's and then we're the conspiracy.
I mean, if you're not gonna be using it, then that's fine.
Well, I'm trying to remember. I haven't seen this transcript.
Okay.
And February 20th may have been earlier before the break.
Oh, well, hey, then, we don't need to rehash that one.
And that's what I'm trying to figure out, but for January 11th and February 20th, I'm trying to figure out when we had those arguments, because we actually played those videos on the.
Okay.
We haven't received the transcript when we discussed January 11th or February 20th, so I don't have an independent recollection of what they are.
And those who had the minimal, we agreed on most of that.
Okay.
The actions that came out, we agreed on.
And they've already been played, y'all just aren't sure whether it was pre or post recusal motion, is that what you're saying?
Yes, those two videos were played. Let me back up so the record's clear. The video for January 11th and the video for February 20th were both played in front of the jury.
So
At least on the 14th and I believe on the 17th of June.
Okay, but,
I assume that the argument may have happened.
okay,
I don't know if the argument happened post the 12th.
Right.
I can't recall, or if it happened pre the 12th. That's what I need to determine.
So I have some notes.
Okay.
That were taken by Tim, who, I have that the June 11th interview, excuse me, thank you, January 11th interview was played on the 17th. And the February 20th interview was played on the 17th. So those were played after the motion. I just want to make sure. What does this mean?
Come on, chicken. Ooh.
It looks like portions of the January 11th were played before, a very small portion, it's like 30 seconds of it.
Was played before what?
Well,
Okay. So would that indicate to y'all that y'all had already hashed out the evidentiary issues with regard to the January 11th statement prior to the motion to recuse being filed? It would indicate that to me, but did you at least do the entirety of this January 11th statement at the same time? By which I mean, that was not at all clear. Did you handle the evidentiary issues with the January 11th transcript all at the same time?
I knew what you were asking. I don't know the answer to it, and this is why, because
Okay.
in this matches my recollection. This Hylton used January 11th to one very particular point that she played like 30 seconds
Right.
to Mr. Copeland. So I don't know if we had reviewed the whole, and she also played a 10-second clip of the January 28th interview before the motion to recuse.
All right.
And a 12-second clip of the February 20th. But I'm trying to see if there's any note about when we discussed the actions.
So I know that after the jury leaves and hasn't yet come back, y'all discussed the January 21st and the February 21st one. So y'all had not done those pre-interview. I'm not helping, am I? I'm making it more. Okay, yeah, no, I don't know what that means. February 21st. I don't know. So if y'all don't know whether you dealt with all of January 11th at the same time or not.
So, Your Honor, initially, I impeached Mr. Copeland as the issue or the topic came up. Then when it turned to everything's a lie, then we went to getting in the entire statement. Or playing the entire statement. And so when we had argument.
All right, so you spent a lot of time after the Yes.
I'm looking at notes for 6/17/24. We sent redactions regarding. We were discussing redactions, I think, on the 17th regarding January 11th, January 28th, February 20th, February 21 interviews. That leads me to believe that these were not redacted prior to the 12th.
Okay. Well, y'all said y'all are close on those anyway, so why don't we just.
So I think
if it's me revisiting and ruling differently, then maybe lucky state, maybe lucky defense. Who knows? I don't know.
So I think the next video we can actually go to is January 28th because that is where we had some more redactions.
So are y'all just then, as to January 11th and February 20th, y'all said, I think, that there isn't much y'all disagreed with about that anyway?
That's my recollection.
All right, so maybe y'all can get to huddle up together on those two and maybe y'all can come to agreement. If not, you can either figure out was the ruling made before the motion to recuse, or if there are two or three things and we don't know when the ruling was made, just bring them to me.
Yes, Your Honor.
Okay, so then we'll move on to February 28th. Is that what you said?
January 28th.
January 28th. Right, February 21st, January 28th. I am just making it that much more confusing. Sorry, y'all. Mr. Harvey's going to use that later when I say that. Even the judge admitted it. I'm teasing you, Mr. Harvey, although I bet you will. Okay, January 28th.
Yes. So
And that has either not been discussed or it was discussed post recusal motion.
discuss post recusal.
Okay, and so do we need to look at a transcript, or Mr. Shart, you're just gonna?
If the state has a transcript of this motion, I mean, of this hearing.
February, January
I'd like
28th.
for about the same.
All right, we can, I assume we have the one that. Ours came, I don't know where ours came from, if they came from Ms. Weaver or from the state, but Ms. Percival will forward you what we have. Is everybody good? Does anybody need a break? Quick break, 10-minute break. Let's come back at 3.
She just seen homeboy do a big stretch. Let me go back a few seconds. And she seen him. He did a big stretch. Let's see. This one right here. Look. Oh,
Is everybody good? Does anybody need a break? Quick break, 10-minute break. Let's come back at 3.
Get back to them. Hey, what I want to know is what's going on. Hold on, let me switch that. Oh, did I not hit the play button? Oh. Man, we moved past it. Hey, we too late now. We too late. It's too late. Yeah, we late on that one. Yeah, I'm gonna drop the link real quick, but it'll be real short while because we can't have all the traffic once the court comes back, and then we can. And then we can probably do something. I may drop it again after the court if y'all still here. She said, I'm scared. The chat been cutting up. She said the chat been cutting up. Best ever. This the most I come in lifestyle. Who is Malcolm? Who is Malcolm? Well, if you scared, what's the question then? Just ask it in the chat. And maybe we can answer. Maybe the chat can answer. So I don't believe that one bit, the way you stand on business. Thank you. The 313, the best side. She said he the feds or some, because we always got to click on all messages in the chat to see his comments. Oh, see, I don't know how they work. I don't know what it looked like on y'all side. I didn't know that. TT is. So you already watched it, didn't you? They got music and stuff on there, so we can't play it on. I'm just glad she didn't do it while she was on the stage. I would have been just done. I would have been done if she would have did that while that woman was on the stage. And then they were like, "No, if you play for her, it's a political ad, and you can be." I already watched it, D. I already watched it. So my reaction has gone. What's going on, Tasha?
Nothing. You gonna play the video for us?
No, that's gone. We late on that one.
We not late. We kept
We
saying
late.
play the video. Even TT say play the video.
No, because that's political. They said it's a political ad. Y'all did y'all not see the comment?
Nah, we ain't see no comment.
Yeah, I said
What
nah.
comment? What comment you see? We ain't see no comment.
They
You said all
want
you gotta do is put it on mute. You don't even gotta play the whole thing. Go ahead and play it and put it on mute.
because y'all gonna take this as an endorsement. Let me see. Hold on.
We not saying that you endorsing it. You can put the banner up saying I do not endorse this.
Let me see. I don't even know how to- This ain't no strips. Let's see. So apparently, this is a video of Megan Thee Stallion at, I'm gonna say a free concert. Y'all say a political rally. I don't know. I think it's a free concert, just educating the public to register to vote. Cause y'all, one thing y'all not gonna do is do Megan Thee Stallion from Houston like that. But let's see what happens at the thing. We're gonna play it on hopefully mute. If I can do it, let me see. Let me know if could y'all see this?
Yeah.
Tasha?
Yeah, I can see it.
Okay. So supposedly she's dancing at the they said she got the suit on. Oh. Somebody said she got a lead attorney's signature suit on. She done stole his suit.
You seen that little jump with the twerk. That was inappropriate.
This can't be real life.
It is real. This is
No, I know it's real, but I'm just saying we have moved so far in politics. Imagine this happening back in the day. Imagine. I mean, not just this rally. I mean, Trump has some wild stuff going on too. You know,
right, because he just got shot in the ear, so we can't really say too much.
It's a lot going on. Like, what the hell is going on in today's times?
I don't know, but somebody wrote on the little comment. They said, y'all, we need to put all our extracurricular activities down and start because they trying to play in our face.
The chat then went down about 5-6 people. They going to go find this video.
Mm-hmm.
They going to go find it with the sound.
Listen, I ain't gonna even lie to you. I seen you when we was watching court. You went to go look for that video. You was searching.
It didn't take me long. She said, "Ooh, delete my last comment."
Ooh.
Right. No.
Highlight it so I can see. TT.
No, it got some words on there.
Oh, okay.
I try so they don't mess with the video. I tried to put the ones with the words on there.
Yeah, well, we only got 10 minutes. I only came up here. I was gonna throw some ones, but it's
throw
okay.
some ones.
Yeah, I was gonna throw some ones for Megan Thee Stallion. I was gonna throw some ones. I mean, if Jiggy and D willing to come up here and show us their skills, then I can load them up. Yeah, yeah, we'll take super chat.
Hey.
Slick. He said he blocked me, but he can see me on this panel.
Oh, even if you're blind, he can see you up here.
Mm-hmm.
Oh, that makes
Yeah.
sense. That makes sense.
He
What?
ain't
Where?
blocked me.
Nah, yeah. Where Jiggy at? Y'all are funny.
Jiggy done left us to go get that Haitian food, but it's okay. When he watched the playback, he'll see we was offering to give him super chats to come up
D
here
said,
and
I'm
show us
finna
what they
go
working with.
vote. I'm finna
Okay.
go vote. You voting today?
Hey, everybody, if y'all want to see D come up here and do the same twerk that Megan did, drop some green
Oh, they
hearts in
say
the chat.
Miss Deborah C. Kamala didn't know about that.
Oh, I don't know. I mean, she had to approve it. I need to see some green hearts for D to come up here, y'all. D gonna give us a debut after the stream for.
Wait a minute. So it was an official rally where Kamala showed up to, or they were just putting it on in her name?
No, that was the official rally. That was her rally that she was promoting, and they asked Megan Thee Stallion to open up for her at that rally.
Oh, to open up for her, so she okay. I got you.
You know, that was planned. That wasn't no. She knew what was going on. She probably didn't know exactly what was gonna happen, but she had an idea. What else could Megan do?
Yeah, it was an official rally. Oh wow.
All right. Okay. D said he gonna shave my head. I gotta get down because I like my hair.
Oh, so now you can read the. You know what?
I can. Yeah. I can read the comments. Cause what he not
Tasha,
gonna
you
do?
funny. You are funny. But
Listen.
you are.
Yeah, I only came up here because we had a short time on a break, and we had to make sure he played that video on this
And
screen.
I knew that's why you was. I said, look, I knew. I
Yeah.
knew.
You knew it because you heard me say play it and drop the link real quick so I can get D gave me all his extra money from his last
Funny.
extracurricular activity, so I got a whole bunch of ones I can throw from D to y'all in the chat.
She's like, I keep telling you it's an official thing. Oh man. I mean, the young folks gonna show up because they want to see her and get, the free concert, whatever it was.
Yeah, you seen they said they was HOEs for Harris.
Wait,
New
what?
promotion. They have she had hotties for Harris, so that's Megan Thee Stallion thing. But some people was on Twitter saying they mad because now it's the HOEs for Harris.
Oh.
Oh, I got to get down now. Slick has officially arrived in the chat. I told you I was done. Y'all have a good day.
All right, thanks, Tasha. Oh my goodness, y'all. Oh my goodness. Y'all, let's get back real quick over to the trial because the judge should be walking back out in any second now. We want to make sure that we don't. Oh, what happened to my? Oh, hold on. People say, hey, I clicked on your link. I was trying to get your opinion about the trial. And when I clicked on there, I seen a girl with some blue pants dancing. I didn't know what was going on. I thought you were high. What's going on there, bud? Oh, my God. All right, y'all, we back. They ain't talking about nothing. Just let us go home. Let us go. Oh my God. Y'all are funny. Oh my God. Oh. If y'all don't mind hitting the like button. Oh. If y'all don't mind. I'm trying to see who unsubscribed so far. This is not an endorsement of either candidate. Yeah, but somebody did say that. They said, hey, if you play a political ad for, I forgot who said it. You got to pay one for the other side. Like, hey, this ain't no political ad. We just doing the dancing part, not the message. I forgot who said I can't even scroll up all the way there for, but that was funny though. All right, we back up. Thank you, 313. The best side. Did they not turn on the audio? Or do I have it muted? Looks like I got the audio. Maybe the court hasn't turned on the audio. There we go. It's the court. Can you please bring?
Your Honor, can we have just 3 minutes? I think we might be able to get through this much quicker.
So now they need 3. He said, I never seen her before. Megan look, he finna go Google Megan Thee Stallion. Shout out to Megan, all the way from the great state of Texas. Houston in the building. Who was that cop right there? Is that Deputy Brown? is that the one that leaked the info, or is it somebody else? Yeah, Hylton working. Love ready to go home. Love. Somebody said, who said that earlier? Love somewhere looking for a job. Put your cash up. We'll do. Let's see, I think I got the banner already pre-made. Thank you for asking. Let's see. But who is it? She said, what would you do without this chat? I don't even know. But yeah, y'all definitely made my day today. Be you funny. Crazy straw. It was an nasty work. Not a crazy straw. She said she'd do get a shot of that gray goose to get her loose. Oh, what? Law Malcolm said this is what? So you don't like the judge, Law Malcolm? Somebody said we literally too top. Wait, what? Wait, what top are you talking about? The judge got her scared. Got who scared? Oh, you talking about Love? Not a crime. Oh my God. Oh my God. Y'all are funny. Well, we might as well do some while we here. How they used to say, binks that we here, might as well talk about some because they surely ain't talking about none in this courtroom. Politicians say she lost it. She had more when she was in the H. That's what politicking males say. But she didn't went to Cali and chilled out there for a little bit. Yeah, this is a lot of wasting time. Come on, Judge, get a handle on this thing. This is insanity.
So you're on the first time that we have, we're at issue is page 42, line 3, through page 44, line 8.
Oh. I want to say thank you real quick to TT for the kind cash out for a great stream today. Thank you. Thank you so much for the cash out. TT, that's really kind of you. And I ain't show your name, just the just this part. So thank you so much.
It's a discussion about possible, quote unquote, beef between Buddy J, who is, his name, last name is Usher, and he is allegedly a member of IF, or an affiliated subset of IF, and he's a rapper. And I think the state's theory in some ways is that it was considering beef between Buddy J and Mr. Williams, because Buddy J said some things about Mr. Williams, Mr. Jeffrey Williams, I should say, and Mr. Copeland goes on to say, well, they say that Birdman Williams, Brian Williams, aka Birdman, wanted to sign Bloody J, but Jeffrey Williams didn't want Birdman to sign Bloody J because of the feud that they had between each other, and he was blocking Birdman from signing Bloody J. But so that's the background. Look, the bottom line is Mr. Copeland saying, they said that Birdman wanted to sign Bloody J. There's absolutely no indication. My understanding is that Mr. Brian Williams is a multi-millionaire who runs a big record label. There's absolutely no indication that Brian Williams is running his ideas of who's going to sign and not to Kenneth Copeland. And Kenneth Copeland's just kind of, and he says it. He says they say this, they say that. And so that's all hearsay from our perspective. It's all speculation. It's not based on those things. And Brian Williams is on the state's witness list. So if they want to call Brian Williams and ask him about what his plans were,
Jeez.
Bloody J.
Gee.
But Mr. Jeffrey Williams allegedly stopped it. They can certainly ask Brian Williams.
And Your Honor, the state has no objection to page 43, starting at line 4 through page 44, line 8. The only portion that the state wants in is page 42, line 3 to page 43, line 2. Mr. Copeland, it's either in this interview or one of the other interviews, talks about how he actually brought back, or he tried to get Bloody J and Mr. Williams to kind of, at some point, start working together again. So he has some familiarity, we believe, with the relationship between Mr. Williams and Mr. Usury. So when he's on page 42, when investigator Dennis asked, so what happened with Bloody J? Weren't they cool? He explains his understanding of when they may have started to fall out. This transcript is not the best, but some of what I believe is in this transcript, if you go to line 12, when you said you was trying to hook them back up, what happened? Like, did they fall out? Was it a beef or something? His response, I think they did because Bloody J joined they gang. Whose gang? If gang is what it actually says.
That's not saying gang.
No, it says,
it's gang, G-A-N-G.
and it's saying if gang, I-F gang. He says, and I guess he was down with YSL, and I'm at line 23, and then it says, you know what I'm saying? So he joined them. And so that's his understanding of where their beef started at some point between Bloody J and Mr. Williams. And this is corroborated, Your Honor, because
come on, Hylton.
We have video evidence that at least back in 2012, Mr. Williams and Mr. Ushery, they're releasing music videos together. At the time, it looks like it's a ABG or Atlanta Blood Gang music video, but they are friends. And we know that the friendship dissolved sometime after 2012, which will corroborate or lean into what Mr. Copeland knows about their relationship. So we that's the only portion we wanted in, which was page 42, line 2, up to page 43, line 1.
So I understand the objection to that being this, for all we know, is hearsay about why they fell out.
I think it's the way that he speaks. And if you watch it, it doesn't seem like he's saying they, like this is something they told him, because he says, when you said you was trying to hook them back up, what happened? Because he was trying to bring them back together. So it seems the state understands that he has personal knowledge of how the relationship dissolved, not something that he overheard but something that he's.
Yes. Additionally, Mr. Copeland, outside the jury's presence, and has personal knowledge of it.
The next portion that is in in disputes, Your Honor, is page 203. Excuse me. I need to find out from Mr. Shard if he looked at what we discussed of 80804 all the way through 81150.
Can I back up on one? My notes may be wrong. Did you agree to number 5? 750.
Jiggy say what?
Yes, we're not going to contest that.
All right, so where are we now?
Where are we now?
80804
So
to
there's
80.
the timestamp.
So roughly page 178.
This is a big one. We agree from 80804 to 80912.
Right, and I don't have the
So-
timestamp, so.
Page 178, line 7 to page 180, line 8.
Tosh.
And the state wants to go beyond that. And what happens after 180 line 8 is very interesting. This is January 28, 2015. At this conference. He spoke on January 11th, 2015. Speaks on January 28, 2015. February 20th and 21st, 2015. And then on June 10th, 2015, is the first time he says that my client and other individuals are responsible for Donovan Thomas's murder. In this segment right here that the state's wishing to redact, they ask him about who he thinks or who's responsible for Donovan Thomas's murder.
Hey.
And he says, well, what my understanding is, or what I've heard, now mind you, his stance on June 10th is he knew that my client and others committed this murder that night. So he was in knowledge of it that night. On January 28, 2015, they're asking him, who's responsible for Donovan Thomas's murder? And he says, well, I believe, or I heard, and I'm not asking him to do the truth of the matter asserted, I'm asking to show that his story's changed and he didn't say it initially. He said, well, I heard that Kelvin Watts had robbed someone and then Donovan Thomas was murdered as a result of that. And I believe, I'm not going directly off the transcript, but he puts forth different theories on what happened to Donovan Thomas. And our stance is that's important for the defense because if he was a truthful person who was telling the truth, he would have said that then. Now, the other interesting thing is on all these other dates that he's given these statements, he's not facing arrest. It's not until he's facing arrest that he points his finger at my client and others. So to us, that's a very important fact. And it's
I agree.
not
We
being
can't hear nothing.
for the truth of the matter asserted.
Hey, Tasha, hit the link if you can.
What Mr. Copeland has said at different times, with common sense would dictate if he's being a truthful person, he would have said
I ain't gonna
what the state's saying the truth is.
if you can for a second.
All right, are you sure this is 178, line 7 through 180, line 8? Because I don't see this being about any of.
So that's the part we agreed on. And then they want to go beyond that. And starting at 180, about 180 line 8. And we want to keep it in.
So 180, line 8 through what the state wants out.
Until 186, line 2.
No, Jiggy, no. I was going to ask her a question about her. We share her channel to support it the other day. Yeah, she didn't have to come up. I just needed to ask her in the chat.
Mr. Hylton, could you just, want to stop?
Page 186, line 1.
And the transcript doesn't really.
We can listen to it. And why, I mean, maybe get the gist of it, why does the state think
Because it's a lot of rumors. This is actually not him testifying from personal knowledge. When he first starts on page 180.
So I would concede it's not personal. I would concede that that's not personal knowledge.
So think that they can cross-examine him on whether or not, why didn't he tell the police early on, but all of his speculation about what the rumors are is irrelevant. That's putting in information in front of the jury that's based on speculation and rumors. If they want to cross him and say, on January 28th, you didn't disclose that any of these people did it, I think that's fair for cross-examination, but to actually introduce this statement of him speculating as to what may or may not have happened on the night of the murder, it's just that, it's rumors and speculation.
There's a fundamental difference between not coming forward with information.
You got a channel? Yeah,
being asked about something and coming forward with other information.
Yeah, she got a channel. I ain't even know she had a channel. So she always supported it. Never said nothing.
On page, the very end of 184 and beginning of 185, maybe? And I'm not even sure if that seems to be the only thing they're talking about, but
The beginning part of what they want out, and so there's after the part with our agreement, they talk a little bit about an incident where Kelvin Watts shows up at Lucci's mother's house after it's been shot up with a gun.
Yeah.
That is a separate, so I don't want the court to be confused. That is not the the Donovan Thomas murder.
Okay, so do you want that part here?
I do want it in. If you ask me why it should be in, I want it in. But the reality is, I don't believe that Mr. Came to the court. I don't believe that Mr. Copeland has firsthand knowledge of that And that doesn't really fall under my argument about the Donovan Thomas.
Or then you agree that we don't have to talk about that part, so point me to the part where we actually, that you, the defense for Mr. Stillwell, want in and think appropriately come in under this.
I think, respectfully, I think we need to just play it because
That's
I can't,
fine.
the
That's fine.
transcript is so.
Please play something.
Yeah, no, I mean, I think so too, but certainly it's not that part about which, and which is. All right, so can somebody?
Yes, so I'm gonna start around, as a reviewer, at 8:08:30, which should reasonably be somewhere on page 179, probably around line 7.
When she was, she can come out and then this like Rich on the corner door had a show. And I was there. And Rich on the corner came, but Rich on the corner tried to play both sides. So
He like this guy, like.
yeah, so he just like bro, man, I'm tell you how serious it is, bro. Kill try to kill anybody, bro. He told me to call Max and tell her, trick her down here so he can kill her. Just to get back into it. Yeah. He said like he wanna kill somebody that way gonna hurt. What the hell? Do what he's saying. But Rich on the corner, you born him out of jail. Lucci ain't gonna pay his bond. They said he mad at Lucci because Lucci ain't pay his bond.
Why? Why Lucci ain't pay the bond?
But what don't make sense, let's say, okay, what word did we get, right? Somebody said that Kel was called over there to the house after he got shot up. So at Lucci Mama's house? Yeah. All we heard was Lucci Mama's house got shot up. Kel pulled up with the guns. They would come to the tree. Kel pulled up with the guns in the car. And police walked up, searched the car, found the gun, locked him up. But why
Why was he there? Who brought him there?
I don't know.
Lucci Mama house. Kel, come. Who brought him to Lucci Mama house? Like, how did he know he got shot up?
Like, do you just hang out in the driveway? How do Lucci? They probably, you know.
So if that's the case, and then he got locked up, why did Lucci want to pay his bond?
Oh.
You know what I'm saying? If I basically
called you and said, yo, my house got shot my town.
Check out.
And then the red Camaro Lucci got, the same color they ran around, they shot my girl mama's house up. They Lucci cup. You know what I'm saying? But I ain't get it. You know what I'm saying? They got my name on so much stuff. Like, people that come and tell us, they tell us little bit, then they start talking about it's me. You know what I'm saying? Like, my girl, she get a lot of information from her friends. She got a lot of friends, so they be around me. Lucci and them was talking in the studio, and it was a girl in there. They missed one of them, and she my girlfriend. And she said that they nobody can do that. Nothing. You know what I'm saying? They was all like Kill and K robbed somebody. You know what I'm saying?
Kill and who?
K.
Who's K?
I sent you a picture there too then. I think I sent to those each other. They had chop on in the picture. Oh yeah. And the them was in the car. Yeah, them two robbed somebody, and they supposed to came back. This was they talk about the studio. You know what I'm saying? They just put my name on it and covered it up. Make it seem like they ain't got beef in the streets, whatever. Yeah. And then they like, she be like, they know we can't do it. You know what I'm saying? But they gonna keep playing on him. And she be like, K, when the nigga got killed, K first one called everybody like, we killed Nut. We killed Nut. Tell them on there what did. He the first one started my name. And they like, Kill went along with it. So they had just robbed somebody, then they did. Like, Nut died, then they started. That same day? I don't know when. They just robbed somebody. And niggas supposed to be coming back for them. You know what I'm saying? Like, Kill robbed Flat. Flat. He robbed one of them. Like, and then, like, they would have somebody broke in that car. And gave me the phone. And the jury.
What we even talking about?
So, Your Honor, look at a lot of it is.
Just can understand that.
About what he's hearing about what happened leading up to the murder.
She couldn't understand nothing.
I don't even know if they're rumors that he heard. I don't. He might be completely making it up and never even heard a rumor, but that's besides the point. They're asking what happened, how did Nut get killed, and he proffers a theory or a story that that Kel and Kay robbed someone, and then those people came back and killed none. And that is, and the relevance of that is it's not for the truth of the matter asserted. I don't think anyone in this courtroom, at least on this side of the room, is going to get up in closing and argue that the real killers of Donovan Thomas were, I'm hearing the name Nick, and maybe I'm following the story correctly or not, that Nick, after being robbed by Kel and Kay, came back for revenge and killed Donovan Thomas. We're not arguing that that's true. What we're saying is simply that, according to state's theory, Mr. Copeland had inside information on January 10th, 2015, and about our clients committing a crime, and then he's asked about it on January 28th, and not only does he not, it's one thing not to mention our clients, which is important, but it's a whole nother thing to put a different theory out there. And so we think that's very relevant, and that goes to his credibility. And I understand he's arguing to everyone that he has no credibility, but the state is arguing that there is credibility with his June 10th, 2015 statement, and we're saying there's no credibility to that either.
No, that's not saying right. I don't think the two are not mutually exclusive. He can know the truth, but proper rumors, but what those rumors are is they're not competent evidence. Like what he's saying, they can cross him without this coming in about the fact that he told the rumors. You told the police rumors in January. What those rumors are is not competent evidence because it's all speculation. It's all rumors. They can clearly ask him that on the stand without going into.
All right, and I assume that the only reason June 10th comes in anyway is.
I can't hear you,
because
Judge.
he takes the stand and says, I don't know anything about anything, I don't remember. Right, and so June 10th comes in as a prior inconsistent statement.
Yes, Your Honor.
Because
Prior to everything, his response is everything in June 10th, again, the whole finessing, and then he's now changing the version of facts as to what happened back in January 2015. He's now changed some of those facts. I don't know what he will do when he comes back, but that's what he can do.
Yeah, we can't hear.
If the state can stand up and go, all right, here's your prior inconsistent statement where you said X, Y, and Z, which was all these people over here on this side of the room killed them. Then they want to be able to say, well, look, in January you said something different. Explain that. Why shouldn't they get to do that?
Somebody in the back had to hold a sign.
Ask him about in January. You said it was all rumors. You said that. You said that there were rumors.
To turn her mic on.
What those rumors are, I don't think it's relevant. They can definitely ask him now whether or not he says I never gave anyone a rumor. Then maybe that might open the door for something else. But for the state to play it initially, if we even get to play the statement, all these rumors coming in, I think there would have to be some foundation about the substance of the rumors if they come in. But they can ask him simply on the stand. You told rumors, and if he says yes, then that's it. What the rumors are will be irrelevant.
We've all been doing this long enough to know that one of the things that makes stories ring true sometimes is the inclusion of detail. It'd be one thing if he just said, John, I heard John killed Donovan Thomas, but he didn't do that. In the story he gave, he gives details. He gives a story, a coherent story, and that matters. It's not just that he gave rumors; he gave a coherent, detailed theory. And the state, I'm sure, at some point is going to argue to this jury that, oh, well, he was telling the truth on June 10th because look at the details he gave. Why would he how would he ever come up with this story that it was these specific 4 gentlemen in the car? How would he ever, and we're seeing on January 28th, he is giving a detailed story with individuals and a motive and all the rest. And so I don't think that it does. I think something is lost if we were limited to just say, oh, well, you talked about rumors on January 28th. That really doesn't do it justice. We should be able to get into exactly what he said. And again, we're not going to argue that that's the truth. We're just going to argue that it's Mr. Copeland's ability to think on the fly and come up with detailed stories. And when he was given an opportunity to explain what happened, he came with a detailed story that had nothing to do with our clients. We think that's fair game.
Well, I mean, you can certainly ask him about it. You can ask him in as much detail as possible as you want to. And I think it's gonna depend what he says there.
Okay.
Oh, me, yeah, sorry.
So maybe
They finally tell her about a mic.
If you're saying, I'm not presuming that he's going to deny saying this. So yes, if we ask him on the stand and on cross-examination, leading questions, and he confirms that on January 28th, he told about
This
all that
story
stuff,
about,
then
right.
I can see that we wouldn't
That's it.
necessarily
Yeah.
get to play.
Okay.
But I think, as I understand it, the state's saying that we don't even get to go there.
Oh, no, they're not saying that. You agree they can cross him as much as they want to on, hey, this was your theory or rumor or whatever that you told the police on January 28th. They can ask him about that, right? I mean, you agree to that.
He said, this is what I told the police?
Can they say, do you have a dispute with them being able to cross Mr. Copeland and say, well, on January 28th, when you were talking to the police, you told them that you heard from the street that Kay and whomever robbed so-and-so, and it was those people that then killed Nutt.
And a judge calling him more.
So the state's concern is, even in the interview, he doesn't say it as fact. He doesn't say, this is what happened.
Well, sure.
He said, this is what I heard.
Yeah.
So to me, it's still speculative as to what he heard on the shoot. Whatever the rumor was, to me, is still speculation. I think an inquiry could be, you didn't tell them on January 28th that Shannon, Stillwell, these people did. You only proffered rumors, not the.
But they can, so you think they can ask, you told rumors, but they can't ask, what is the rumor you told them?
Correct.
That is not correct. You can, in fact, ask them about the detail of the rumor that he told them. As long as, I mean, obviously he is clearly saying this is a rumor I heard on the street. And I know your point's gonna be, well, that's an awfully detailed rumor. And you could argue that later. But yes, you can get into the detail of, didn't you tell them you heard X and Y and Z? And then if he says, yeah, I lied about that too, then that's the end of it. If he says, no, man, I never said a thing like that in my life, then we may be able to actually play that part.
Just play the tape. Jury ain't even understand it.
No, it is. I mean, he says it is. He says, this is what my girlfriend told me she heard from somebody else. It's clearly a rumor. That is not their point. Their point is, you, at some earlier point, are telling the police some theory, albeit rumor, albeit street talk, that is some details. And I think they're going to argue whatever they're going to argue, but they can get into the substance of what that rumor is. They can't mislead that this is what you said as fact. It has to be still, this was the rumor you told them, but they can get into the detail. Mr. Steele.
Right, I think what you just said is what I want to ensure that we're.
Yes.
So
Okay.
I think we're good. And Your Honor,
He's just saying I'm standing up because I wanted to make sure that you already just explained what I was going to ask about.
But the one position is, you know, you may know this, but Mr. Copeland didn't say, like, I never said anything. What he actually said was,
I said all of I don't remember exactly what I said, but everything I said was a lie, right?
exactly.
Yeah.
Because the police were making me the number one target. They told me I'm the subject of this murder, and I wanted to push everything I could away from me and onto others.
Mm-hmm.
So that's why it's very important to show that he's just coming up with, you know, Mr. Lamar is Rich Homie Kwan. He put a hit on another person to kill them. Ask Mr. Copeland. He has 17 people that he says put hits on other people.
Okay.
That's outside of people here.
Okay.
But what you said is exactly right. It doesn't matter. I'm not using it for truth. I'm using it for exactly what he's saying. That's what I was doing.
Okay.
And at trial, he said, and that's what I did for the people here on trial.
Okay.
Thank you.
Help him off, Steve.
All right. What's our next portion of this transcript at issue?
And I want to thank you to whoever sent me a cash out.
The next part that's.
I don't want to say your real name, but thank you for the cash out for sending. That was kind of you.
At issue potentially is page 203, line 11 through page 206, line 17.
Okay.
And more specifically, page 206, line 15. To line 17. And Mr. Shar, are you okay with 82131 through 82137?
So that's 206, 15, and 17.
Yeah, that was going to be page 203, line 1 through 16.
Your Honor, could I just ask that 15 seconds or whatever that is potentially in dispute be played? Because I don't think I have an objection, but
Okay.
I can't really tell.
Okay.
Let's hear it.
Sure.
And Your Honor, I'll play with 82131 to the whole section.
Okay.
One time, me and G not together. Me and G together don't matter what. Just like GP. We was together. You know what I'm saying? We not doing that.
Who killed DB?
They don't even, man. They don't
Who you
even.
think?
I don't know. Trey. They don't even, man. They don't
Who you think?
I think you started right after.
I can't understand Woody or the cops or the laws. What are they even talking about?
Man, besides Shannon and G, you ain't gonna see me hang with nobody.
So is it a question?
No, that's what I say. How the hell I be seeing y'all all the time? Everybody out to me. Like, it's not one time.
I'm fine the state wanted to play that, and I don't have any problem.
Okay.
So right after that, we're in agreement from, I believe, 8/21/37 to 8/22/52, where the murder of a gentleman by the name of DB is discussed. I believe that we agree that that is coming out.
Okay.
And then if Ms. Hylton could just play the 7 seconds that on the other end of that she wants to include, I just want to make sure.
All right. So this is going to be somewhere on 206.
Yes.
Okay.
Somewhere, or starting at line 5 or line 6.
Okay.
He said, I thought it was just me. Bro, I was like, play the tape. Jury ain't gonna understand none of it. Just play it. And even if they do, Woody gonna say he was lying.
It's gonna start a little early at 8:22:02.
Okay.
He just showed up. He did kill me. Him in his car. I know, but just like you said, somebody that might put him on the team. Yeah, that's all we can prove. Say, just like the little nigga, Lil Haiti. When he just got out of jail, he see me in the club. He walked right up on me. I'm murdering me. Yeah. Who? Little nigga, Lil Haiti. You know, who's supposed to have something to do with GB. Oh, okay. But that nigga walked up on me, well, nigga, who the hell is you? Yeah. I ain't know him. Yeah. What's up? Best friend, what's up? Why you looking at me like that? Yeah. And me by himself, like, I know that's my little brother, Lil Haiti, he just got out. So I'm like he booked, like, nigga, shit up. Nigga, like, what's up?
Hey, Lil Haiti, the one that got shot in the bay?
Yeah.
On Boulevard, right?
Yeah.
He out too?
They him. Like, I don't. So they don't corner that video on his page. All them walking in the house. Saying that he shot my grandmama's house. I know them, all the niggas they did. You know what I'm saying? They pulled up into a house in 3 cars.
So you mean, after this, so it's Rich Homie and Thug beefing?
Nope. How is that not possible? Everybody try to say, I feel like
he played both sides.
Nah, I feel like everybody like I feel like when he needs. Nah, I feel like they came together and made an agreement to kill me and everything go away. I feel like it, but I'm not gonna run.
We're past it. I heard that portion we can keep out.
All right. So what is the portion that is at issue?
No, nothing right now. Now that.
All righty. I'm glad we all did that.
8/22/59 is where we're gonna go back live on the state. This play.
So the full redaction 8/21/37 through 8/22/59. Sorry, the full redaction will be 8/21/37 through 8/22/59. And that's going to be page 203, line 19 through page 206, line 17.
Okay.
We have a series of agreements, Your Honor, and I think there's only one more that we disagree. Is that correct? And it's all apartments.
Okay. Where's that one?
Page 269, line 19 through page 270, line 14.
All right. And is this the part that the state wants in, defense wants out, or the other way around?
Right, if I can do one more time, this might not be.
We both agree that a certain part of this comes out. There's a portion of it where Mr. Copeland somehow talks about a rumor that Donovan Thomas in his dying breath said that Doug was responsible.
Okay.
A, that's not true, but B, that's hearsay. People that were next to Donovan Thomas said that's not true. So, but it's hearsay nonetheless. But I believe that the state wants to not take out a certain segment of this. And that was our disagreement.
We are fine taking out that part.
That part being,
Sorry, what Mr. Sharp just mentioned, that Thug did.
okay.
That part we will keep out. We didn't know if the defense has other objections to, and I'm sorry, Your Honor, we're on page 270, line 7. It actually says, he said Thug as has something to do with it. It's unintelligible, but that is the line that we're referencing.
Okay, so y'all are by agreement taking that out.
So, but I guess at the bottom of 269, we have it written down as 269, 19, 270, 14. Is that correct?
That's what I wrote down, but what y'all might have an objection to, I don't know.
Well,
So (269:19 through 23), where he's saying some detail about what he heard about not getting shot. Is there any dispute about whether that is in or out? I mean, I don't know, y'all.
I agree that is out. My understanding was the state viewed that those timestamps were too large and that something within that time period can get in, but
Okay.
maybe not.
All right, Ms. Hylton, was that something y'all intend to put in?
Initially, yes, but Your Honor,
How about now?
we will not put it in.
All right, so then 269 line 19 all the way through 270 line 9 is, I'm sorry, 9 or 14 is out by agreement. Which one was it? The end, 9 or 14? No. Okay.
So, page 270, line 9.
Line 9. Okay. Yeah. She is out by agreement. All right. So was that the last thing?
Yes.
Okay.
And Your Honor, our agreements for redactions, I guess they'll just, when we email them, they'll be made part of the record that way.
When you email them to whom? What I'd like y'all to do, I mean, for this, we actually, anything we didn't discuss that y'all have an agreement as to, like all of Mr. Adams' stuff, just make a little list and say, the state and the defense agree that XYZ is out. Okay?
Here, I already compiled it from the first time.
Super, just get together with your colleagues on the other side and make sure they agree and get it filed. Okay, so that's that statement. That's the January 28th statement is taken care of. And y'all are gonna, on January 11th and February 20th, figure out the couple of little things that might be in dispute and then bring those to me. And I doubt if y'all got a chance to do that already. So it seems like then the next statement is June 10th, right?
You wouldn't do that, that's what we did this morning.
That was,
You started with June 10th.
We'll go in reverse.
You went in reverse.
all right, okay, you're right. So if we done,
We've done all the 3 that we can do.
and, okay, and then the other 2, y'all are just gonna figure out what the small little differences are. Okay, so then I think the next thing we have to sort out is with regard to the testimony of Mr. Copeland that occurred post recusal motion, I don't know how many days of transcript of that y'all have yet. I think you have at least 2 or 3 days worth of that, but maybe not all of it from Ms. Weaver, Judge Glanville's court reporter. Some directly from her, some through Ms. Firstfield. Because, right? Have y'all discussed that at all yet?
So Mr. Shard and I discussed briefly that the defense needed to talk amongst themselves.
Okay.
And then they were going to come.
All right. Okay. So over the weekend, y'all figure out both amongst yourselves and then between the defense and the state, if there is anything, and if there is, what of Mr. Copeland's post recusal motion testimony there might be some agreement to. And then also, if y'all can think and propose to me on Monday, whatever y'all think might be appropriate in terms of explaining to the jury if they're going to have to sort of rehear any part of Mr. Copeland's testimony. You know, just what we're going to tell them about that. Okay. And then after Mr. Copeland testifies, what's next? And how long do y'all anticipate that taking? Y'all have no idea, do you? Because who knows what he's going to do.
That part is true. Does the court mean like which witnesses?
Yeah.
Okay, so I anticipate there will be 2 other potentially Mr. Sledge, Mr. Zachary.
Okay.
Those 2.
This is what you gave me. That's basically an order, right?
Yes.
Okay.
Yes.
So then, Mr. Sledge and Mr. Zachary, are there anything about their evidence that we need to hash out? And I can't remember, what did I give you as your deadline to give us all the details about the evidence?
You said the exhibits was Wednesday, but then the witnesses was Monday, and
I thought the first 30 might have been Monday.
the first 30 yeah.
Okay.
Monday.
All right. Okay. So I honestly did not think we would. I am really glad that we did. Congratulations to everybody. Get through as much as we got through today. But given the last couple of days, I'm pleasantly surprised that we did. So I actually, at this point, told the jury, don't come before Wednesday, because I figured we had enough work to do Monday and Tuesday. And I think that probably is true. But yeah, with everything that you're, and if y'all get finished early, you know, you don't have to wait till Monday morning. You can go ahead and email whatever you get finished with as you're finishing it. All right. So yeah, we can start working on all of that. All right. So this is a good time to adjourn for the day, or do we have other things we want or need to take up right now?
There may be one more thing that we can take up if the court would allow us one more.
Love, let's go home. She like to play, don't
You're right,
she?
we do have the 5 jail calls that we intend to get in through Mr.
Perfect.
Copeland.
Yeah, we can do that.
Let's listen to them.
Okay.
I do want to hear the jail
And I've already
part.
listened to the portions of.
And there were portions that we did not object to, Your Honor, so I can go through.
Yep, I heard that Wednesday. She already told them they have Monday,
By
Tuesday
call,
off.
which one we didn't object to.
So there's no sense in They already made plans Monday and Tuesday. No sense in trying to call them now. So real court not to win.
So you're working off of, so I know that Mr. Shart had provided kind of June 19th-ish, his proposed redactions, right? Is that what you're working from to tell me which ones you agree to?
Yes, is
Okay.
that what Mr. Steele sent? No, for the jail calls, I'm looking at Wednesday, June 26th. There was an email that Mr. Steele sent.
I don't know that I have that.
Okay.
What I've got is it may be the same list. Oh, it may be. I don't know. What I have is whatever Judge Glanville had made a court's exhibit when y'all were talking about them. And it says forward Stillwell proposed redactions. Anyway, it's a list of like 10 proposed redactions. Is that the same thing when we get down to it, or?
No, I have.
Well, give me what it is that I need to be looking at.
I can find it for you.
You know what I'm looking at right now is not even about the jail calls. So never mind. But I don't have what it is that you're talking about. I'm looking. So there are 5 jail calls and there are portions of the 5, is that right?
Yes.
Okay. And then you have agreement as to certain portions of those? Okay.
Yes, so the
All
state's
right.
intention was to play the entirety of the calls, but
All right.
then there were some objections, and so
Sure.
we don't have any objections.
Okay.
So we don't have objections.
All right, so do you want to put on the record what portions?
As if the court has the email, I can go through the areas where there was objection. And
I don't have the email. I do have the email. I just don't know where to find the email. Okay. All right. All right. I am now looking at the email. So go ahead.
So for the first call, which is on March 11th, 2015, there's an objection from 10 minutes and 45 seconds to the call to 10:50. And the state has no objection to not playing that portion of the call.
Okay.
from 15:15 to 15:32. The state has no objection to stopping, to not playing that portion of the call.
I didn't know you were still here, Ken Goddess. Thank you again this morning for the
June 10th call, from
$100
7
cash.
minutes to 7 minutes and 3 seconds. We have no objection to not playing that portion.
Okay.
From 8 minutes to 8 minutes and 12 seconds, we don't have an objection. And from
Okay.
9 minutes and 57 seconds to 10:15, we do not have an objection.
Okay.
For the June 13th call, we do object to that portion of 2:55 to 3:10.
Okay.
June 14th, we have no objection from 13:51 to 13:58. No objection from 14:11 to 14:13. And then for the June 15th call, we have objections to 4:53 to 5:11.
As in y'all want that in?
Yes. You're
Okay.
right. 6:01 to 6:12, we object. We want that part in.
Right.
6:42 to 6:49, we want that in.
Okay.
But I don't know if someone told me this, but I wrote in 13:10 to 13:17.
Come on.
And we don't have an objection to that part. I'm not sure if maybe someone called me, but I wrote in another portion of that call, and we do not object to. Oh, that's on the email as well? Okay. I wrote it. I have it handwritten.
Okay.
So, because it's on the back side.
All right.
So we have no objection to 13:10 to 13:17.
Okay, great. All right. So then our issues are with June 13th, 2:55 to 3:10. And then June 15th, 4:53 to 5:11, 6:01 to 6:12, and 6:42 to 6:49. Is that correct?
Yes, Your Honor. And so we're pulling those two calls up now, Your Honor.
Okay.
Weinstein ready to go. He holding his head over there. Yeah, Weinstein ready. It's been a long day. He's ready to get his weekend started. Well, I thought he was asleep. He probably was, TT.
As Mr. Box is here and Mr. Steele is handling this portion, may I step out?
Sure.
This is a free call from.
Uh-oh, got a jail call.
And I'm going to start, Your Honor, around 2:25.
Let's go. Let's go.
You booked the Brian. Meet me on University. On University well. That gas station we always, you know what that gas station Chevron. That's Chevron. Meet me at Chevron.
Hey, Matt.
Okay. Yeah.
Look, you ain't right, bro.
What did D do?
I'm gonna say too much, bro.
The D told. What's that? You talking about rock crew, Lil D?
Yeah.
I told him. He told on Roscoe too. You think I'm fucking playing, bro? He told on Roscoe. He told on Roscoe just cause he Roscoe ain't no fucking blood. And he don't give a fuck. Roscoe ain't free. Hey, D-Sean, I'm finna come meet you.
And that concludes at 3:11, Your Honor.
Oh, wow.
And to give some context,
Please.
on this call, this is a call from June 13, 2015, which is 3 days after that June 10th interview. Mr. Copeland is now in custody. He calls his girlfriend, Miss Quarterman, who then calls the person who you hear is Max, but it's also Dolly White, also known as Dolly White, but is Mr. Williams' sister.
Mm-hmm.
She is a person that the state alleges a number of the gang members will call to get in contact with Mr. Williams or for her to facilitate a number of different things throughout the trial.
Mm-hmm.
And while on the phone, there's first talking about money to help with his bond. That's
Mhm.
when you hear her talking about meeting the girlfriend at the gas station.
Right.
Then he says, little D ain't right. At that point, they jump to, because he snitched, because he told on Roscoe, and they're talking about him not doing what a gang member is supposed to do, which is then snitching, Your Honor. So we believe that that is relevant information for this jury to hear, that the gang members are talking about the failure of another gang member to be supportive of the gang, to actually tell or snitch on another gang member. And that's what's contained in that portion.
That's too much hearsay, though.
And the objection.
Too many levels removed.
Your Honor.
Yeah, that's
It's not, I don't know. I've listened to these so many times. I don't know if it's fair to you, but he never said about, oh, this is what gang members should act like. This isn't appropriate for a gang member to snitch on someone. That's not in there. What he said is something to the effect, I'm not quoting it, hear what little D did.
Yeah, it's a lot of hearsay.
Yeah, and then she says, D ain't right, D done told, blah, blah, blah.
Yeah, so how does he know that?
That's too far.
Well, I don't know that matters, because they're not offering it for the truth of whether D ain't right.
I don't know.
We are not offering whether D is or ain't right. It's the fact that literally it was everything they said about him, and overtly the fact that a YSL member, they believe, told if he did or didn't, and their anger towards it.
I don't see it like that. I see this is after Mr. Copeland. This is after Mr. Copeland has cooperated with the authorities. He is in contact with Detective Gaither on a daily basis.
Yeah.
And he is speaking now as a government agent.
Do you have proof of that? I mean, that's not an issue in this trial. This is him on the phone with his people, still thinking nobody knows he's said a word.
Of course, no one knows it. That's why he's an agent.
Yeah.
He is being told on June 10th, you need to work with us.
Jiggy.
Otherwise, you are going to get severe time. And he says, great, I will work with you.
Jiggy said he
That's the
informant.
recording that you listened to. You didn't listen to that part, but it's in this 9-hour recording. So I don't see how this comes in. It is
Okay.
I don't
hearsay that he is just saying, did you hear this other person? We have no idea the context. And it is being asked for the truth of the matter, because that's why they are talking about it. This is not, oh, it doesn't matter if it's true or not. He's specifically saying this man said something. I don't see how that comes in. You know, we could ask him about it, but I don't see how the jail call comes in. I think the state has to lay a predicate or a foundation before you think.
Well, I mean, I would assume they're going to have to lay some kind of foundation for some reason to get it in.
But not now.
And I don't know what that's going to be, but.
Not right now.
But assuming, I mean, I don't know, maybe you want to elaborate, Ms. Hylton.
We believe this is also evidence of the overarching gang conspiracy. Again, we have to prove that this is a conspiracy, that this is in furtherance of that conspiracy around. We believe that one YSL member telling another YSL member that one YSL member snitching is in furtherance of protecting the conspiracy, protecting the gang, Your Honor. And this would be evidence of that. So essentially it would be a co-conspirator statement between these co-conspirators talking about gang activities.
That's a stretch. Are they saying Young Thug's sister is an unindicted co-conspirator, or she just a witness?
I mean, I think if the proper foundation is laid, that comes in over a hearsay objection. Okay, and then, excuse me, June 15th, a couple of different portions.
I'll wait on it, Jiggy. You heard the judge ask Steele. She said, you got any evidence of that? And Steele didn't really say much. He said something about this on the tape you haven't heard yet.
Your Honor, of course, I would just start at 450 and play through 649 because it's only about 2 minutes for those 3 seconds.
I'm still sitting on the phone.
She explained what the tape.
And tell me who I'm about to hear.
Right. That's what I'm saying.
Yeah, Mr. Copeland calling his girlfriend on 3-way, but at this point he has asked his girlfriend to call Detective Gaither. And so the portion that you're hearing is Mr. Copeland and Detective Gaither on the phone.
Okay.
Thank you. That's what you need to do before you play a tape. Set it up so we can know what you playing. You just playing random tapes.
Gotta.
I'm gonna start at 4:40.
For everything. Like, I'm not gonna sit here and promise you like you're gonna get out of jail next week or in 2 weeks. All that, like I told you, you gave us a lot of good information, but we gotta still do our job. We're not just taking your word for the gospel just because it's coming from you. We still gotta investigate shit. So all of that will be taken into consideration at the end of the day.
So my brother,
like I said, do your brother know what?
That set up for the feds put touch him.
I'm not talking to nobody about your case, but to you and who you got on the phone. Yeah. That's up to y'all. Like we don't do that.
I'm saying, so is they trying to work with me though? Is they gonna try to work something out?
I can't say what they gonna do. Like I said, everything that you told us, we want to speak with you again. All of that will be taken into consideration. That's what she told what the ATF agent when we first came in, the lady.
Yeah.
That's what in the beginning. A lot of what you say will kind of determine your future. That's why you need to be completely honest with stuff.
Yeah.
So at the same time, we still got to look into it. We're not just going to take your word for everything you say. We got to be able to, prove what you say is true.
So if I prove it, then y'all let me have it right.
Are you hearing anything that I'm saying? Because I feel like I'm talking in circles.
Nah, I hear you, but it's confusing.
If you provide us with some things that we can verify, it's not up to us to let you out of jail. That's totally up to the DA's office, all that stuff on what they want to do with you. They do take into consideration if you helped or not. And so far, it appears as if you've helped, but we still have to do our job and investigate.
Yeah. So I still got state judge and
I conclude at 6:53.
Okay. And so what is at issue? What statements specifically are at issue?
Detective Gaither's statements bolstering so far. You've helped. We still have to corroborate, but so far this was helpful. I don't know what the right word is, and I believe that's bolstering his statements.
No, that could come in. That's Woody himself.
Right. And what does the state say to that?
Sure. Yeah, we don't know what he's going to say on the stand, but if he goes down the same line of, I was just lying to finesse investigation, I made it all up. This is in complete contradiction to that because she's telling him, just like she told him in the interview, we have to verify what you're telling us. So if he was telling lies, he wouldn't continue to say the same things over again because she keeps telling him, everything you told us, we appreciate you telling us, but we have to verify everything that you said. So there's nothing I can do for you until.
Well, he's not really saying anything over again. He's saying, hey, I told y'all something. Can you let me out now?
Right, and so when he's saying everything I said is a lie. So
he is now, yeah.
He is now. So what this shows is a contradiction because he wouldn't be calling the detective trying to continuously see if he can get out of jail if what he said was a lie.
Yes,
especially when she's telling him.
All right, the objection is that Detective Gaither's statements, you know, well, yeah, I mean, you seem to have helped us, but whatever. Why do you want any of this?
Well,
how do you envision using that particular thing I just heard?
So there's a few things. So part of this trial, some of the defenses that have come out is that the police didn't fully investigate anything.
Okay.
That they took his version and just ran with it.
Okay.
So this supports that that's not what happened. That even back in 2015.
Is Detective Gaither going to testify?
She has
All
testified.
right. Has she said already, man, we didn't just take his word for it, we investigated?
She testified
Yes.
to that.
Okay, so it's not necessary for that.
But again, I think it gives context to.
I mean, it's
not. Mr. Steele's focused on Detective Gaither. We're focusing on Kenneth's actions. That if he lied, he would not continue to call the police to verify how they're going to help him when he knows. Listening to Detective Gaither, every time she speaks to him, she says, "We can't do anything yet until we verify what you told us." So clearly, what you told the police isn't a lie. Even though you're saying that today in 2024, what you told them back in 2015, you believe to be true because you wouldn't keep calling if you just wanted to tell them one lie and that was it. You wouldn't keep calling the detective.
All right. So let me ask you this. If what you want that in, or those portions in for, is Mr. Copeland's, hey, y'all, come on, I gave you the truth. Let me out now. Is there some way that you could redact that where we don't hear big chunks of Detective Gaither saying something she's already said on the stand anyway, which is I got to verify this stuff? See what you can do, okay?
We can see what it is.
Okay.
All right. It don't hurt nothing.
We'll see.
I don't know.
Judge, if I may.
Yes.
Again, putting everything in context and thinking back to some of the testimony that Mr. Copeland had put forth previously.
You know, the state's position that he just put to the court as well. If he wasn't telling the truth, why would he call and try to follow up and see if they were checking on his truth or not? When he testified, one of the things that he said, it was probably the biggest thing that he said is, hey, they don't know that I'm lying. And he said, yeah, I lied to them. I'm trying to finesse my way out of this, but they don't know that I'm lying. And that was in response to a specific question that Madam Prosecutor, Ms. Hylton, asked Mr. Copeland. So I think that kind of, that goes against what they're saying as their rationale.
I mean, don't get me wrong. I'm not sure that what they're saying it's going to come in for is going to in any way show or be a convincing argument, but I mean, they can.
Yeah,
it's not inadmissible for them to try it.
Right. I understand.
Let it
but
come
I think
in.
our objection, as Mrs. Steele stated a little while ago, is, why is any of what the detectives bolstering of Mr.
I understand, which is why I told her if she can come up with a way to get her part in without the objectionable part, she needs to try to do that.
I'm confident that she can.
Even if they keep it out.
Okay, so that is all of the jail statements.
The detective will come in and testify to it in person.
All right, one thing I wanted to do is do some test run of this, and this doesn't need to be on the record, where I just don't have it. I've never used these before. So how is it that y'all are doing this?
Oh, so we're done for today,
Do
y'all.
I hand these out to all of y'all and then? All right, I don't need to, y'all have them, so.
We need the base.
Okay, and I mean, everybody doesn't have to do it. If a couple of people want
I think we're done. Oh, she got the suitcase.
That has no earthly idea. It's, it's plugged in right now. So I take one of these too. Is there some significance to the red ones?
You want one to try?
Hey, is there some significance to the red ones? Does anybody know whether there's some significance to the two that are red?
I don't think you've ever used this.
All right, so. And does the court reporter get one so she can also hear what's going on, I would imagine? Okay. And then what?
There's a push to talk.
He said,
Sorry, y'all.
Judge calling the Woody. She calling Glanville.
We're done with court.
No, we're not.
So you do not need to video me trying to figure out the technology.
We need some more images with you with the headset to your ear.
Something we need to put on the record.
Yeah, we can get the bench if you want.
Oh, they gotta put some on the record.
Hey, that's a brilliant idea because they don't take pitch comments. Sounds good to me. All right, then how do you turn what is this here?
All right, y'all. Looks like we're trying to. Oh, they took the link down. Come on, hold on now. Where did the link go? I guess they took it down. What I'll do is I'll drop the link if anybody had any comments they want to come up and they got a camera and of course a microphone. Because we can look at you all day long, but we ain't gonna know what you're saying. I'm gonna leave the link up to the court for a few more minutes just in case they put something else on the record. But this is insanity. We just heard a jail call. So supposedly somebody called Woody, or Woody called somebody from the jail phone, and then that person three-wayed the detective so they could figure out a way to get Woody out of jail. So that's all that was, which is wild, the detective talking on the jail phone. And it don't even sound like, Woody was just confident. He's like, okay, I need some proof, but he didn't know how to get the proof. I mean, I think so. He's still valuable to the defense. I mean, because he can still come to court and say, everything I said, I was trying to get out of jail. That's what I'm saying. Let the phone call in. The phone call would show he was willing to lie. He was on the phone with his family member, and they were trying to figure out a way for him to get out of jail. So they grasping at straws, trying to get him out of jail. So, I mean, let the tape come in. I think that'll really help the defense. It'll further prove that he was lying. Now, unless something happened to him on the street, like right now, and we don't have Woody to come back and say he was lying, then next thing you know, the jury might believe everything they hear on these calls. So I don't think it's a smart idea for anyone to even think about hurting Woody. Not because he's just valuable for the defense, but because have we not learned a lesson of what happens when you go around? Now, if they want to be locked up for life, for foolishness, they can try it. But I don't think that, nobody gonna try to hurt Woody. I don't think that's smart for a number of reasons. I mean, if we learn anything, do not commit crime in Fulton County. Because whether you did it or not, you're going to jail. And if you end up in Glanville court in the future, he gonna remember this. That man gonna have a memory of all of this. But Brian still, let me go back, but I believe Brian still called Woody an informant. But I think he used the word, he's like a government agent. So that's similar to an informant. Let's go back. Let's see if we can find Brian Steele when he was talking to the judge. Call that man a whole informant.
And that's what's contained in that portion of it.
Okay. And the objection.
Your Honor, it is not, I don't know, I've listened to these so many times, and I don't know if it's fair to you, but he never said about, oh, this is what gang members should act like, this isn't appropriate for a gang member to snitch on someone. That's not in there. What he said is, something to the effect, I'm not quoting it, hear what little D did.
Yeah, and then she says, D ain't right, D done told, blah, blah, blah.
Yeah, so how does he know that? Who did he hear it from?
Well, I don't know that that matters because they're not offering it for the truth of whether D ain't right.
I don't know.
We are not offering whether D is or ain't right. It's the fact that literally it was everything they said about him, and overtly the fact that a YSL member they believe told if he did or didn't, and their anger towards it.
I just don't see it like that. I see this. This is after Mr. Copeland. This is after Mr. Copeland has cooperated with the authorities. He is in contact with Detective Gaither on a daily basis.
Yeah.
And he is speaking now as a government agent.
And do you have proof of that? I mean, that.
In contact with Detective Gaither on a daily basis.
Yeah.
And he is speaking now as a government agent.
Oh, my bad. I was muted, y'all. So y'all hear Brian said that Woody is speaking now as a government agent. And then the judge asked Brian, do you have proof that Woody is a government agent? And Brian still said, I think he said he does have proof, but the judge hasn't heard it yet. So let's go back and let's see a few seconds. But Brian is calling Woody a government agent, aka a informant for the government. Let's go back. But the judge asked for proof, Jiggy, so we can't say it's fact yet.
Has cooperated with the authorities. He is in contact with Detective Gaither on a daily basis.
Yeah.
And he is speaking now as a government agent.
And do you have proof of that? I mean, that's not an issue in this trial. This is him on the phone with his people still thinking nobody knows he's said a word.
Of course, no one knows it. That's why he's an agent. He is being told on June 10th, you need to work with us. Otherwise, you are going to get severe time. And he says, great, I will work with you. That's in the recording that you listened to. You didn't listen to that part, but it's in this 9.
Well, okay, well, that's different because if he say, great, I will work with you, that means he's not an agent yet. If he said, I will work with you, not at the time of that recording.
Otherwise, you are going to get severe time. And he says, great, I will work with you. That's in the recording that you listened to. You didn't listen to that part, but it's in this 9-hour recording. So I don't see how this comes in. It is hearsay that he is just saying, did you hear with this other person? We have no idea the context. And it is being asked for the truth of the matter because that's why they are talking about it. This is not, oh, it doesn't matter if it's true or not. He's specifically saying this man said something. I don't see how that comes in. You know, we could ask him about it, but I don't see how the jail call comes in. I think the state has to lay a predicate or a foundation before you think it.
Well, I mean, I would assume they're going to have to lay some kind of foundation for some reason to get it in.
They lay a foundation.
And I don't know what that's going to be, but.
All right, so there we have that part. Let's see something. Somebody said they may be back on the record, so I want to make sure we don't miss anything. When the screen went black. All right, the screen went black right there. So anything after that. All right, I think they're going to go back on the record. Thank you, Kiki, for letting us know. And let's finish the rest.
This will be brief, but Your Honor, important to us and to the court. On February 7th, 2023, on April 18th, 2023, September 6th, 2023, January 13th, 2023, and one more, and then, which I don't have the date, July 29th, 2024. Mr. Williams has put in Brady motions.
Okay.
And the state has not complied with Brady. They comply at times. I'd like a date certain, like today, that any Brady evidence that is still outstanding, that it has to be to us by Monday or whenever you think, Wednesday, whenever, because Brady is, so serious, because then we go out and investigate, but the witness is already on the stand.
Right.
So I've, I know I don't have to put in writing. It's not good faith or bad faith. It's a prosecution team. But if the court can just set a deadline, and then obviously it's ongoing because new information may come forward. That's my only issue.
Okay. Is there anything that you, know of that you don't currently have?
No, because then I'm not so sure it'd be Brady.
It wouldn't be, but people refer to stuff as Brady, even though it comes out and you have it for the trial.
But anything, Mr. Zachary is a perfect example. I have no evidence of this. But if he's coming to testify, the state has alleged that he's a co-conspirator, unindicted. There has to be some sort of agreement. I mean, there just has to
I'm sorry, some sort of what?
There has to be an agreement.
Why?
An agreement. Oh, okay. Well, a lot of times there's not any agreement. There
Right.
might be.
But
I would
just use that as an example.
I would hope that the state knows that if you have an agreement with any witness about, you know what I mean, more lenient treatment, any kind of an agreement, that you need to reveal it. You know that, and you will do that. And you will do it as soon as you know it. If one does not currently exist, but one develops next Tuesday, then tell the defense next Tuesday.
We will.
Okay. And as to any Brady material, and understand your obligation is to everything you know right now that is material, potentially exculpatory, anything that could be covered under Brady, you need to provide to the defense if you have not already done so. And I'll let you make a statement if you would like to after I finish talking. And the Brady obligation is continuing. So if y'all are still doing any kind of investigation, you come up with anything that is Brady material, then you also need to get that immediately to the defense.
Yes, we understand that.
Okay.
obligation, And
All
we
right.
will continue to comply, and we will converse. And if there's anything that either team member is aware of that we need to provide, we'll provide.
Okay. Thank you.
No, somebody gonna converse.
All right. See y'all at 8:45 on Monday, 9 on Monday. Yes, Mr. Short. Let's say 9. Y'all did such a good job today. I'm going to give y'all 15 extra minutes to sleep. 9 o'clock on Monday. Yes, sir.
Your Honor, I just wanted to bring it to the court's attention that I know that Mr. Weinstein has an outstanding motion that he renewed maybe 48 hours ago.
Which was.
You might come about my mistrial?
Yes.
Oh, no, I know. He has a supplement to that. And I thought I said this morning, that's what I'm going to be working on this weekend.
And I have some bad news for you.
What's that? You
as
have
we
more
head
to
into
add?
the week- Yes, Mr. Weinstein's a faster writer than I am, but
He is a good writer.
He is.
Very kind of you.
So I recently filed a, while we were in
Loved
court,
it like
a
that.
motion, for a fair trial, seeking remedies. Oh, and I will email, it was just filed. And I will email it over. Mr. Steele brought up the desire to have an evidentiary hearing on these matters. I know that
Which matters?
the ex parte communications and the impropriety.
Yeah, like wanting to cross-examine yes, wanting
John
to
Melnick.
put Mr. Melnick's testimony. And yes, I had said that you could give me a proffer, and if you're ready to do that, we can do that.
Well,
y'all don't want to do just a proffer.
Mr. Steele was the, spoke to Mr. Melnick. Yeah.
Okay. All right. So with regard to the motion, Mr. Shart, that you filed within the last few hours, if you could email that to Ms. Persifield, I'll take a look at that over the weekend as well. Mr. Steele, if you want to be heard on I'm glad. Thanks for the reminder to circle back on that. I had said, talk to Mr. Melnick and you can put a proffer on the record. So if you're ready to do that, we can do that now.
I need more time because I did speak with Mr. Melnick. I told him what John McCord said. He stated that it was very nice. He stated that I was not getting for him. I'd like to address the report himself. Okay. That's what he told me. So I can't make a proffer because I don't have the information. I have him under subpoena, like I told
Okay.
him.
What do you have him under subpoena for? When?
2-hour call. 2-hour call.
Okay. Well, can you proffer to me? I know you can't say, here's what he would say, but how about tell me why it is that you think this is something relevant to this trial at this stage, considering that Judge Glanville has already been recused. And maybe y'all want me to, I have not finished reading all of the material and all of the case law. So I don't know what my decision is going to be on the supplemented motion for mistrial that Mr. Weinstein filed on behalf of Mr. Kendrick. Do y'all want, I will rule this weekend. Do you want to wait and see what that is?
That's denied.
Or do you want to just tell me why is it that anything Mr. Melnick might have to say in defense of himself matters for the trial? It might matter for everybody's, what they feel about their professional reputation. I get that. But for this trial, why does that matter?
So under CAR, C-A-R-R versus state, it's a 19, I think, 97 case, 98. It was the case that gentleman owned Pike's Nursery, I think, the house burned down.
Yeah.
There's great language in there about prosecutorial duties.
All right.
And it talks about that the prosecutors need to, they carry the burden. They can charge people. They can ruin people's lives just by the charge. And they have a duty to the public to be open and candid.
Sure.
So, and all lawyers do, but especially prosecutors. And Mr. Melnick, I know this because he did say this, and that's why he wants to address you, because he was not mad at me. He said he needs to have it on the record himself, because he said that what the state was saying is not.
Okay.
And I think that goes into your analysis of why there was a meeting in the first place. I don't think that it was appropriate, and I'm not picking anybody, but like the Honorable Judge Krause said, if I was going to ask this Honorable Court for an ex parte meeting, I believe that the way I always have it is there's a buffer. You have somebody say, what is it about?
Yeah.
I tell you, and I have to be candid. And if I'm not, in hindsight, you would probably, I assume, or any court would tell me, you had no right to do that because you got it with false pretense.
Okay.
Mr. Melnick is going to say that what Adriane Love said to the judge is just patently not true. The emails, her description of the emails is untrue. And there's no way to say that's inadvertent because she said that on Friday the 7th versus Monday the 10th, she kept talking about these emails and she changes her statement. So anyway, I believe that it's.
The best evidence of that would be, I'm sorry, I didn't mean to interrupt you, but just somebody give me the emails.
I did. I put it in my motion that I filed when I found out this honorable court was the court. And I forget what I titled, I can find out for you. But
Okay, I'll go back and look at those.
it was a motion, it had two parts to it. And it said, I really don't want, as I told you, I don't want a mistrial. I just want to make it right. And I want the record to be good. So anyway, Mr. Melnick is going to take to task, and you make a credibility determination. Adriane loved John Melnick's statements. He also adds that he states that he and his client, and he did not tell me, I said I don't want to know because it's attorney-client privilege, but he's going to work on it. He said, I assume that's a waiver. I'm assuming that with his client. He's saying that what Ms. Hylton said to the court and by both courts is not accurate also.
All right.
Then I have information that there's off, so it's not in the transcript. So Mr. Weaver's either not there or definitely not recording it, that Mr. Copeland did talk about the killing of Donovan Thomas, said it's not on the transcript. And that would be either Brady, if it's an inconsistency.
So wait, so that I understand what you mean. You are saying that you have reason to believe that in the June 10th ex parte meeting, once Mr. Copeland was a part of that he talked about the killing of Nutt at a time when Judge Glanville was in the room? Because there were definitely two different portions where at one point he and Ms. Bumpus talked privately, which obviously nobody recorded because the court, at least the record reflects the court reporter and the court and whomever left the chambers so that they could talk privately. So it's entirely possible he talked to her about that. That wouldn't be on the record and it shouldn't be on the record. Nobody else heard it. And then there was another portion where I believe the court left so that I don't know if it was you, Miss Hylton, or I think Miss Hylton, Miss Bumpus, and Mr. Copeland could talk together.
That's what I'm talking about. So it's not privileged.
Okay. All right.
There was substantive conversation about the killing of Mr. Copeland.
Okay. So
And Ms. Hylton,
hang on. I'm jotting some notes for myself. Give me just a second. All right, and you have reason to believe that whatever Mr. Copeland said at that point in time in front of the prosecution is something that is Brady material.
impeachment.
Impeachment. Okay, and therefore Brady. Okay.
So that's why I wanted to put.
All right, thank you.
And call the prosecutors. Now, they may say that didn't happen. And I assume that's what they're going to say because they would have a Brady obligation to run out and say, June, this happened, this man said this. But they didn't say that with anything. So I don't trust that the Brady was being complied. That's why I asked you again today, please, can you put some teeth into Brady? Because Mr. Copeland did say on the record, I'm a liar. That is Brady. That's like the greatest Brady.
Well, you got that, so.
But I got that because
I know, but you have it now, so it's not Brady, just like you just said.
my point is, it was hidden on the 10th. How about that? By Judge Glanville and the prosecutor. They knew about it because they were in the room when that was discussed. That's objectively true. So anyway, I'm just telling the court, I was not there. I don't want to make specious allegations against anyone. That's why I want to get it right. And that's why I asked you to have an evidentiary hearing.
Okay.
I believe that there's Brady evidence. I have a good faith belief. I'm telling you everything I know. I'm told that it's not privileged, that Miss Bumpus, Miss Hylton, Mr. Copeland spoke, and it's not in the transcript, and Mr. Copeland was talking about his information on the killing of Donovan Thomas. Because you have to remember, in the statements, he has himself not involved.
Mm-hmm.
He has himself learning about from another person.
Right.
And my understanding is that is not what he said. That's inconsistent on June 10th. And I did not get that from Ms. Hylton. If that's wrong, but I can't ignore what I'm being told.
Okay, well, that's new information for this court, so.
That's what I wanted to call the witnesses because.
All right, well, you didn't tell me that before.
Okay, well, I didn't mean not to tell you that. I'm trying to be open, but that's the reason I wanted to call the witnesses.
Okay, I mean, that's, okay.
Additionally, Your Honor,
Yes.
at some point, I believe, you're going to have to make a finding of fact on the propriety of these ex parte communications.
Oh, I know. That's a
And-
part of Mr.
Right.
Weinstein's motion for mistrial. Yeah.
And you know, I don't want to be a witness. I mean, I could say that there was absolutely no reason for it, and there was no cause for the state to even have these concerns. But Mr. Melnick can explain, you know, if he was conspiring with me and Mr. Steele to obstruct justice, I doubt he'd want to come in here and talk about it, but the state can ask him about it and get to the bottom of it. But I don't think that's what the testimony is going to be.
Okay,
And I think that's important for the court to know.
Okay, well, I don't know that whether it's true or not is what matters. It's what it looked like at the time to the state to give them a reason to say to Judge Glanville, we have some concerns. We might like to talk to you about it. Just heads up, we're going to do some research. We'll get back to you. And by the way, y'all, I know that everybody, whenever we were here last, was that yesterday or the day before? Wednesday. So Tuesday, I gave y'all the transcript from the 7th. And Wednesday, a couple of people made some statements about, oh my gosh, now lo and behold, we find out there's been yet another ex parte we never ever knew about. And actually, when you go back to the transcript of the June 7th, 2024 court proceedings, on page 95, on the record, before court adjourns for the day, is when the prosecution says, hey, by the way, we might need an ex parte, or we need an ex parte. And then it is definitely still on the record in court where y'all all heard not the content of the ex parte, but that the state wanted an ex parte because people from the defense say other things on the record after that. So in open court, y'all were notified that they wanted one. So, I mean, it's not quite the salacious revelation that y'all made it out to be. Yes.
So as in the King case that the state is relying on, the state has to make a showing of necessity for public, the necessity for the public interest for for immunity to be granted by the court.
Okay.
And I was under the impression, I think a very reasonable deduction was that they were simply going back there. And I agree, they did announce an open court and we didn't know the substance, but I think a fair, reasonable deduction would be that they were going back there to present the basis for granting immunity. Little did we know that they had already done that and they were going back there to have that other conversation. So that's
okay. Yeah, I mean, I know y'all didn't know the substance of it, but.
And wrapping back around to that.
Yeah.
I don't know if there was, but I'm assuming that under the King case, since it wasn't, I guess, that afternoon of the 7th, maybe it was prior to that, maybe it was in the morning, maybe it was the afternoon of the 6th, but at some point under King, there would have been some type of an ex parte meeting where the state presented the reason that they needed that immunity. I don't know if that was done on the record, if there was a transcript of that, but if there was, we have not received that either.
Well, there better not be anything else that
Well, how did they
occurred
get-
as a meeting, because I told everybody on Tuesday, stand up and tell me anything there is. Did y'all do anything beyond the motion to get the immunity order for Mr. Copeland?
No.
Okay.
So we submitted a motion.
Right. And they have a copy of that. And that's,
Right.
all right.
Right.
Okay.
That was,
Okay.
and Judge, I also state that at the time, I'm not certain why it would be believed that we were trying to get the warrant or the immunity agreement because Mr. Copeland was under arrest at the time that we stood up and made that announcement in court on the 7th. I think he had already been.
So what that
arrested,
mean?
I
Well,
think.
you could be arrested and not have immunity for your testimony.
Right.
The judge had already told him he had immunity on the record.
Okay. Well, I don't know. I mean, they're probably just trying to remember it themselves too, but. All right. Well, Mr. Shard, I'll take a look at your new motion. And obviously I'll be looking at Mr. Weinstein's motion. And why don't, Mr. Steele, you plan to have Mr. Melnick here at 9-ish. I don't know whether I will hear from him or not, but okay.
And Your Honor, so that we're, I'm understanding is on Monday, we're having the matter that Mr. Steele wants to present Mr. Melnick for.
Maybe.
Would that be a collateral issue of?
Maybe.
Okay. So
if I end up hearing from the two of you on that, I'm not gonna make you not be prosecutors in the case anymore. We can hear that separately if I even hear it.
And okay, and so would Mr. Steele be allowed to introduce extrinsic evidence of a collateral issue that he's raising about the emails and things of that nature?
I mean, the emails are already in the record. I think he's complaining that at one point, I mean, the emails are what they are. And at one point you said, this was an email to me. And at another point you maybe said, I accidentally got copied on this email, but I think it's actually different parts of the email. I think there's actually an explanation for why that might sound inconsistent, but I'll go back and look at all of the transcripts. But beyond that, I mean, no, I don't think so. I don't know what he's got planned. Maybe you want to ask him, but I don't know if he's talking to you yet. So I don't know. We'll take it up Monday. All right.
One last thing, Your Honor. On Tuesday, I believe I brought to the court's attention whether or not the court would allow
vacation.
If we get to Mr. Copeland next week. I know you said the jurors might not come back until Wednesday.
Right.
Substitution of counsel.
No.
Wanted to see if the court had made
vacation.
a decision ultimately. One
so,
objection.
Yeah, I never got any kind of written anything or further objection from anybody. So I think there's just the one objection that I didn't get a real good reason for. Okay, yes, there may be a substitution if we end up examining him while you were gone. Thank you, Mr. Weinstein.
So,
all right, we're actually in recess now.
Wow. So Weinstein withdrew his objection. I think Hylton want to go on vacation, and it was one objection saying that you can't switch prosecutors in the middle of a witness. But now it's going to really be a show come on Wednesday, because now we got to remember when the jury left, the last three people they saw when it came to the trial was Judge Glanville, Woody, and lawyer Hylton, the one that just spoke. Now when they come, it's going to be Judge Whitaker, a new judge, a new prosecutor, because Judge Hylton is going on vacation, and then we have obviously maybe even a new witness if Woody, if they skip him. I'm gonna drop the link if y'all have a mic and a camera and y'all want to come up and talk about it. Y'all want to come up and talk that law, come up. Well, yeah, this is a mess for sure. A big mess. I've never seen anything like it. Not even in personal trials, but just trials, other trials, national trials, other trials that stream. I've never seen nothing like it. Jiggy, where you at? And if y'all not subscribed, y'all free to hit that button. And if y'all are, just hit the like button. And if y'all mad because I'm talking about your judge, if you're in Fulton County and I'm talking about your judge, hit the dislike button. Oh my God. Let's see. Let's get that out the way. But the judge will deny anything that's going to stop her trial, anything that's going to stop her from getting her career off the ground. Yes, she's a good judge in Fulton County, but guess what? She want to go on a statewide stage. Maybe one day she want to be attorney general. Maybe she want to run for governor, House of Representatives, or the Senate. And she can say, you know what? On her resume, I presided over the longest trial in Georgia. When the chief judge can do it, they had called me. They called on Judge Whitaker to clean up this mess. I'm the one that did that. So anything that got to do with mistrial and all of that stuff, that's denied. I'm telling y'all now. She's not letting this trial go. She's not letting it go. Oh, let's go.
I guess they looking for me.
What's going on? Thank you for coming back up. Yeah, we looking for you, especially Jiggy.
Why y'all looking for me? Listen, did you catch the celebration after the judge told her that she was able to go on her vacation?
No, I didn't see it.
Go back and watch the last few seconds of it. She started celebrating with a little dance.
But my thing is, she didn't want Melanie to go on vacation. She talked about how can you go on vacation in the middle of a trial, and now she doing it.
I just want to know who gonna cross it or who gonna do the direct for him.
Right. Yeah.
That's gonna be funny, especially Wednesday. I'm mad I got a lot of stuff to do on Wednesday.
If you want to.
And he don't like Hylton as it is. I mean, let's be clear. They not friends, but they still got some type of rapport where he ain't gonna just be flat out, disrespectful with her. But they trying to bring somebody else in to go through all of these calls and videos, and he don't really know them like that. It's gonna definitely be some fireworks in the courtroom for sure. Let me go back and see.
You reminded her circle on the record. So if you're ready,
I want to see her celebration. And you said she did a dance at the end?
Yeah, look at her.
Attention, and I come to the court.
I think.
I wonder where she going. If it make her dance, maybe she running. All right, let me see. Is it? I think we got kicked out. Oh, there we go.
Yeah, I got kicked out. That quick motion.
Yeah, if they let Brown do it, it's gonna be something.
If they let BBL Brown go out there dancing, it's gonna be fun.
Not dancing. I think they ended the stream, so it's finalizing. Okay, there we go. Yeah, now it's finalized. I can go back and see it.
So I think there's just the one winning him while you were gone. Thank you, Mr. Weinstein. All right, we're actually in recess now.
Okay, so she did a little arm pump.
Yeah, she did a good little arm pump. Now, I ain't seeing on the screen.
Let me see. She did a little arm pump.
All right, we're actually in recess now.
She practiced. Let's see. Hylton.
You see the love?
Oh, okay.
It was exciting.
Look, quick one.
Now, I do believe that Love is nervous.
Yeah, Love hiding some as usual.
She doesn't want that proffer from Melnick. I don't know why.
Right, because she made a lot of assertions about Melnick in the second transcript. And now Melnick could come in there and say she a goddamn lie.
Right.
I didn't say none of that.
And that's what I'm waiting on. Monday.
And not only that, y'all heard Brian Steele say, or was it Weinstein, that there's another conversation that's not on the record with Caleb Bumpus, Woody, and Hylton, where it's alleged that Woody was talking about Nuts' murder. Did you hear that part?
Yeah, I did, but I wonder if Melnick told him that, then they're gonna probably have to call Kayla in too.
They may call Kayla in, and Kayla may, but somebody said Kayla said that's.
But that's why they have him under subpoena, remember? Still just said they had him under subpoena, and Kayla said that on her channel.
Right, but didn't Kayla say there's nothing missing? Or did she mean that specific transcript? But now we got to get those other conversations.
Yeah, she said it was nothing missing from that transcript. She didn't say that it was no other conversations that was had.
Oh, so that's that's the distinction. So now we need to find out either from Kayla or we're going to probably find out from Melanie if there was another conversation, which, obviously, because remember when it first leaked out, they were saying that Woody had confessed to murder. And we were trying to figure out how did everybody get it confused. Woody never confessed to murder in the transcript. But now we're hearing that it was another conversation that's not in the record. That between Kayla, Woody, and Hylton. If that's the case, where is that conversation at? We need that conversation.
Right. And did he actually say that he killed Nuts?
Did he say that? Right. We don't know if he said that.
I believe it's some substance to it. I don't think Steele will bring it up if he didn't know if it was some substance to it.
But remember on Kayla's stream, I think it was, I don't know if it was her first live, but I had came up after Woody had left on her live. But I believe somebody had asked the question to Woody, is this the rest of the transcript? And I believe he said no. Or something, he said something's still missing.
Yeah, he did, but she said she went back and cleared it up. Because remember, she said she wouldn't let him answer any questions regarding the transcript. He'll have to come back. They'll have to have a conversation. And he never came back online.
Jiggy want to know, what does Yantus mean? That was a word that was used in Weinstein's motion about Glanville and D.A. Love and D.A. Hylton. He called them
women, talking like women. Like cackling women, basically, is what that means.
Yeah. That's exactly what let me see if I can get the legal definition. And I'll share the screen so you can see.
I ain't no lawyer.
This is what he called a woman who is a gossip or a busybody. Yeah. She acts like a nosy yenta.
Like cackling women. So he basically called Judge Glanville a woman. I mean, let's be for real. That's what he did.
Regina ain't like that. If Regina's still in the chat, Regina said, "Now we don't need to do all the name calling." Regina does. Shout out to Regina W.
You trying to get me in trouble?
No, that's her own. Her own opinion can be different than ours and yours and mine.
Right.
Shout out to Tasha. How was your night out on the town?
I don't know. I can't call it. Ain't that what people say?
I can't call
That's
it.
what they can't call it.
I can't call it.
Well, how late you stay out?
I got here the next morning. I got home the next morning, but I was home.
The next morning.
Hey everybody, I'm not giving y'all my location.
All right.
Where I went. I don't know where I went at. I went to go see Jesus, y'all.
All right. Keep on playing.
I went to church.
Oh, you went to church? Okay.
Uh-huh.
And he said you keep that hush hush.
Slick.
What Tia say? Tia said the judge messy. She told Line Love to ask Steele. Then she laughed and said he's still not talking to you.
That was real messy. You see, that was horrible though. I'm not gonna lie to y'all. That was really horrible.
The judge, you're right. The judge, she shady as I don't know what.
She is. She be low key throwing them a lot of shade. I don't like that.
No. She
I don't
know
like
it.
That ain't nice.
Talking about, yeah, did you talk to her? Oh, yeah, I forgot y'all not talking. Yeah.
He didn't talk to you. You knew that people weren't talking.
Yeah, she knew it. She knew they weren't talking.
Listen, he told her yesterday he don't talk to her.
He don't talk to her.
And he pointed the little finger. I don't talk to her.
I'm glad he didn't, push that finger inside that woman's head. They would have been fighting in there.
Huh? Look, did one of these.
Right. He got too close to her. She would have got with him up in that courtroom. And then turn around and file charges on him.
Maybe.
But we're not going to advocate no violence. We're not going to advocate no physical violence. So thank you, Tia, for sending me the motion that was just filed. It was just filed hot off the press.
You can tell today they really weren't doing nothing, especially for him to be filing motions in court. He wasn't even paying attention.
The motion, like 21 pages. I'm like, wait a minute now.
Who? For who? Hold on, wait a minute. Let me go sit down. 21 pages for who?
For Matt Shard. Let me see if I can pull it up.
Matt Shard don't even know how to write 21 pages. I ain't seen a motion from him that long at all.
Hold on, let me see if I got it. If I can.
Now,
Matt, I hope it's some good, Matt. Don't have me read no.
Listen, so Slick say you looked over his comment when you called her judge.
No, I ain't calling no judge. What are you talking about?
That's what he said.
Let me see. Oh, did it not? Hold on. What? What's going on? Okay. Let's see if this one is. Man, it's a lot. But guess what? We ain't got to go through it all. We can just we can hit the talking points. Somebody said Steele wrote it, Max signed it.
He did. That's what it sounded like, because he definitely looked back at Steele for confirmation.
Like, hey, you got that motion I told you got it. You
got that motion you finished that motion for me? That's what it's giving. I'm not gonna lie.
Yeah, they spent the whole day wasting time.
I think it was a good day though today. The defense lost a lot, but they ain't lose too much.
She said, y'all be able to tell because, right? So let's kind of go through and see. So we see this was filed 8/2/2024. So that's today, 4/6 p.m. Eastern Standard Time. Superior Court, Fulton County, Georgia. And I'm oh yeah, she did it. Okay, There we go. I was like, what was that background noise? What is she doing? This is a renewed motion for a fair and constitutional trial. Inappropriate remedies for constitutional violations. So now he's not only saying I want a fair trial, but now he's asking for solutions. What you can do about it, Judge. She said Woody was singing.
He was singing that whole time.
With the mic, wait a minute, not singing with the mic. Hold on. Let me see something. All right. She said singing with the mic.
He kept saying, "Can you hear me? Can you hear me? Can you hear me?"
India, hold on, I have to go find a prop. Is this the kind of mic?
I know, dang on. First off, why was that mic so close to you? Because you didn't get up.
Actually, I did.
So Talk That Law is doing.
Oh my God, I'm gonna host the show. Yo, we got a. He said he was singing. Oh my God. Y'all know what? Oh, y'all funny. This the mic that Miss Hylton had. One day she didn't use the mic on the table. She had a handheld mic, like she was in church.
She was.
And she was walking around with her own microphone. Like, wait, what?
That's the outfit she had on. She had on a church outfit. You might as well say she was going to church.
Oh man. She said I had that mic in gold. Yeah, my legal assistant. Where did this mic come from? I think an arcade or something. Maybe I don't know. Is it Dave and Buster that had it? I don't know. But I had seen it on her desk. Hold on, not
So you went and got that microphone from her to portray this. I can't.
Hold on, I had to pull the camera down.
When they start coming for you?
Like you said, I would have to stand up.
Go ahead and stand up.
I said, let me pull this microphone down. This camera down. Oh, let's go through this, y'all. I know some of y'all.
Are you trying to divert from the conversation? Now, stand up.
Nah, I'm good.
They said stand up.
I'm
a mute.
No, you good. Comes now, Mr. Shannon Stillwell. So this is Max Sharp, client Shannon Stillwell, buying through his attorney, and he files his motion for a fair and constitutional trial. Now that's crazy when you have to file a motion for a fair trial. That's wild. She said she was talking back to the judge with that mic. That's wild. Let's keep going. Okay, so here we go. Background facts. Mr. Stillwell is accused of multiple felonies, including conspiracy to violate the RICO Act and other felonies, but he's an innocent man. Okay, that's giving Brian Steele. But we all know when Brian Steele, his first paragraph is Jeffrey Williams is an innocent man.
That's definitely Brian writing.
Yeah, that's Brian info right there. Number 2, like all citizens, Mr. Stillwell is guaranteed a fair trial and due process by the federal and state constitutions. This kind of goes without saying, confrontation clause, due process clause, all of that. The 6th and 14th Amendments that guarantee criminal defendants the right to a trial in front of a fair and impartial judge. Now, I believe when the 6th Amendment was wrote, it only applied to fair trials at the federal level. And when the 14th Amendment came in, it incorporated it to state trials. And I have to, it's been a while since I've been in school. So let's see. 14th Amendment fair. Let me look that up and make sure I got it right. Okay, yeah, so the 14th Amendment guarantees the right to a fair trial by prohibiting states. Yeah, so yeah, it just really extended it to the states. So let's go back to where we were. And the due process clause guarantees a defendant a trial free of prosecutorial misconduct. Y'all ain't gonna get that. That love, as long as that love in action, y'all ain't finna get all that. Y'all asking, love say y'all asking for too much. Now let's keep going. Number 3, Mr. Stillwell and his co-defendants have been in trial for approximately 19 months. That's insanity. Approximately 75 witnesses have testified so far, and Mr. Stillwell has remained in jail this whole time. Judge Ural Glanville was the original trial judge in this case, and he was kicked off by another judge, Judge Cross, on July 15, 2024.
Now you gotta read this like they wrote it, because I'm thinking that he put all of this stuff that I'm like, I know he did right, kicked off.
Well, he was recused. I mean, we can say
I thought he still wrote that, but I get you.
Yeah, Judge Glanville was recused from this case. Yeah, I'm just spicing it. There's a lot of legalese, mumbo jumbo. So I'm just breaking it down in everyday language. Recused, he was kicked off because he was no good. He was corrupt in the back room having secret meetings, and apparently he had more than one. He had multiple meetings. And from my understanding, we have more meetings that may come out. Lady Reese, I had to look at the words too. What are Mr. Stillwell's rights? The state of Georgia is seeking a life without parole sentence for Stillwell if he is wrongly convicted. So Mr. Stillwell, he got the most to lose. They're trying to lock him up life without parole. And Mr. Stillwell demands that his trial be conducted in a fair and constitutional manner. Prosecutorial misconduct implicates a criminal defendant's due process rights when it renders a trial unfair and violates the defendant's right to a fair trial. All right, y'all. We're going to work through this, y'all. I know it's Friday and y'all got stuff to do tonight. So I ain't going to just read word for word, but we're going to get the gist of it. We're going to get the meat and lead the bones. Due process also requires that Mr. Stillwell receives a fair trial in front of a fair judge, a fair court, a fair tribunal. In order to do that, you got to have judicial integrity. Is a state interest of the highest order because the power of the court to resolve disputes rest upon the respect accorded by citizens to a court's judgment. So pretty much the judge has to be fair. You can't have your own biases against defendants, and you definitely can't be working with the state. You can't have your own prerogatives. You got to be fair. You got to be neutral. You got to be a referee. But no, Judge Glanville, he took off his referee whistle and he said, you know what, I'm going to get in the game. Y'all losing. And you can tell because the state hasn't been the same since Glanville left. They lost the star of the show. Kimberly says only 2:30 in Vegas. We got hours. No, she got hours. It ain't 2:30 for everybody, Miss
I was about to
Kimberly.
say, speak for yourself, Kimberly, because it's 5 o'clock here, 5:36.
Right. And I could tell people got stuff to do. And let me stop real quick. If y'all haven't subscribed already, hit that button. All right, let's keep going. So we kind of know that. To the extent that this trial has failed to meet these constitutional requirements in the past, Mr. Stillwell demands that the court take appropriate actions. While Mr. Stillwell is confident that the court will endeavor to ensure him a fair trial moving forward from the current trial judge, this does not cure, this does not fix, this does not remedy the constitutional errors and the resulting harm to Mr. Stillwell that has already occurred in the past. He said, even though the new judge is going to be fair going forward, how are you going to fix what was already broke in the past? So let's keep going. So these are apparent examples of error. So he's going to point out stuff that's plainly an error. In his opinion, this case has been plagued by discovery violations. That's not a lie. Lost and missing police reports. That's not a lie. And Brady violations. Yeah, the police saying that the police reports are lost. They don't know where they're at. And sometimes they just flat out say we don't have them. But I know if you have them and they don't say what you want them to say, the DAs will try to hide them.
So if they found them, what would happen?
Well, that'll be a Brady violation because you didn't turn over what you had, and that could, get the trial throughout completely. So even if there's a guilty verdict and another prosecutor find this police report tucked away, and that police report has evidence that can free the defendants, or is favorable to the defendants, it helps them out, then that's a new trial.
Would it not be a dismissal though? Because they withheld that evidence and they clearly withheld it?
I mean, it'll be up to the courts. And, every jurisdiction is different. Now, the courts could say, states, since you withheld that, we're not going to give you a chance to retry it. But it just depends, because let's say you have a grieving family. Somebody was, murdered, killed. Should the family have to suffer because a rogue prosecutor hid some reports? So a lot of times they give the state a chance to try it again. But the only thing is the prosecutors hid that report for a reason. Because obviously if they hide it, it's showing some type of evidence that can show the defendants, not guilty. So, trying to take them to trial again, but this time the defense will have that report. The chances of them winning will likely be slim to none. So they may not even retry it, especially if the person already been in jail a long time. And I see that happens a lot of times when new DAs come in and they bring in their own team, and then they end up finding all the dirt that the old DA's office had hidden in the closet.
Oh, that's probably why they didn't want to get off this case.
A lot of them will start like conviction integrity units where they go back and review convicted cases that they have from previous administrations to see, if that person's guilty or not, or is there some evidence showing their innocence.
Do you think that's why Love and them don't want them to start? That's why she was so concerned today with that proffer, because she stood up and was like very concerned with what could come out of what Brian Steele is trying to do with Melnick. And I don't know why, but it's something up with it.
Yeah, I think so too. She want to know exactly what's going on. So they're gonna huddle up in a conference room. Maybe they got a war room, a big table to bring out the prosecutors in to see exactly what can Milnick say. And then they can go back through her reports to see what she told the court he said. So they could try to do some type of damage control. Thank you, 313, for stopping in. I know some of y'all got to go. I see the number dropping down low. But if y'all don't mind hitting the like button on the way out, appreciate you.
The number's low to the floor.
Oh, it's all right. I mean, hey, people come back and watch it later, so, you know. Now, court is on Monday. The next court date is Monday at 9 o'clock Eastern time, 8 o'clock Central time. All right, let's keep going. Let's see if we can just find some stuff that's good in here. So Matt Shard is saying the prosecutor of this case has, the prosecutor of this case have repeated, or maybe repeatedly failed to follow the orders of the court. They talked about the defense counsel like a dog, and that's me saying that. They say allegations. I know you might not be following along.
I got you now. I'm listening.
And have lacked candor to the court. This case has been plagued by improper rulings, constitutional violations, unconstitutional applications of OCGA rules. The defense counsel has routinely been cut off by the trial judge when arguing these matters. He don't want them to put their arguments on the record, so he cut them off. We've seen Glanville doing that. That's not nothing new. Let's keep on going.
Yeah. It sounds like he's telling the truth in his motion. Still did a good job.
You know,
still did a good job.
Counsel is solely concerned about his client, Mr. Stillwater, not himself. Nonetheless, the treatment of defense counsel in this case is evidence of Judge Glanville's lack of impartiality, which violates the rights of his client. He goes on to say, incident occurred in October of last year when Judge Glanville initiated a contempt hearing against Matt Shard. Wow, I must have missed that one. So he did a contempt hearing against Max.
When was this? I ain't see that.
October. Well, people weren't really paying attention. You know, the case didn't really get back high until on this day, Judge Glanville sent deputies to find Max at lunchtime and summoned him to his chambers. A courtroom deputy informed Max that Judge Glanville was expecting an apology for calling him some bull XXXX in open court. While in chambers, Max was advised that he should not deny the accusations as it was all captured on video. What a tape at? Where is the tape?
I gotta go find it.
When Max refused to apologize for something he did not do, Judge Glanville, tersely instructed counsel to leave his chamber. He said, "Get out. You're not going to apologize? Get out." Later in the day, Judge Glanville initiated a contempt hearing against Max. Judge Glanville berated Max and threatened incarceration. Judge Glanville accused Max of violating bar rules and putting his law license in jeopardy for lying to the court. Yeah, and not confessing his sins. Glanville, who the hell you think you are?
His sins.
Not confessing.
Oh my God. We gotta go find that video. That probably good.
He say Max gotta confess his sins like he
he is almighty
himself.
That's what it is. He definitely is almighty.
Now, and I know in the Catholic faith, I know they confess to a priest.
But I'm not confessing to no judge.
You sure better not, especially one that works with the prosecutors, right? Yeah, you better not.
Going straight to jail. Do not pass go. You're not collecting $200.
That's wild. Talking about that man trying to make a grown man apologize.
Oh, I mean, I guess that's why Matt's so mad. That makes sense, though.
In the end, Attorney David Box, who was seated within feet of Brian at the time, spoke up and stated that Max never made such a statement.
Oh.
Of course, the video that captured the event was never produced and no apology made. See, look. So Glanville then called his man to his office, accused him of cursing at him in court, wanted him to apologize and confess his sins, and said it's on video. And now, of course, when David Bott spoke up, you know, he's probably the most senior person in the courtroom.
What date was that? What date was this?
They said October 2nd, 2023.
Oh, we gotta go look that up because that's probably good.
Of course, the video that captured the event was never produced because they didn't have it.
Mm-hmm.
And no apology was made. See, that's one thing about Glanville that I don't like. People think we'd be hard on him, but he could have left it alone when he kicked Max out of his office. But what he did, he came out and initiated a contempt proceeding against Max. Somebody said he probably got PTSD from the war. He needs to go play with his damn dog.
Right? Because
and not with us in his courtroom. You're not with us.
But that's the second person he done did that to. They say he made one attorney write him a long
What's that song by Young Dog? He said, "Don't play with me."
That's what they need to start doing.
He telling who to go play with. Hey, hold on now.
Don't play with us. Look, say don't play without that law.
Yeah, that ain't gonna happen. So let's keep going. Judge Glanville has repeatedly demanded that certain defense counsel, see, he got his picks that who he don't like, include Max Bryan and Carrington Matthews, to sit down in a terse and abrupt manner when overruling valid objections, all in front of the jury. These incidents have been too numerous to document individually. It's so many of them. We can't even tell it. We can't even tell it all.
Brian wrote this. I ain't gonna even lie to you.
So they already been beefing. Judge Glanville has sustained all type of facts, not in evidence arguments from the state. So a lot of times when you are questioning a witness, the state can object and say facts not in evidence, and the judge blocks you from questioning that witness. But the thing is, it may be a fact not in evidence, but you're questioning the witness to find out. You're trying to find out the fact. You're trying to find out what the evidence is, the truth. But the judge is simply saying, no, you can't do it. It cut off the defense. And then he goes on, let's see what the footnote say. As defense counsel never uttered these words, undersigned counsel relying on his own memory as what exactly specific alleged other words were. The press was not filming that day. You don't got it, Tasha. The press was not filming that day, of course, and the transcript is not available to counsel at this time. Obviously, this was not an effective interrogation technique, as undersigned counsel knew he did not commit said act and would not be shown on courtroom video doing so. The reality is the court was demanding Max to lie to the court about falsely confessing something that he did not do. Yeah, the judge thought to come in there with some weak interrogation tactic. That's what Max said. It wasn't even effective. You know how they try to. We got you on video. That's how the police be lying to the suspects. We got you on video. You might as well go ahead and tell us.
That's what he did to Kaylin when he said the video. I went back and looked at the video.
Right. And my response is, well, if you got it on video, well, you don't need me telling you nothing. Mm-hmm. You got everything you need. So obviously, that's why it's important. You know, if you're interrogated by the police, just request a lawyer. Don't even respond to any question. Because they'll tell you, oh yeah, we got it all on tape. And then your friend, we picked him up. He in an interrogation room a few doors down.
Telling on you.
And he done told us everything, so he might as well just tell us.
And he ain't said nothing.
I ain't said nothing, man ain't be nowhere to be found.
Listen.
Mad Barber say it ain't the judge lying. He's saying Sharks be lying.
I mean, Shark do over exaggerate, but I don't think he lying about this. I don't think he would have put it in no document and been lying for real. I had to turn my camera on for that one because we ain't gonna play like the judge don't be lying.
But you know, to some people, the judge can do no wrong.
He can't, but he a liar. Him and lying love.
Jiggy said, I don't trust accounts with letters as a profile account. I believe I've seen Mad Barber come on before.
Jiggy,
in the comment section. You might pop in and out.
Give him grace. Jiggy said he don't trust nobody without a profile picture.
Oh, Miss Lavonna waving at her. She must know.
Oh, hey, all right now, Lavonna, where you know him from?
Yes. Okay, let's keep going. It was nothing else up there. Okay, just one example could be found by viewing Max attempts to effectively cross-examine investigator Tyrone Dennis. Judge Glanville on 2 different occasions basically called Brian Steele unprofessional, unprepared in front of the sitting jury.
He did. Now he did do that.
And then when it was shown that Judge Glanville was completely off base, he was lying. Judge Glanville refused a defense request to issue an instruction to the jurors that the jury should disregard his comments about Attorney Steele. That's why sometimes that's you got to correct people sometimes where they act up at. This like let's say a little kid acting up in the grocery store. Some mamas and daddies will whoop them right on the spot or pop them, or we ain't gonna wait till we get home with the same place you show all that, you get showed up at.
Man, I be hitting little kids that ain't even mine at the grocery store. I be like, be quiet. Like, oh Jesus.
So Brian Steele should have got the judge straight right there.
He tried to.
Yeah, I would have told you somebody in this course, a lot of people in this court were unprepared, but I could tell you it's not me. Judge would have cleared the courtroom.
Right, that's what I'm saying.
Go to the back, jury. No, it don't matter about no trouble. The judge ain't gonna do nothing. What are you gonna do? Hold him in
for 20 days.
That's fine. He go to jail, but guess what's gonna happen with the trial? The trial not gonna go forward because the client, Jeffrey Williams, ain't gonna have a lawyer. So
you heard him try and say that he can use Adams because he's being very effective counsel for him.
Right. And you remember what Adams told him? Adams said he won't do it.
Yeah, and Love went be calling.
So Adams' position is Adams only knows certain things about the case, but Brian still knows everything. Adams just helping. Now
crazy.
No, because I believe Adams started off representing somebody else, but that case settled. So that's when he joined the team of Young Thug. So I can imagine that he didn't learn all the facts about Young Thug's case because he wasn't his lawyer at the time. These past 19, months.
Look at you. That's the lawyer in you trying to make it okay. Get caught up. Ain't that what the judge say? She told him to get caught up. He need to get caught up.
Yeah.
But, so in that situation, would Thug be paying both of them, or would he just be only paying Brian Steele, and Brian Steele will be paying?
I mean, that could be, that they could have some worked out behind the scene. Yeah. Judge Glanville has monitored the movements of defense counsel throughout the courthouse through security cameras with no permissible purpose and without cause. I wouldn't be surprised if Glanville had his own monitor in the back.
He might, because he said he monitored the cameras after to find out who Kayla told. So I believe it.
He got his own. The state has repeatedly demanded reciprocal discovery from defense without any legal basis. Yeah, you can't do that because the defense don't have any obligation to present evidence or put on the case. It has repeatedly misstated the law covering reciprocal discovery, all to obtain an unfair advantage from Judge Glanville. And I don't know how this one didn't, underline red. Because sometimes it autocorrects, but it autocorrects the actual words. But he was writing this during court today. He didn't have time to go back and fix it.
I mean, still did some mistypes too in his last motion.
The state has gone. Yeah, that's true. And you still think it's still?
Mm-hmm.
Let me read some more.
Look at
Matt. The state has gone so far as to contact non-attorney members of the defense team, this Love, and demand that they provide certain items to the state without even talking to the lawyers first. And now I was shocked when they did that. When Love called the defense investigators asking for evidence without talking to the lawyers. Now that's wild. These actions were taken without any legal basis and was an attempt to unconstitutionally invade the attorney-client privilege. Yeah, that's wild. You can't do that. And the duty of confidentiality of the defense. Good thing they had a smart investigator. He hung up the phone and he told them, hey, Love trying to get me to send her something. The state intentionally and erroneously accused Attorney Steele of tampering with evidence and altering jail calls. Of course, these heavy accusations were entirely false and without merit. They lying. And guess what? There was no consequences for making these wild false claims. And then we know June 10th, Judge Glanville held an illegal secret meeting in the back room with what, Tasha? With what off? With the lights off.
Nah, I'm not condoning that because they're not gonna come back and say that I said they was doing anything inappropriate. The lights was on, y'all.
The lights were on.
The lights was off.
Well, this is all allegedly, but if they wouldn't have told the deputies to turn their body cameras off, we would know for sure. But the body cameras was off. So something was turned off. Tasha say, y'all not finna come for her and her channel.
Love say, turn off the lights.
And light a candle. Come on.
Tonight. Because she said she'll contact them on Saturday night now.
She said, hey Judge, I don't want to bother you Saturday night. That's what Love said. And I'm trying to figure out why she talking to the judge on Saturday night.
She talked to the judge every night, baby. Every night.
Do his wife know that Love calling him in the midnight hour?
In the midnight hour, God's gonna work it out. He was trying to work it out.
Because I'm trying to figure out what was so important that you had to call this man on his off day. I know somebody ain't gonna like that. I know somebody in the chat, man. But that's what she said in her motion. She said they got homework to do. Saying let's work it out. All right, let's keep going. Then Judge Glanville got mad at Brian Steele and tried to hold a contempt hearing against Brian Steele. See, so when y'all try to take it for Judge Glanville and say we've been too hard on him, look at all the stuff that he done did. And this is just a piece of what he's done. He didn't have other lawyers. He tried to embarrass them, had them writing essays. He didn't put a juror in jail. He did a lot of stuff. And I mean, I know he got that military mentality, but you're not in the military anymore. You can't just be ordering people around like that. Somebody said he was a weekend warrior.
Oh, nah, y'all, we ain't gonna do that.
Now, look, my best friend's military, and he lets me know all the time. He say, they respect the National Guard, but he said it ain't the same as somebody that's there full time. But But I'll let somebody else, if y'all want to speak to that, hit the link. I mean, but thank you for your service, Glanville. But we still gonna drag you.
Him and that dog.
We still gonna drag y'all.
Him and that dog.
Somebody say that. Why are you talking about? I go to work on the
Listen, I'm trying to
Right.
see if I can find that.
And we got to be careful with these deployments too, because in our mind we say, "Oh yeah, they got deployed, like they out there on the front lines, and they deployed in a bunker on a computer,
Right.
chilling, not doing anything." But I ain't knocking him. Hey, he did his service.
Someone be
somebody got to do it.
Someone be cakewalks.
Yeah. I know.
I know.
She said it ain't the same. My father served in There's a Storm.
It definitely ain't the same like it used to be.
That's like me going in for JAG as an attorney and get deployed to represent soldiers. And I'm in court. I'm just defending soldiers. And I know I was deployed now. I done been to war. Boy, you ain't been in no damn war. You just sat over there in the law library. Somebody ain't gonna like that. And that's okay. I still told him, man, thank you for his service. Whatever he did, he can't continue to do all of that now in a civilian courthouse. Over here, we got rules
and regulations.
You just can't bark orders and try to have your way in what you say go. And the only reason that he finally woke up and saw the light because his superiors came in, not his general above his head, because I believe he was a 1-star general in not a 5-star, 4-star general coming in over his head, or the president sitting him down. It was his civilian boss, the Supreme Court.
Right.
They said, Glanville, if you don't sit your down somewhere,
long head,
you're not running none in Fulton County with your mouth. We got the last say. Telling somebody to confess their sins.
Yeah. I don't know why I'm actively looking for this thing, but
for what?
I'm trying to see if I can find something for you.
Oh, okay, go ahead.
I feel like somebody done caught this October. It's too many people in this courthouse that somebody should have caught something that was said on that date.
Oh, okay. I got you. So yeah, that's what, this is why we go so hard on him, because all the wrong he has done. And this is just what we know about. We don't even know what he really been talking about. I want to see some text messages between him, Love, and Hylton.
What was the date of that that it was October what?
Oh, let me go back up. I believe it was the 2nd, but I'll go back up to check. Let me go back.
It was on the footnote, so
yeah, October 2nd.
Okay. I'm in September, so I think I might have some stuff.
Okay. So Judge Glanville briefly incarcerated Mr. Steele and attempted to sentence him to 20 days in jail. Judge Glanville deprived Attorney Steele of due process and the assistance of counsel. I believe Judge Glanville deprived Attorney Steele of due process. Well, if anything, he deprived Jeffrey Williams of due process and the assistance of counsel. Unless he's talking about Steele didn't have a lawyer at the time. Well, he couldn't have got a lawyer that fast. But his lawyers eventually showed up. But anyway, The defense, after repeated requests, has finally been provided with the state's June 7th, 2024 ex parte secret meeting, motion for order to compel testimony necessary to the public interest. This motion was submitted by the elected district attorney, Fonnie Willis, and what he's called them co-conspirators, Adriane Love, upon information and belief, is a glaring misrepresentation. What is this? In paragraph, 11 of this motion, the state asserts that after an encounter with defense team members, Copeland informed representatives of the district attorney's office that he may attempt to plead the fifth in order to avoid testifying against members of YSL. The motion does not provide any information regarding the specifics of this alleged encounter or which defense team members were allegedly involved. Upon information and belief, reaching out to defense counsel involved in the case, this information is completely false. So he's saying not only did Adriane lie, he said Fonnie Willis lied. But y'all know the apple don't what? Fall far from the tree. Road Dogg says she signed it. Yeah, Steele's wife, she's an attorney, but she's not representing him. She has nothing to do with this case. Call them out, Shar. Call them all liars. And Max goes on to say, no members of the defense team had any contact with Lil Woody on June 6th. And they never interacted with Woody in any way that would dissuade him from testifying. Nobody's trying to stop Lil Woody from testifying. This is a flat out lie. It's false and disparaging. And all this information was provided to the crooked judge Glanville in an ex parte motion. Well, let's see how many people click out because I call that man crooked. I ain't lying. If y'all say he not crooked, get on the camera, come explain y'all position. And he goes on to list some law. Judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. That's the rule. But what? Judge Glanville did it anyway. Not only did he do it anyway, he did it twice on June 7th and June 10th, as far as we know. So he may have more secret ex parte meetings out there that we haven't found out about. Because according to Brian Steele or Weinstein, one of them today said that there's another meeting that Caleb Bumpus and DA Hylton and Woody participated in. So I guess we need to ask Kayla if that's true or not. And you know what I've been saying I'm going to call her? I'm going to really call her. But I don't know if she's live or her. I don't know what she got.
You've been saying it all week. You need to call her. Look, put us on mute and call her.
Call her. No, I ain't going to put her on the spot like that. But I'm definitely going to reach out.
All right, put us on mute and text her.
Let's keep pushing through. In other hearings, both parties should be notified. Okay, yeah. So he lists some legalese, the case law of why ex parte meetings are inherently wrong. And he goes on to say that Rule 2.9 instructs judges to generally avert ex parte communications to ensure fair hearings. Stay away from them like the plague. Don't go near no ex parte communication. And I told this story before. In one of my trials, we were trying to subpoena a witness, a police officer. And
education, get my master's.
I'm gonna meet. Are you good? I'll meet you. And then while I was talking to the clerk, the judge just happened to walk by, and he was, trying to figure out where we are with the case, with the witness. Is he gonna come in? Yeah, if he was talking to the clerk and I wasn't there, that's one thing. But just to be fair and to keep down any confusion, I said, Judge, let's go walk over to the DA's office and to make sure he's involved in this conversation. It wasn't nothing important, but just to be, you don't want to be accused of having no ex parte about the case, and about a witness. And the DA was, him and the judge go way back. It wasn't a big deal, but just to make sure you're not breaking any rules on accident.
As Miss Willis say,
So,
that don't make you true.
Hold on.
Can you hear me? Kayla is live. I'm sorry, I thought I had muted it. Kayla is live with Jeff Daddy on the bad podcast that don't go in and out. Just FYI, if you want to watch it.
Okay, now is she on her own channel?
Nah, she's on that No Days Off radio channel doing an interview with Jeff Daddy.
No Days Off. Let me see. If it's a bigger channel, then I don't mind.
Looks like they got like 14,000 subscribers, so no. But I'm just giving you that information and everybody else just.
Well, let's see. I mean, I'm sure the 70 of us in here is not going to take food away from somebody with 14,000. So let's see. I don't see the channel name. So it's called No Days Off. Is it one word, 3 separate words? Do they have a
No? So No Days. Look, No Days is together and then Off Radio.
Okay. So No Days.
And then space Off Radio.
Off Radio. I still can't.
It's gonna come up with different, but I just sent you the link.
I see it, but we can't hear Kayla saying nothing.
She talking.
Yes, she talking, but could you hear her? I can't hear her.
I don't know. I got it muted right now, so I'm not listening.
I'm gonna share my screen, y'all. But I can't hear nothing that she's saying. I don't know if the microphone not working.
I can hear her now. I can hear her. So.
Well, y'all let me know if y'all can hear. I'm gonna mute us so we don't.
It's not complete. Well, in which Kayla was mentioned, and they pretty much had a discussion about her accusing her of some things that didn't happen. So that's what she's talking about.
And I want to say this to Fabs 40. I have been saying what you just said since day one of this case. I'm so glad that this case is being broadcasted on a daily basis because the people, and this is the reason why, because the people is now being able to see what type of system we dealing with here. They're able to see it now. You know what I'm saying? To where, we have a lot of people who will jump the gun and say, oh, they guilty, or they did that, or he did that, or she did that. Because you're not there. You're not there. And I speak on this to a lot of people now, which I have been speaking this for years. I mean, like 20, 30 years or better. Stop getting caught up in what people say so much. If you feel some kind of way about somebody, or you feel some kind of way about something you have heard, or you think you know, do your own investigation.
That part.
Do your own investigation. Don't just let what somebody say right now make you make a hasty decision and say what they saying is the gospel. Because, I raised my kids on, it's easy for somebody to pick you when they know you'll respond to anything. It's easy to do that. It's easy to do that. So what I want y'all, I can't say that enough. I can't say that enough to you all. When we stop letting society and what people in society think, say, and do make us act accordingly in a manner that we shouldn't, we'll be a better off people, man. We'll be a better off people. There is nothing somebody can tell me about somebody, and I'm just gonna take it as the gospel. I'm gonna do my own investigation. If I feel like it's worth it, if I feel like I need to investigate it, I'm gonna investigate it. I'm gonna check it out. You know what I'm saying? So, and what I'm speaking on now don't have nothing, ain't just about what's going on with this case, what's going on in any other fashion. What I'm speaking on now is life. Let's start living that. You understand? I'm saying in your relationships, in your datings, in whatever you consider yourself being a part of with another half, with whatever you decide to do in life. Let's start living that, man. Let's stop letting what we think people think about us make us act a certain way. When I was 14, 15 years old, it's two words in my vocabulary I kicked out of my vocabulary. And I'm telling you a true story when I say this, because I've been on my own since I was 13. Two words I had to get out of my vocabulary, and it made me the man I am today. Along with people who I have surrounded myself with that taught me more discipline. And those two words are ego and pride.
Oh, okay.
If we don't get that shit out of our lives, people, it's gonna sink us if it haven't already sunk some of us. Ego and pride is the two most definite words to me in life.
Did Kayla come back?
Everybody live off of that shit, and it's not good. It's not good. So that's why we get stuck in.
She was saying something earlier about Judge Glanville, but I mean, I don't watch it. I just wanted to let you know that they was live, just in case you wanted to look at it. This podcast.
That's why we feel like.
But Kayla just sat back down.
My child can't wear this because everybody gonna say this or that about them, or they gonna this or they gonna. Hey man, if you want my child, and my kids will tell you this. If you want my child to wear certain shit, buy it for them.
Come on.
Buy it for them. You do what you can to support your kids' needs. Fuck their wants.
Yeah.
They have to earn what they want. Make your kids earn what they want.
Let's see if we can get Kayla's portion.
I put out a
she challenge
a year ago. Well, almost a year.
Let's see if we can get her part.
To a lot of guys that I go to the barbershop with, and I hang out with.
Where is she that? Let's see.
And I would you say what she's doing, and what I mean by that is courtroom. Actually,
you gonna let her talk.
And in a way, a lot of I'm to build
you gotta let
you that that you heard him.
Wait, when did Kayla talk?
You can't.
She talked for a second.
I'm sure
Oh, that's true.
But see, look,
with me hugging someone.
I can't really hear her.
And I don't
I can hear.
understand why that was necessary. And then to say that I don't pass the smell.
Can you wait in the chat? Can y'all hear her, or is it just me?
Far, and then to come Monday and ask me to see pictures of my kids, and
because she don't sound as loud as him.
Throw Melnick under the bus, but you was throwing me under the bus too. So I'm just now I see why Glanville felt the way he felt about me. Yeah. Because she put it in his head.
Exactly. And what Kayla's referring to, you guys, she's referring to the newly released transcripts that uncovers the ex parte meeting. Or actually, according to Woody, it's not complete. and we don't expect it to be complete. So it's just what they put out to say this is the transcripts from the ex parte meeting. And then we also found out about another ex parte meeting this week as well, in which Kayla was mentioned, and they pretty much had a discussion about her accusing her of some things that didn't happen.
So this is Young Thug's dad.
And,
Yeah, that's his daddy.
I want to say this to
I don't know
Fabs.
who he is. We can get.
I have been saying
Okay.
what you
Okay.
yeah,
But yeah, I think we got
the gist of it. But basically, I heard her. She just said that she was upset about the July. I'm talking about the June 7th meeting, and they portrayed Love asked her the next day to see pictures of her kids, and she thought they was on a good page, and they wasn't, and she was trash talking them. It was nothing.
Wait a minute now.
How I can hear you couldn't? I don't know. Not that.
I'm still trying to figure why Miss LaVonda think I should be talking to Kayla every 5 days. We had the first interview. We had the second interview, Dear Woke Christian channel. We had the third interview on Kayla's channel. How many times you want me? How many times we to talk to Kayla? 3 times.
3 for 3.
How many times you want me to talk to her, Miss LaVonda?
Oh, they say she live on Nick channel right now. Jesus, Kayla just live hopping.
Right, I was saying how she moving that fast, Nick.
That's why she got up.
I mean, I just really want her to answer.
Oh, LaVonda, you got the link for LaVonda. She gonna come up here and child, LaVonda, are you gonna come up here and be nice?
Kayla then got in her car and took off. Kayla driving on that man channel.
You lying? Are you telling the truth?
No, I'm saying on Nick's channel, she's in her car.
Wild Spirit say she on the YouTube tour.
Hopefully she
is.
She drive well, I don't know. She's in a car. Let me not say she's driving.
Everybody on there. Steady Nash, Cat. Oh, that's what Jig went at. Jig went to clock in. Let me see. Hold on, wait. Let me see. Jig, is you in here yet?
Somebody said they'd rather hear me read this dry motion.
Yeah, then listen to that. I ain't gonna lie to that. Look at Steady.
Oh, yeah. Woo.
Face. Well, I'm so glad he got on that hood, that helmet on top of his head. Be nice. Be nice. You ever seen a live animal show?
You said a what?
A live animal show, like a circus. You ever seen one?
No.
We finna watch one on this other channel. I'll be back. I'm just joking. I'm just joking.
I'm not gonna play with you. Oh my goodness. Yeah. The only part that I'm trying to figure out is if Kayla can confirm whether it was another meeting or not, because they're saying there's another meeting. They said get down right now. Now they're trying to. No, you're all right. All right. All right, y'all. So I want to keep pushing through this a little bit longer. A little bit longer.
Hey, they finna speak on that part we're still talking about. That you want.
They are?
Yeah.
Okay. Oh. Let me know when they get to that part, Tasha, because I don't hear it yet. Because I'm only trying to get that portion. I don't want to be running up on nobody else's You know how some YouTubers are.
I'll put a thumbs up when they get close, okay?
Okay, good. I don't want to be recording no more than necessary. Mookie say, all right, y'all, my YouTube time is over. I'll holler at y'all. Appreciate it. Shout out to Mookie. Stay safe out there this weekend. What's going on? Get him, Joe. Get him, Joe, in the chat. All right. So we're just kind of going through this motion that was just filed.
Question: do you want to listen to Kayla's part only where she's talking, where they start talking, or you want to listen to when still, because they're like going through where
No, we already heard all the Steele stuff.
Okay, so I got
just Kay. We just need Kayla's response. Yeah,
I got you.
Yeah, appreciate that. All right, so let's keep going. And if you need to, you can mute me. Gosh, I know you're trying to listen to them. All right, so let's go. So we know June 10th, the defendants and defense attorneys were in trial in a way they were waiting for court to start in Glanville, Love, and Simone Hylton. This may not be Steele, because he called a Fulton County deputy district attorney. Still would have just said lawyer Love and lawyer Hylton, as well as Woody and his attorney Caleb Bumpers, all met ex parte upon information and believed this ex parte meeting was initiated by nobody else but Love. Neither Woody nor his attorney requested this meeting. In fact, neither Woody nor Bumpers ever expressed any concerns which would have prompted a meeting. And they say, while the state falsely characterizes this meeting as merely a discussion, ain't no such thing as no discussion about his immunity. The reality is that Woody had already been granted derivative use immunity. There was nothing else for the parties to discuss. Either you're going to testify or go to jail. Copeland never requested to meet with the prosecutors and the trial judge to discuss these matters. Additionally, the ex parte communication were about more than just immunity. Judge Glanville and the prosecutors discussed proposed testimony, provided legal advice, albeit incorrect legal advice. Of course, Glanville gonna get it wrong, and strategy to Copeland. This is what happens when you have judges trying to give legal advice and DAs. Y'all not defense attorneys. Y'all specialize in y'all field. People think because you're a good prosecutor, you can be a good defense attorney, or vice versa. Or they think that judges just know all the law. Man, I know so many judges that can't get the law right to save their lives or their careers. But people still vote for them. Throughout this process, Judge Glanville was clearly working on the prosecutor's team, and he abandoned any semblance of impartiality. He said, to hell with it. I can't help them enough just by coaching from the bench. He said, to hell with it. I got to put on the jersey and actually get in the game. Let's keep on going. Neither Judge Glanville nor the state revealed that these ex parte communications had occurred. He hid it while they were waiting outside for hours, completely oblivious to what was occurring behind closed doors. And by doing that, Judge Glanville's silence violated Georgia Code of Judicial Conduct 2.981B. The defense would likely not know of these communications had it not been for Brian Steele, who learned of the meeting by happenstance and confronted the court, bringing sunlight to darkness. See, I'm not the only one saying that it was some darkness going on. They said Brian Steele had to bring that sunlight to a dark room, a dark courthouse. Y'all see it. Let's keep going. When attorneys still inquired about the secret, June 10th meeting, Glanville got mad and tried to hold Brian Steele in contempt. Judge Glanville attempted to incarcerate Attorney Steele for 20 days. Judge Glanville had his deputies take Attorney Steele into custody and attempted to incarcerate Attorney Steele without notice or legal counsel. And that's kind of iffy right there, because I never seen judges, if they're going to hold somebody in contempt of court, normally you go into custody right away. You can contact your lawyer later on, just like any other arrest. When you go in, the police going to take you to jail, they don't give you time. I'm going to call my lawyer on the side of the road. So, that's that. But they don't say, okay, you get to stay out. You don't have to go into custody until your lawyer gets here. But in any event, as the existence of the ex parte meeting became known, Judge Glanville frustrated the lawyers, the defense attorneys' attempts to learn more about this meeting. He hid it. Judge Glanville, he got in the way. He frustrated their attempts to learn more about the meeting and the repeated request for a transcript. Some people say he didn't want to get a transcript because he still had to get it ready. He had to go through the transcript with his magic marker and make some stuff disappear, allegedly. Because I ain't never seen it take that long to produce a transcript. Judge Glanville claimed that what occurred in this secret meeting in his chambers was privilege. This claim of privilege was without merit. Yeah, Judge, you don't get no claim of no privilege. You can't claim. How you claiming privilege for somebody else's client? Judge Glanville, it appears, instigated some sort of investigation into this incident. And guess what? The investigation was not about the illegal meeting, but it rather how they found out. How did y'all learn about it? That's all Glanville wanted to know. He said we could care less that we were having a meeting, but how did you find out? And now Regina said, "Yentas." Tasha, you finna go down that rabbit hole?
Sorry, I'm listening to this.
No, you good. I said you finna go down that rabbit hole with these questions in the chat.
Oh, I was trying to figure out what because you going to say you was ignoring her, and I didn't have the chat up for a second because I was listening to this thing.
Right. I'm not ignoring her. I'm reading the words. The motion.
Somebody said she wanted you to drop the link for her or something.
Okay. Well, let me get through. We're almost done with this motion.
Okay.
Obviously, we can't read and talk and watch a video, Kayla. It's just gonna be too much going on. So I haven't forgot about you, Miss LaVonda. If you still had time once this is done. Okay. All right. So let's keep going. This investigation included Judge Glanville utilizing law enforcement resources to access courthouse cameras to track the movements of Brian Steele. He all in the cameras. And I bet you he was in the cameras with the same deputy, Deputy Brown, the one who's alleged to have told about the meeting in the first place. Deputy Brown probably made sure he didn't have that camera to where he was seen on it. He probably showed Glanville the parts he needed to see. But as the public pressure mounted, as Talk Their Law and other YouTubers put that pressure on him, all of a sudden a transcript of the meeting was eventually provided to the defense. See, when public pressure come out, when you start talking about a lot of stuff in the media, next thing you know, the Supreme Court of Georgia hear about it. Next, the heat's turned up. Next thing you know, we got a transcript. And the transcript of the meeting speaks for itself, and it is shocking. Not shocking, Brian Steele. He said, and it is shocking. What was going on in this transcript? He say, A, neither Love, Hylton, or Glanville had a legitimate basis to engage in ex parte communications. Somebody said Hylton was back there with her uncle. Somebody said she didn't call that man uncle. It just sounded like that. The ex parte meeting was not requested by Woody or his attorney. The prosecutor, specifically that sneaky love, misrepresented facts and lied. And guess what? She made those lies against attorney John Melnick. But guess what? John Melnick may be in court on Monday morning. So Melnick finna expose the lies that Love told on him. And that's probably why Love was looking kind of scared at the end of this hearing today. Because we finna get to the truth of the matter asserted. So Melnick does have a subpoena to be in court on Monday. And we have a footnote here, number 5. The details of these misrepresentations are discussed more fully in other motions. The state claimed and Judge Glanville ratified, co-signed that Copeland faces no legal jeopardy in this case by advising Copeland that the statute of limitations has run. It is unclear how the state and the trial judge came to this conclusion. First, the conclusion ignores the tolling provisions of the statute of limitations in Georgia. Second, even for older incidents, their legal analysis and interesting in light of the case that they are currently prosecuting would be interesting to the 6 defendants at trial. Number 7, as the prosecutors in Glanville have claimed that this transcript captures the entirety of the secret communication between the state and Glanville, it is entirely unclear how Judge Glanville even had knowledge of the state's list of questions for Mr. Copeland, aka Woody, because that discussion was not found in the transcript. See, so that's what they're saying. Something's missing out that transcript. That's why we need Kayla to fill in that blank. If she knows, she may not know. Here we go. The prosecutors and Judge Glanville incorrectly advised Woody about the law of derivative use immunity. See, this is why you don't get legal advice. That's why Woody had reservations. Woody didn't trust the DA and the judge. And guess what? They didn't even know what they were talking about. They tried to assure Woody he could never be prosecuted again by them or the feds. The prosecutors and the judge incorrectly advised Copeland that he could be held in civil contempt indefinitely. Judge Glanville abandoned any semblance of neutrality and worked in concert with the prosecution. So he's on a prosecution team. Judge Glanville assisted the prosecution. He threw on them alley hoops. Not only that, he instructed that a list of questions be prepared by the state be provided to him. And this is what Matt Shaw said. The judge wanted a list of questions provided to Woody, but guess what? That's not in the transcript. So what we're saying now is, if the judge asked for a list of questions to give to Woody and it's not in the transcript, that means somebody took it out the transcript. And if they took that out the transcript, what else did they take out the transcript? A significant amount of Brady material poured out in this meeting, but the same was hidden from the defense. They hid it. And we all know about the June 7th ex parte meeting that we just found out about 2 days ago. The Honorable Judge Whitaker provided much needed clarity to the defense by releasing the rough draft. See, look at this, a rough draft. A rough draft of a transcript. Regina saying either they scrubbed it or it was another meeting. Yeah, something missing for sure. This ex parte meeting occurred on June 7th and included Love, Hylton, and Glanville. So we already know that. They wanted the transcript. Neither Judge Glanville nor the state made any disclosure regarding these communications. Even as attorneys still pulled the curtain on July 10th. So what they're saying is, when they made a big fuss about July 10th and not having the transcripts, in Judge Glanville wisdom, he should have said, okay, if they're making a big fuss about not having the transcripts from the first secret meeting, we better tell them about the secret meeting to make sure that there's no confusion. But guess what? They hid the second secret meeting. We just now found out about that 2 days ago. So they saying, as big as a fuss Brian still made when he pulled the curtain back on July 10th, neither Judge Glanville nor the state ever disclosed about the other secret meetings. Instead, Judge Glanville and the state remained silent on this topic. Additionally, while the parties were well aware that the Honorable Judge Cross was considering, see, they knew Judge Cross was considering whether to kick Judge Glanville off the case or not. You think they were going to raise their hand and say, oh, yeah, by the way, Judge Cross, we got something to tell you. We have another secret transcript that you don't know about. They withheld that from Judge Cross. Even though Judge Cross still found enough to kick him off the case, they withheld that from her. And Judge Cross took the bait and said Judge Glanville did nothing wrong. I wonder if she think that now that more transcripts are coming to light. See, that's what happens when you try to protect your friends, Judge Cross. They make you look foolish. You're trying to protect this man, saying he did nothing wrong when you kicked him out the case, and now more dirt is coming up about him as the weeks pass. This is why she should have did the right thing in the first place. But even though they knew Judge Cross was considering whether to kick Glanville out, neither the prosecutor nor the judge revealed to Judge Cross that there was in fact another secret meeting that occurred 3 days prior. This was their secret. And then he said the transcript of June 7, 2024 communications is shocking. He said it's shocking. Now I'm trying to see how much more shocked can we be? It also sheds light. Let's see, shed some light. There must have been some darkness somewhere on how this case has become. Don't even give me the going on this word. Irretrievably broken. That sounds about right. As an initial matter, there is no stated justification for this ex parte communication. The meeting was again initiated by the state, more specifically Love. Neither Woody nor his attorney had requested that the state meet in private with Judge Glanville. The meeting itself was and is illegal. India said that, yeah, that's how you say it. Shout out to India. Shout out to India. The state in this meeting intentionally and wrongly attacked the character of Woody's attorney. Well, both his attorneys. They talked about Melnick and Kayla. They talked about Melnick, claiming Melnick was not representing Woody's interests. Oh, yeah. They talked about him bad. They were trying to get Woody's attorney kicked off the case. They talked down on Melnick's name to the judge, all because Woody was not interacting with the prosecutors in a manner that they wanted Woody to do. They wanted Woody to be buddy-buddy with them. But when his lawyer showed up, all of a sudden, it's a problem. All right. Let's keep on. Hold on, I'm gonna put it. I'm gonna make it a little bit bigger so it's easier to see. But I'll still be right here. Hang on a second.
She's talking now.
Okay, let's go. Okay, the prosecutors claim to be the only ones who were truly representing the interests of our witness, not our witness. Oh, she's trying to get my attention. What happened?
Nick and Kayla are talking about it. They haven't said anything of substance yet, but she's like, that was the first time she heard the information. So I don't know how true it is, but
So she said she don't know that.
I don't know. We're gonna see if she keep talking.
Okay, thank you. All right, yeah, we're gonna push through. We're trying to figure out, and she's listening for us to see if Kayla can confirm whether or not there was another meeting between Kayla, Hylton, and I believe Woody, because one of the lawyers mentioned it today in court. So we're trying to confirm if that's true, because if it's another meeting that's missing, then it's safe to say there's other stuff missing. And we don't even know. Well, let me not jump the gun on that, but okay. The prosecutors complained that they had been having productive communications with Woody outside the prison of Melnick before Melnick had inserted himself into his client's affairs. Let's go to footnote number 8. While the state has maintained at times, at least, they did not realize Woody was represented by Melnick when speaking to him, this excuse is difficult to accept. Their story has also changed. At times they didn't know. And then at times Melnick told them he didn't represent Woody. At times Woody told them that Melnick was not his attorney. At times Woody never asked to speak to Melnick. The explanations are all hard to accept. Love has prosecuted Woody in another case, which was resolved in June 9, 2023. Melnick represented Copeland on this case. So at the very least, if Love prosecuted Woody in June just last year, that's probably why he don't like her. She just prosecuted him on another case just last year. And guess who was his lawyer? Melnick. Melnick represented Woody on this case. Melnick's representation of Woody is also openly discussed in interviews which were provided in discovery. Additionally, the fact that Melnick also represented Woody's interest as a witness in this case was always fully understood by that Love. As Copeland faces legal exposure in this case, the defense has always acted appropriately and has refused to initiate any conversation with Woody, who is known to be represented with Melnick without Melnick's knowledge and approval. Melnick's representation of Copeland was no secret. All right, so that's footnote number 8. The prosecutors claim that Melnick was not representing Woody's interest is rich, as they were communicating with a person behind Melnick's back. The state had intended to call Woody as a witness without granting him any sort of legal protection as a witness. It was only after Melnick inserted himself and advocated for his client that the state sought to grant Copeland derivative use immunity. The irony does not end there. He said the irony does not end there. The state in this meeting claimed to be concerned about the possibility of Woody suffering an unjust jail sentence due to Miller's interference in his client's affairs. That's crazy because his own lawyer is not the one putting him in jail. It's the state that's putting him in jail. At no time, however, did the state ever seek a non-custodial alternative for Copeland should Judge Glanville hold him in contempt. Instead, these prosecutors insisted on an indefinite incarceration for civil contempt, which would have been illegal. The state also questioned Milnick's devotion to his client, as Milnick was planning to leave the state on vacation while his client was incarcerated for contempt. Now, that's really funny that they tried to say that how could Milnick leave the state? And now you hear Hylton in court today begging so she can go on vacation.
hold on.
We got action.
Sorry. Kayla just said something that was really, really interesting. She said, so Rachel insinuated that that he said that he killed Nut in that meeting, and that information should have been turned over. Teddy said, oh, well, I don't believe that actually happened. And Kayla said, what if he said something else that was a Brady violation that should have been turned over?
Do you have a timestamp? Maybe we can get that in a little few seconds.
I'm still on it. So if you
okay,
go right
keep going. Okay,
and go back like a minute and like 2 minutes, you'll catch it. Like 2 or 3 minutes, you'll catch it because it just happened. Like as soon as I said, hold on, I just put him on mute.
All right, we're gonna watch just a few seconds of this, and we're gonna get off these folks' channel.
Well, you have it now. We don't have all of it, and I don't know if they're talking about where Woody may have told them that he told them that he possibly did some of these things, and then they weren't going to turn that over. That is a Brady violation. When somebody else claims that they did something and they tell the prosecutors, and that could be a possible defense for the defendants who are being accused of doing the same thing, you have to turn that over. The fact that they had given him immunity, the fact that he was under arrest, none of that matters. I don't understand what they're talking about.
Yeah, and
crazy.
That's assuming he said that too, though. I don't see why you would admit to unaliving somebody, but
well, he's got a lot of interesting strategies, but the state doesn't get to decide if it's truthful or not. They still have to turn it over, and then the defense gets to do what they want with it.
Yeah, I'm just saying I'm kind of 50-50 on if that was ever said personally, but I hear what you're saying.
I'm not saying I believe him, but
yeah, no, I'm saying I'm not sure that actually was said in those chambers, but because part of that was when in just the transcripts, I'm just going off the transcripts. Essentially, what he was saying was basically, even if I said I did this, the Fed's gonna come and get me. You know what I mean? So it doesn't interest-wise, it doesn't make sense to me for him to even ever admit to saying that. But we'll see what happens. I mean, I can admit my YSL bias. I tell people that all the time, even though they don't believe me, but it is what it is.
But what if there was something else that was Brady that was said that isn't about the murder?
That didn't make it onto the court reporter's transcript.
Yeah, I mean, it doesn't have to necessarily be about the unaliving. It could just be about anything, I'm just saying maybe. I don't know.
Yeah, like how could we be confident in it? Yeah.
Well, I wasn't there, but
me neither. But to count my own chest, I called there's something missing really early. I'm just saying.
I love you, Kayla. You know that, right?
Yeah.
I couldn't. I'm sorry.
When I read that transcript, it took me roughly an hour and a half, an hour 35 minutes. The meeting was 2 hours 10. And I don't read that fast. And even with commentary and everything, and even because then the attorney-client conversation was according to later 7 to 10 minutes, something of that sort, if I remember correctly. that still leaves something around 15 to 20 minutes of things in the judge's chambers that isn't accounted for, in my personal opinion. I just don't know. I called it. I called it, and I'm taking full credit for it, just so you know.
He's taking credit for it, y'all.
But yeah, I mean,
You can
every damn day in this court, we find out something new about
every day
what Hylton and Love did or didn't do. And I thought this was off the rails even before this ex parte happened. I mean, I've been shouting from the rooftop for months and months about this. And
you mean the opening statement? Because the opening statement should have that ruined everything.
So what y'all think?
I'm gonna tell you the truth. She implied without implying what was going on, because that laugh was too fake for me.
Right. She ain't gonna. Yeah. She probably gonna leave it at that. I don't think she ain't gonna say much more.
Well, should she have even said that? Right.
I mean, because it might be confirmed because Brian still said something that is left out. They had a meeting. It was Weinstein or Brian.
What I will say though is she did. You're right, because she did say she was scared of what else Brian Steele would say next on this interview before all of that. I don't know, y'all. I'm a little scared for Monday.
Yeah, it's gonna come out now. Oh, thank you, Aries 1. That was, thank you for liking and sharing the video.
All right, y'all. I'm about to head out. I'll be in the chat though.
Oh, okay. Well, thank you again, Tosh, for always coming up.
I know I'll see y'all next time.
Right. Which probably gonna be Monday, man. Monday sounds like it's gonna be a good day. We might get Melnick on the stand.
Listen, I think she's gonna let him up there. She don't have no choice, because if Melnick shows up, he's just gonna be sitting in court for no reason, waiting on her to call him. I think she's gonna call him, because she wouldn't want him there if she wasn't.
Right.
But okay,
yeah.
I'm getting the chat, y'all.
Okay. Oh wait, Jiggy said don't leave yet unless she has something to do, because I think Jiggy wants to come up.
Jiggy, are you coming up?
I think he said maybe in about 10. I don't know. He said he's charging something.
Okay, you about to join. I'll stay and wait on you, Jiggy, for just a second now. Go ahead.
You want to just come back when he come back? When he come back.
I'll see him for a second. I'll just mute myself and wait till on him to come up.
He said he's charging his phone right now.
All right. I'll wait.
Oh, okay. All right, y'all. He said, what chat is what? Is that cat? What does that mean? I don't know. What do you mean specific, Torrance? Oh, you want to go? Let me go back. Hold up. And shout out to I think Nick is what they call him. Nick. Can you see it now? Or no? Oh, hold up. Can you see the name, Nick? I don't know if I can make it big. Nick, Nikstarow. Oh yeah, no problem. Appreciate you popping in. Oh yeah, I got it. There you go. No weapon formed against me. Come on. Yeah, shout out to Nick and his channel. So if y'all want to go over there and catch the rest of that. But we, Kayla, she dropping breadcrumbs. Kayla, we need the whole info. What happened? I mean, all this speculation going on. All right, y'all. So we're just finishing up this reading. Some of y'all said we don't care who on. We over here. We not leaving. Appreciate y'all support. And if y'all do want to go over and check it out, no love lost. Hell, y'all might go over there and get some good information and bring it back. Then we'll go back to the stream if it's something breaking it down with B. She said we would talk that long. That boy said, "Oh, mom, what up?" Oh, he said, "Oh, okay." There was he said, "No thanks." Law Malcolm, be nice. We don't got no evidence of none of that. Including the price of the dress. We don't know that. Yeah, and I took my camera down for a second to let since it's been going almost 10 hours, I want to give it a little bit more juice. That bar was getting pretty low. I said, let me knock it down and juice it up for a second. All right, let's keep on reading. All right, y'all. So we're just going through the finishing up this motion. This is Matt Shard, and he's writing a motion about why the judge should throw this case out. And we're like halfway, we're almost more than half. I think the bottom just exhibits. The state complained to Judge Glanville that Melnick had not planned his vacation around Woody's testimony. This is a ridiculous accusation, as the state has intentionally failed to communicate with Melnick and had not given Melnick any notice that they were planning to call Woody on June 7, 2024. June 7, 2024. Oh my goodness. Long 10 hours. Let's keep going. We already read that footnote, I believe. Oh, we got upon information and belief, attorney Melnick had already purchased non-refundable tickets for a trip to Alaska, which was to commence that coming weekend. Perhaps if the state had not cut Melnick from their communication with his client, he would have been able to tell them about his scheduled trip.
Hey, Tyler Law, drop the link for Jiggy real quick.
Oh, okay. Appreciate that. While I'm reading, I don't see y'all comments, so. Not Stream Lab. Jiggy said, you know what I'm talking about. Law Malcolm say, talk to Law is cool and I'm sticking with him. Plus, he doesn't block you. Yeah, I can't tell you how many people come on and have different opinions than me. but I don't sit them down and block them. What's going on, Jiggy? Let me see if I can move myself out the way since I ain't got a.
My doggy, what's up with you, gang?
Man, I can't call it. What's the word?
I in my office right now. It's a little bit different. But nah,
I know
before I talk to my boo Tasha, I'm trying to see, bro. I missed that whole shit earlier about still saying the government agent shit. That was kind of crazy. I ain't gonna lie. I missed that, bro. We got to chop it up about that.
I said now this whole time you've been saying that Woody's
the
an
whole
informant.
time, the entire time.
And when Brian still actually said he was a government agent, you had went radio silent. I said, "What? This is his time."
I wasn't here. I didn't see that, bro. I would have been real vocal if I seen that. I promise. Once you did a replay and you double back on it after the end of the day, that's when I was like, "Wait, what?" I was going crazy in the comments. I was like, "Nah, that's that confirms everything." Bro. Obviously, now he's not gonna like present evidence for it. He doesn't have to, but during his case in chief, he definitely will.
Well, we're gonna see. Because right now, I mean, the judge said, "Where's your evidence that he's a government agent?" And then Brian still said, "Well, he agreed to cooperate with the police," but I don't think it was. I don't know if that's the case because
bro, still got more. I ain't gonna hold you. Still got more. Remember, even before when Glanville was like, "Oh, who's the next witness?" and Thug or Jeffrey rather was just like he was like nodding his head type shit. Like there's something with that, bro. I ain't gonna hold you.
Let me say this right quick because I don't want to forget. Thank you, No Weapon Pointed Against Me, for the super sticker. It's really nice of you. And I know sometimes people pop in and out, and I don't want to wait too long to acknowledge it, and you be gone from the chat. So I want to thank you while you are still here.
Yeah, bro.
No, you good. So thank you so much. And I'm discharging my I'm gonna turn it on in a few minutes. But yeah, go ahead. But thank you again, No Weapon Pointed Against Me.
And the wiretaps too. I've been told you about those too. Now they really about to come in. Honestly though, I don't think Whitaker gonna let them in. She's gonna let some in, but she's not gonna let as much in as the state wants. So, I've been told you about those too, man. I've been told you.
But my thing is, just because he's on a jail call with the detective,
I didn't even know that, bro. I didn't know that was a wiretap. That was spooky to me too, bro.
No, that wasn't that's not a wiretap. That was a jail call.
They got more wiretaps though. I didn't even know about that jail call with Gaither and Woody, bro. That shit is spooky too. Like, yo, bro, I said in the comments earlier, I don't know if niggas know how jail calls work, bro. But the only way you could make a call off a jail phone is if you like memorize the number. If you memorized her number, that's saying a lot, bro.
Well, they can write it down too. I mean,
say that again.
They can write it down too. I mean,
they can, but bro, like, come on, man.
Or they can have a business card.
You being devil's advocate right now. You're not being.
No, I'm speaking from personal. No, I'm speaking from personal experience because a lot of times when I go visit my clients, you see it might be a big holding tank and people in the back. Hey, tell your lawyer what's your number. Give me your card, and then they call their family, give my information. So I mean, it's not uncommon.
Low key, I didn't even hear the conversation. I wasn't really tuned in when you was playing that shit. But just the fact that they had one, bro, that says a lot, man. That says a lot.
Yeah, and it looks like, from my understanding, Woody called some girl, and the girl three-wayed the detective in because they were trying to figure out how to get out of jail.
Bro, his girlfriend knows she's an informant. Like she knows she's an informant.
No, but this was a scenario. They were trying to figure out how could Woody get out of jail, and the cop said the only way you can get out of jail is we can verify with the information you told us. And then No, I'm gonna finish this. And then Woody said, okay, I'll verify. And they trying to say just by saying that, or I try to verify he's a government agent. That's not how that works. You're not automatically an informant because you say, okay.
Yes, sir. But do we know what was the case he was bagged for? Like, what was he bagged for at the time when he was having that conversation with her?
I'm not sure what you're asking.
Do we know?
I'm not sure what you're asking.
I'm saying when he had that conversation with Gaither, like that jail call they recorded or played rather when he was talking to Gaither. I'm saying, do we know what he was back for at the time?
No, I don't think we know. I don't remember what because I don't know what day he was in custody, but
Yeah, nah, I don't think I was just asking.
but whatever the case may be, I mean, I don't know if that's really like relevant, right? I mean, what would they prove?
Depending on what? No. I'm saying, depending on this case, if he's saying beneficial information to a cop, then I think his case was a little lengthy. But what somebody just said in the comments, they said don't inform us we having conflicts or like that. Yes, but I also think like there's a difference between a state informant and a federal informant. I don't think he's a state informant. At first I did. I thought he was a state informant. Now I think he's a federal informant. Like, and that's why the state is doing all this weird shit, because they can technically, and he's not fucking with them because he knows he's a federal informant. He doesn't have to fuck with them like that. That all makes sense to me.
Well, I don't know if he's a federal informant because Gaither doesn't work for the feds.
Nah, that's not that. That was his buddy. Dennis and Gaither was his buddies, bro. But then during that 9-hour interview, I think that's when he really became a federal informant, bro. He was in there with ATF agents, and I think that's because of the murder that sparked mad shit. Like, that makes sense in my head.
The judge had asked. He said, "What proof do you have that he's a government agent?" And still should have said, "Okay, I got paperwork. He's a federal informant."
Come on, doggy. You a lawyer. You know he don't gotta present that right now. It's not his case in chief. He don't gotta say shit right now. He just gotta.
But
just get on his side.
But who he hiding it from?
He's not hiding it from nobody. He just don't gotta say it right now. Like, that's how I feel.
Okay, he's not hiding it, but he don't have to say it when the judge asks him.
That's how not like, bro. She. It's not. Like I said, I didn't see it in real time. But when you played it back, like, it's not like she said, "Oh, do you have any whatever she said?" But then she moved on instantly. It's not like she waited for a response. Like, she said, "Do you have any proof or some shit like that?" And then she moved on to the next question instantly. I feel like I feel like she know too. Like, if Glanville know he was a snitch or informant, I think she know too. And I think I don't know. I'm not a lawyer. I don't know law as much as I think I do. But I feel like if he is really an informant, then it gotta come up at some point.
But okay, at the end of court today, did you hear the judge tell the state, specifically Love, if there's any agreements with anybody that you have in the past, the defense should already have it, or if you make an agreement in the future, the defense needs to know about it. So if there's some type of deal or some type of information,
bro, I didn't hear that. But even the fact that she's saying that I think that says a lot. Like, they're aware of some tricky business going on, bro. And really, like I said, I think Woody is a federal informant. He don't have to fuck with Hylton and Love like that. He got higher ups that he could cater to. And I think that's why he's really trying to help the defense now, because the state is doing this all wrong. Like, they can't put a federal informant on the stand and not say he's an informant. Like, they're doing this all wrong. And that's why I think Woody's doing all this extra shit, doing on the YouTube promotion, saying X, Y, and Z, like, just not fucking with them in general, because he really don't have to, because he don't have no state immunity. He got federal immunity.
Yeah, the only thing I'm saying is just because somebody may agree to cooperate, we don't even know if that was even fruitful. Anything came out of that. That don't mean that they automatically, they're an informant. You get what I'm saying?
What you say, bro?
No, I'm saying just because somebody say, okay, I'm gonna try to find out something to help themselves out. I'm gonna try to find out some dirt on somebody. That don't make them a federal informant.
Absolutely not, bro. Like I said, I think this dude became I don't think dude ever went to the feds, bro. Like, you see how comfortable he is on social media. Everybody I know that went to the feds, bro, they got fed pictures. You know, they in the white tees, pants, or they chilling. Like, they post that shit. The way he's comfortable on social media, we never seen no fed pics of him. I really don't think he went to the feds. My theory, my hypothesis is he went to witness protection after the nut shit. And he became a federal informant for not for YSL, just became a federal informant in general. After that, they came up with this whole RICO shit, and he, once he seen like all the shit going on social media, he was saying, I don't know what he said to them, but I think his logic was like, yeah, I'm not about to go on stand against these guys, and that's why they leaked his first video with Shorty and Dude. Like, that's not you. When have you ever seen an interrogation video like come out? Like, that's not normal, bro. And I heard a rumor that the state leaked it. I can't confirm or deny that, but that would make a lot of sense. That's to try to scare him into saying, oh, if you don't fuck with us, we're gonna. Oh, my fault. If you don't cooperate with us, we're gonna put all these other videos out because we already got this one, and that's essentially what they did.
India said that theory is wild, but Jiggy always has some wild theories.
That's not how is that a wild theory, India? For real.
India.
What? He was in jail for 2 days in contempt. Like, what? In state and Rice Street, and the judge said he couldn't be around no other prisoners. Like, I'm not. That's not. That don't tell me much.
Yeah. I mean, we don't know, but we need to see some paperwork before we can officially say he's an informant.
We gonna find out. I tell you that much, bro. Bro, the shit. When you play back, I never ever seen that shit. I like I said, I didn't watch in real time today. I was late. Still saying he's a government agent, bro. That says a lot, bro. That says a lot. Yeah, we get no comment.
Hey,
though. I know what you want. I know we can move.
No, talk to Tasha real quick for a second. I'm gonna go turn my camera back on.
You a fool.
Want to talk to me?
Hey, boo, I want to talk to you. Why you playing around?
What?
You about to start your twerk channel? You say?
Nah, I ain't starting no channel for real. I'm just joking, y'all. I don't be on there like that.
Nah, you can start a real channel, but you can start a twerk one just for me though.
A twerk channel just for you, Jiggy?
Off.
Cause I'm doing something at work.
It was not being sarcastic, indeed, not at all. He was being dead ass. She said government agent, Matt. You think it's still gonna say anything up there to be sarcastic? No,
I don't think he was being sarcastic. I think he was being dead serious when he said that. He said it with his chest.
He was being dead ass serious. Like, that's not no comment you make on record, like, just to make. He was not being sarcastic. Anywho, Miss Tasha, back to you.
Oh my God, no.
Since Talk That Law don't wanna help no more.
Don't want to help what? I told you. I told you I was second.
Man, nah.
I told you I was gonna take a second.
Nah, the chat gonna help me out. You ain't. The chat gonna help me out. Fuck it.
The chat gonna help you out with what?
With you.
You trying to get Slick to knock me off. I'm just joking.
What? Slick? That's your one? Slick?
Nah, Slick ain't my one.
I'm your one, right?
Nah.
No? Chat, tell her. Chat, tell her she tripping. Chat, tell her.
Talk That Law. They saying Miss Lavonda say engage with your chat.
Miss Lavonda, we got the link. I see all this stuff.
Don't do that.
I'm ignoring. Yeah, I'm staying on topic. But yeah, y'all keep going.
Yeah, exactly. So Talk That Law vouch for me. See, he co-signed me. He said I'm a good candidate. Tell her Talk That Law. She be tripping.
What was the discussion?
Oh, that's what there was, bro. Now you gonna do me like that? All people, you gonna do me like that?
Wait. I told you I had stepped away. What I missed? I didn't have my headphones on.
You gonna do me like that?
He said he's a good candidate.
Yeah, I'm a great candidate. You know that. Just cut it out.
Bro.
You
supposed
to be my dog.
And man, I didn't know because earlier when you had said that Miss Tasha, you had said Miss Tasha. I didn't know what was.
Talk That Law. You so low key, man.
I didn't know. What?
Nah. Talk that Slick. You know what he doing.
Oh, come on, bro.
Don't turn your camera off now. Don't turn your camera off. Do that.
I thought y'all was gonna have to talk.
When I said Miss Tasha, that's because she was getting, a little bit crazy.
All I said was y'all stand up. I said at the UND. You ain't have to stand up. That was just
I stood up though, and I'm here. And Talk That Law supposed to vouch for me, and he not.
No, I haven't finished reading yet, Miss Deborah.
Oh, now you gotta finish reading and shit. All this.
We had took a little
Lawyers read quick, bro. I ain't gonna hold you. Lawyers read mad quick. You got it. You gonna vote? Now you still trying to read old comments, bro. Don't do that. Don't do that.
That's a new comment.
This is brand new because she just wrote it.
Bro. Like one of these regular. He muted me. He told me shut up. That's crazy.
He didn't mute you.
He muted me.
He didn't mute you.
He muted
Tell
me.
him, Tasha. Tell him.
Talk down. Tell the truth. Tell the truth. Tell the truth. Tell the truth.
But it is an echo
Look at
going
him.
on.
You ain't never
I think
seen him smile that big before. Look at him.
Your
He lying
service
on
is
me.
going. Your service is going in and out though, Jiggy. I don't know where you're at. Are you on Wi-Fi?
I am.
Yeah, your service was going in that.
And it's causing like some feedback, like an echo. But yeah, y'all got the gist. But yeah, Miss Deborah, I did plan on finishing up, but it ain't that much longer. It was just we almost at the end. It's pretty much the same stuff we already hashed out. Jiggy say vouch for him. Shout out to Jig.
I want you to vouch for me.
Jiggy, what? Hey, what state you in?
We supposed to be
I
gang.
don't know if you just unless you just I don't know if you want to disclose it or not. I didn't know if you had it back.
I think in Sylvia chat. I'm in Boston. I'm in Massachusetts.
Oh, you way up there. Ain't it like cold up there?
You say what?
It's like cold up there.
It get cold, but this the last winter was fake smooth, and summer been chilling. It definitely get cold up here though. What Deidre talking about? What you mean I tried it? I ain't tried nothing. Cut it out.
No, we all good. It's all good. We just talking.
I'm the chat comic relief. I found that out long ago. I'm cool with that though. I'm built for it. I could
Not
put
the comic relief. But yeah, I mean, I don't know. I think when Melanie comes back on Monday, it's gonna be interesting to see what he has to say about love. Because
yeah, like
if he say
what he's supposed to say on Monday, like what they bringing him for?
Because Love made a lot of accusations against him, and Melanie is supposed to be there to straighten it out. So,
so the defense bring him out against to kind of vouch for their case type shit.
right, and trying to pretty much show why Love and Hylton should be, disqualified, but she's not going to disqualify them. She liked the drama. One thing about this judge, she won't.
Fake.
I mean,
fake.
Let's be clear. Without Love and Hylton, I mean, the trial gonna be dry. I mean, we need Love in there so she can accept her loss because she the one that caused it.
My whole argument for a long time, like there's no way in hell they could recuse a judge who's supposed to be held at a higher standard and not. And if a motion was filed to recuse the prosecutors for essentially the same thing, that there's no reason the prosecutors should not be disqualified or removed too. Like, so for her to do that, like, yeah, she is trying to see how this rock out. But I also think, bro, I really don't think like this the jury's coming back. When they supposed to come back right now?
Wednesday. That's what we're shooting for. Wednesday.
Hell no. I don't see
You
that.
don't think so, Jiggy? I think they're gonna come back on Wednesday. They got to.
Yo, bro, they don't even have real instructions for them yet. They can't bring them out without that. Like,
no, she went over the instructions.
She already went over it.
I don't think it was confirmed though. It was confirmed.
No, it was confirmed. She confirmed it.
Yeah.
She said, "This is what I'm gonna say." She said, and then she said, "I'm glad I made the defense upset. They're not.
I remember her saying that. She said, if I made the defense and state like argue, then that means I did a good job. But she said like that's gonna be the final instruction. Like there's no.
Yep. And
I don't know.
I don't think it's gonna be anything extra added to it. She did give Love a chance to write what she thought, but that was the end of it. She said, "That's what I'm gonna say." Now I know Steele said that he had a disagreement with what she was saying towards the end because he wanted her to put in that Judge Glanville was removed, but she said she wasn't saying that.
Nah, I didn't know it's confirmed. That quiets my opinion a little bit, but I really don't. I really.
Who is this? Is this TT?
Oh.
I see you draw.
I want you to start twerking. I didn't shoot my shot. Tasha know what's up. I don't gotta shoot my shot.
I ain't looking at you right now. What they say?
They said somebody said they was waiting to see me shoot my shot and waiting to see you start twerking. That's what they said.
Oh, okay. Well, shoot your shot, then I'll do the Megan.
What? I don't gotta shoot my shot. You know what's up. I pulled up. I already
You pulled up. You ain't stand up, though. You pulled up, but you ain't stand up.
He pulling up his talk that line gonna vouch for me again. Look at him, just silent with his blue tie.
He
Look at him. Look at him, just silent with his blue tie.
He didn't vouch for you before.
Bro, I'm trying to see.
I'm trying
to see.
Jiggy, they said that you're gonna have talk that law editor working overtime to remove.
For what? What I do?
Hey.
Long as they don't make a short and say a love connection on.
Want to say reach your comments.
What I did wrong.
Miss Lamont, I don't be seeing your cup.
Did Woody really go to jail that weekend, or they take him to a hotel?
I think they took him to a hotel. No cap.
Hotel Holiday Inn. Because Kenneth did.
Honestly, no, I don't think that. I really think they took him to Rice Street and just put him in like PC.
No, he wasn't in Rice Street because Kayla said she couldn't find him. She went to Rice Street to talk to him.
She couldn't find
him. He was not in Rice Street.
Don't tell me he was at the Hylton
Holiday.
He was at the Hylton.
He was at the Hylton Holiday.
At the real
He was at the Hylton.
The real Hylton.
Nah, he was at the
house Hylton.
Now, when she say that though, for real, she said that.
Yeah, she said that day. She said she went to go see him and she could not find him.
Oh, he was at Rice Street. That's what.
Yes, Miss.
He was not in Rice Street.
Nah. So you telling me they brought him to a hotel? Not I'm gonna say a hotel. I think he's been in witness protection from jump. You telling me they brought Brody from his crib because that's what they said they was gonna do. They gonna pick him up from his house. That's what Miss Hylton said. They picked him up from his crib, gave him a fake jail uniform, and put him on the stand.
Man, you don't put nothing past nobody.
Not them, but that's not wild.
But I mean, he could have been housed somewhere else, and it could have been
India say.
Houseware.
That's what India say, but
we don't know.
Why would he go to Cobb County?
But Miss Deidre, they did give jury instructions this morning. The new judge, she said that she's going to explain why she is the new judge. So yeah, they do have that worked out.
Hey, word! I'm really interested to see like what her. Y'all said they agreed to it, but there's no way that could be the instructions to the jury for a new judge and to restart Woody's testimony. Like that's nuts.
Thank you, Miss TC. Have a good weekend, and thank you again for the kind cash out. Definitely appreciate you. She said she out of here. She said she was trying to wait on you to see what you was on, what y'all was on in Boston. She said y'all ain't on nothing. She gone.
I'm not about to.
She said you ain't talking. She said you ain't talking about. She said you ain't talking about nothing. She tried to wait.
Man, Tasha know what's up. She playing around.
Just messy talk.
I'm just saying what TT said. She said she's gonna wait around.
Tasha know what's up. TT know what's up too. Tasha just playing around. Look at her. You can tell by her hair she playing around.
TT has said that she was gonna sit around and wait a few more minutes.
She knows what's going on. She's waiting
I
for.
sat around and waited a few more minutes. Now I'm about to leave. I gotta go.
Now you leave.
She said.
Now, what you want me to shoot my shot to? I already told you what's up.
Dig it. I just said I'm about to go.
I'm not giving you my Instagram on here. You can give me yours though. They can't know my name.
You want them to know my name?
Yeah, you like a fan favorite on here.
That don't mean I want them to know my name.
Yeah, that means you could give it to me and you could not respond to them. That's what it means.
Listen.
I'm listening.
You see my YouTube?
No.
Yeah, and you can find me.
No, I want to see Instagram.
I don't got no Instagram.
Now you don't got an Instagram.
What I'm telling you is, if you want to find me, just go look at one of my videos and you might happen to see my Instagram. But if I can give you my Instagram on here, heck to the no.
Tasha.
What? I said what I said.
Hey, put it in the private chat.
Tasha, what's your Instagram?
Put it in the private chat.
Put it. Look at you trying to get my Instagram talk that long.
Put it in. Okay, and for those who popping in, hey, we've been going at this hold on. We've been going at this for 10 hours, so we're just having a little fun. Can we take a few minutes?
There really is wiretaps. Like
10 hours.
We talked about that today. That's really gonna happen. Y'all thought I was capping. But oh man, talk that law. No, because I've been in this chat for months saying the same shit. Next week when everything come out, bro, he gonna be like Jiggy that man. Watch, y'all gonna see. He gonna be like Jiggy that one, Jiggy the prophet. Wiretaps.
No, Mr.
Informant, all that. Yeah, you as a lawyer know it's coming. Yeah, you look at that grin. He know it's coming. Look at him.
I'm laughing at Miss Lavonda. Some of my application been moved to second in line. Miss Lavonda, you know she would say anything.
Miss Lavonda said what now?
I don't know what she talking about.
What kind of application she talking about?
Oh,
no applications outstanding.
Yo, Tasha though, what's your Instagram for real?
Oh yeah, thank you, Dream Josh. She said talking like your channel carries me through. I'm glad to hear that. Thank you so much for that.
Yes, you can. All right, write it real quick in the chat and delete it. She hopped. You scared her away. Damn shame.
Bro, y'all see each other every day on YouTube, and y'all been.
Oh wait, no, she got it here. She got it in the StreamYard chat.
But yeah, in any event.
Nah, but besides that, bro, really, I wasn't watching live when Still said that whole shit about government agent. After you hearing that, what that make you feel like?
I mean, as soon as I heard those words, government agent, when it came to Woody, then the first thing I thought about was Jiggy, because we talked about this.
I'm saying, what you really think about though? Like,
I mean, that don't just excite me because I'm in the business. So just because the lawyer stands up and say, "Oh, he's a federal government agent," and the judge say, "What the proof at?" Or you just saying something. So that's what I'm waiting on. Where is the
also
proof?
The judge, respectfully, she know he really don't have to present proof as to why yet. Respectfully, she knows that. Like, and that's why I said again, I feel like that's why she asked the question and then she didn't wait for a response. She just immediately moved on to like a different sentence. Like she didn't. It wasn't like she waited for a response as if she really wanted to know as if you have proof.
No, that's not the case because Brian still responded. Did you watch the same video?
She said, "Do you have proof? Pull it back up." I'm pretty sure
she said,
you have proof.
It was the last.
No. Like I said, I didn't watch live. I only watched the replay you showed.
Let me see. I mean, she specifically. Wait, what colors they had on today?
I think.
Hold on, I'm gonna do it. Right I'm gonna mute you so don't be.
Love Heart on the slime green.
No, she
White
had
boy
pink.
had on the same black suit he's been wearing for 3 months.
Hold on, I'm gonna mute you right quick so we can have a video, so I don't have no cross noise. But yeah, you had that wrong. Love had on pink today, not no green. Nobody had on green. But hold on.
You can put a proffer on the record. So if you're ready to do that, we can do that now.
I need more time.
Hold on. I'm not even sharing the screen. Hold on. Here we go. That one. Oh, there we go.
The court said, he stated that it was very nice. He stated that I does not.
Oh, he said green nails. I got you. All right, Jiggy.
Like to address the court itself. Okay. That's what he told me. So I can't make a proffer because I don't have the information. I have him under subpoena, like I told you.
Okay. What do you have him under subpoena for? When?
2-hour call. 2-hour call.
Okay. Well, can you proffer to me? I know you can't say here's what he would say, but how about tell me why it is that you think this is something relevant to this trial at this stage, considering that Judge Glanville has already been recused. And maybe y'all want me to, I mean, I have not finished reading all of the material and all of the case law, so I don't know what my decision is going to be on the supplemented motion for mistrial that Mr. Weinstein filed on behalf of Mr. Kendrick. Do y'all want, I mean, I will rule this weekend. Do you want to wait and see what that is? Or do you want to just tell me why is it that anything Mr. Melnick might have to say in defense of himself matters for the trial? It might matter for everybody's, you know, what they feel about their professional reputation. I get that. But for this trial, why does that matter?
So under CAR, C-A-R-R versus State to 19, I think, I don't know, 97 case, 98. It was the case that gentleman owned Pike's Nursery, I think, the house burned down.
Yeah.
There's great language in there about prosecutorial duties.
All right.
And it talks about that the prosecutors need to, they carry the burden.
India, you
charge people. They could ruin people's lives just by the charge. And they have a duty to the public to be open and candid.
You said it was before this, DJ. I mean, sorry about the India.
And
long day. I see DJ name above yours.
That's why I want to address you, because he's not mad at me. He said he needs to have it on the record himself, because he said that what the state was saying is not.
Okay.
And I think that that goes into your analysis of why there was a meeting in the first place. I don't think that it was appropriate, like, and I'm not picking on anybody, but like the Honorable Judge Krause said, if I was going to ask this Honorable Court for an ex parte meeting, I believe that the way I always have it is there's a buffer. You have somebody say, what is it about?
Yeah.
I tell you, and I have to be candid. And if I'm not, in hindsight, you would probably, I assume, or any court would tell me, you had no right to do that because you got it with false pretense.
Okay.
Mr. Melnick is going to say that what Adriane Love said to the judge is just patently not true. Via emails, or description of the emails is untrue. And there's no...
Wait, is this the part, India, or no? Or are you saying it's before that? If it's before that, I'll go find a part. Okay, let me see.
Wait, what? Yeah, no, I'm trying to see what he said, the government agent part.
Okay, yeah, that's what I'm trying to find. I thought I had it right. Maybe I didn't.
You pulled it up swiftly last time. You got the timestamp somewhere.
Yeah, but what happened is they went back on the record after that happened. So let me see. Maybe it's here. Let's try this.
I've listened to these.
Oh yeah,
okay, right here.
I don't think I heard it when they went.
I don't know. I've listened to these so many times, and I don't know if it's fair to you, but he never said about, oh, this is what gang members should act like. This isn't appropriate.
Oh, I think
for
it's
a
right
gang
here.
member to snitch on someone. That's not in there. What he said is something to the effect, I'm not quoting it, hear what little D did.
Yeah, and then she says,
Did he say not little D? He said little D? That's a oh my God, that's a funny name.
Something to the effect, I'm not quoting it, hear what little D did.
yeah, and then she says, D ain't right, D done told, blah, blah, blah.
Yeah. So how does he know that? Who did he hear it from?
Well, I don't know that that matters because they're not offering it for the truth of whether D ain't right.
Thank you for breaking it out.
I don't know.
Nah, bro, pause it real quick. Oh, you gotta pause it.
Right, it's the fact that
Imagine this argument trying to happen in front of Glanville, bro.
Yeah, it won't happen. All right, thank you for breaking it down with B. I have a good one. All right, let's keep going.
literally it was everything they said about him, and overtly the fact that a YSL member they believe told if he did or didn't, and their anger towards it.
I just don't see it like that. I see this. This is after Mr. Copeland. This is after Mr. Copeland has cooperated with the authorities. He is in contact with Detective Gaither on a daily basis.
Yeah. Nah, he's saying it what I was
Speaking
saying
now
bro.
as a government.
What I was saying.
Oh, hold on.
that?
Hold on. 'Cause when we like you talk while the audio's playing, then it'll block out the audio.
My fault.
No, you good. Just give it a few seconds.
This is after Mr. Copeland has cooperated with the authorities. He is in contact with Detective Gaither on a daily basis.
Yeah.
And he is speaking now as a government agent.
Do you have proof of that?
Daily
I
basis.
mean, that's not an issue in this trial. This is him on.
All right, you see, look, the judge said, do you have any proof of that? And the part is we're trying to see if still responded. So that's the part that we were talking about.
Yes, sir.
Do you have proof of that? I mean, that's not an issue in this trial. This is him on the phone.
That's her saying. Pause it real quick, bro.
people.
That's her saying him being an informant is not an issue at this point in this trial right now.
But she still said, do you have any proof of that? Let's see what his answer is.
She skipped immediately because I feel like she know he got proof.
Well, let's see.
That's my speculation, though. For sure it is.
Okay. For sure. All right. Well, let's see what he says.
Still thinking nobody knows he's said a word.
Of course, no one knows it. That's why he's an agent for the government. He is being told on June 10th, you need to work with us, otherwise you are going to get severe time. And he says, great, I will work with you. That's it.
Well, that's not enough.
Wait.
He said-
Because I didn't see this earlier. Nah, bro, I'm gonna cut you off. Wait. He said great. That means that's what he said. That's what Steele said he said.
Right.
Bro. Nah, keep playing it. My fault.
Yeah, so that's the issue right there.
Nah, spin it back like 10 seconds and play it again. I just gotta be sure.
All right, hold on. Let's get it clean so we can get it clean through.
I'll be silent.
India says she can't hear. Hold on. Okay, let's go.
No one knows it. That's why he's an agent.
Hold on. Let me go back a little further back. Hold on.
Cooperated with the authorities. He is in contact with Detective Gaither on a daily basis.
Yeah.
And he is speaking now as a government agent.
Do you have proof of that? I mean, that's not an issue in this trial. This is him on the phone with his people still thinking nobody knows he's said a word.
Of course, no one knows it. That's why he's an
Bro,
agent.
this is him with his people not knowing he said a word. Like what?
All right.
What?
Hey, all right. We ain't gonna. We got the gist of it.
Bro, that's insane.
I mean, if it don't support your argument, I mean, that ain't gonna help by talking over the video. I mean, your argument still ain't gonna win.
Mine? Come on, bro. That's valid. She just said that's not valid in this trial because at this point, his people still don't know he's snitching. That's basically what he said.
Hey, Jiggy, are you reading the comments?
Nope, I can't. I'm in this shit. I ain't in my office.
Okay, you got 5 people saying that they want to hear the entirety of that.
Oh, my fault. I'm gonna shut up, then I'll argue with them. Wait
till I stop so they can hear a clean cut of the audio.
Something to the fact I'm not quoting it. Hear what little D did.
Yeah, and then she says, D ain't right, D done told, blah, blah, blah.
Yeah. So how does he know that? Who did he hear it from?
Well, I don't know that matters because they're not offering it for the truth of whether D ain't right.
I don't know.
We are not offering whether D is or ain't right. It's the fact that literally it was everything they said about him, and overtly the fact that a YSL member they believe told if he did or didn't, and their anger towards it.
I just don't see it like that. I see this. This is after Mr. Copeland. This is after Mr. Copeland has cooperated with the authorities. He is in contact with Detective Gaither on a daily basis.
Yeah.
And he is speaking now as a government agent.
And do you have proof of that? I mean, that's not an issue in this trial. This is him on the phone with his people still thinking nobody knows he's said a word.
Of course, no one knows it. That's why he's an agent for the government. He is being told on June 10th, you need to work with us, otherwise you are going to get severe time. And he says, great, I will work with you. That's in the recording that you listened to. You didn't listen to that part, but it's in this 9-hour recording. So I don't see how this comes in. It is hearsay that he is just saying, did you hear with this other person? We have no idea the context. And it is being asked for the truth of the matter because that's why they are talking about it. This is not, oh, it doesn't matter if it's true or not. He's specifically saying this man said something. I don't see how that comes in. You know, we could ask him about it, but I don't see how the jail call comes in. I think the state has to lay a predicate or a foundation before you think it.
Well, I mean, I would assume they're going to have to lay some kind of foundation for some reason to get it in.
They lay a foundation to have it.
And I don't know what that's going to be, but assuming, I mean, I don't know, maybe you want to elaborate, Ms. Hylton.
We believe this is also evidence of the overarching gang conspiracy. Again, we have to prove that this is a conspiracy, that this is in furtherance of that conspiracy around. We believe that one YSL member telling another YSL member that one YSL member snitching is in furtherance of protecting the conspiracy, protecting the gang, Your Honor. And this would be evidence of that. So essentially it would be a co-conspirator statement between these co-conspirators.
Okay, so that's pretty much the legal part of it. Jiggy, what's your thoughts on it? I know you I know his brain is itching to get out. Some type of way you got kicked down. Go ahead. What happened? Okay, there you go.
Yeah, bro. I'm saying, like,
how you get to a restaurant that, you know what? Go ahead.
What you said?
I was like, how you get to a restaurant that fast?
Think I've been here.
Oh, okay. Go ahead.
Nah. But no, funny shit though. Like I said prior, I didn't catch that live. I only watched the replay when he spun it back. And now hearing it in full, bro, like I feel like, to me, a person that's been on both sides of shit, I feel like they're literally saying he's working with the law without saying he's working for the law. And I don't know why the state don't want to say like he's working with the law, because that doesn't I don't think that hinders his case. I think they're doing that for Woody, and genuinely. So for the defense to say shit like, or not defense, for Steele to say shit like he's a government agent, he was speaking with Gaither on a daily basis, like that, bro, that's saying a lot.
Yeah, but I found it interesting. The judge had asked Brian Steele, do you have any evidence? Brian Steele didn't try to hide his evidence. He actually told what evidence he had. He said that, let me finish. He said that he has, it's a recording where the detective said, we need you to work for us, and Woody agreed. So he didn't try to hide his, evidence that Woody's an informant. He said, Woody said on tape that I agreed to help the police. But my thing is, agreeing to help the police, but if you say he's an informant, where is the evidence that he went forward with helping the police, not agreeing to help the police?
Brother man, talk that law. Why does Steele need to present the evidence now? For the state to know they have it. Like, he doesn't have to do that. And that's all the state wants. They just want it. That's what they've been doing for the past 4 months. I feel like they really been genuinely just trying to figure out what evidence the defense has, and that.
Wait a minute.
So you fucked up now because Glanville really said like, yeah, the defense got to produce evidence and you do too. But this judge is not going for that. She's not gonna just let in, and she's not gonna say the defense has to produce evidence outside their case in chief. Like,
well, let me say this part then. So you mean to tell me Brian Steele don't want to show his hand to the state? So if Woody's an informant for the government, whether it's the states or the feds, do you really believe Love and Hylton don't know about it? They are the government.
I think they know, bro. I think they just try to be dirty, and that's why all this shit happened. that's why the defense is taking it so like to the core, because like they're literally cheating.
Okay, so now now you just kind of like help what I was saying, because if you're saying Love and Hylton already know he's an informant, then why would Brian still try to hide it from them if they already know?
I don't think he's trying to hide it per se. I think he's just trying to wait until he could really present it in a way that he has to. Like, but even before Woody took the stand, bro, he's been saying little small stuff towards him that kind of paint him in a funny light. He's been doing that with Gaither, he's been doing that with Dennis, and he's been doing that with Woody. That's why I made that comment about them three, because they seem to be in some type of cahoots. So I'm saying not to say. Say again?
No, go ahead.
Nah, I'm saying not to say. I truthfully believe the state. No, I'm sorry. The state knows for sure. In the defense, as well as their defendants know, man. Like he's been cooperating with the police, which leads to my further theory that he never ever went to the feds, bro. He just was in witness protection, and now they took him out just to help their case, and that's really why he's not trying to help them, because he put his family and his freedom in jeopardy. Like, and I could kind of see why he's moving the way he's moving.
And you got a comment here that kind of supports your position, Jerome H.
What it said?
Thank you for joining the chat. He's saying still got things that the DA don't know about.
Yes, sir. And how many times has Miss Love tried to say, "Oh, we need all the evidence that the defense is trying to present"? Like, that's not how trial works, bro. You don't need their evidence. They can present that in case in chief. You got the burden of proof. Like, you got to present evidence. The defense has nothing to do with you right now.
And you also got another person, Mr.
Nah, he called me Piggy. I see it now. He called me Piggy. He don't agree with me. He called me Piggy.
Oh, that's a typo.
Nah, I'm playing.
He tried to correct it, but it's still typoed again. His phone is correcting it. Well, we know what he's saying. Yeah, he's saying he's even agreeing with you.
On Dead Dogs, bro. After now, you played it back about 3 times, and you've seen. I'll say you played it back 2 times, and you've seen it live. After still saying that, like, I'm not gonna say you gotta confirm or deny your position on Woody being an informant, but on a scale of 1 to 10, what would you think if 10 is being an informant and 0 is being a civilian? Where would you think he is?
Well, the thing is,
nah, bro. You can explain the reason after. I need a number first.
Well, I don't think we need a number, because how would he been an informant affects the state's case one way or the other? I mean, we see him on video telling, so he need an official title. I mean, what does he need? How's it gonna affect?
He's an informant though, bro. He's a federal informant.
Okay,
like,
so
I think he told on shit beyond YSL. Like, this is just the state trying to get their cake and eat it too type shit. In my opinion, allegedly. Talk That Law does not confirm or deny anything I'm saying, by the way, so y'all know.
I mean, that's how. She said, "Thank you, Talk a Lot. Make it make sense." I mean, yeah, the fact that he's an informant, or he doesn't have an official title for an informant, I don't really see, the distinction or the big deal. I don't know. You may see a distinction, but I personally don't.
I see it clear as day, and I promise you, I did it. I was so shocked when you replayed that shit and still called him a government agent, bro. I was shocked. I promise you, bro. That just confirmed all my theories, bro. Like, I promise you.
I mean, even if she said he has the official title. If you can get that paperwork to me, we can pull it up, and that'll help support. That'll help support.
Nah, you gonna get that paperwork. Wait till the defense case.
But India is saying, what does it matter one way or the other? Let's see what Jerome H. When you listen to
it matters to the jury. Like, if he just comes in as a civilian witness, then everything he says is quote unquote, like, it could be weathered, I'll say. If he comes in as if they say, oh, this is our state informant, we're putting him on the stand, like that puts that shows that makes it look totally different to the jury, in my opinion.
Yeah, I agree to Rome H. Yeah, Love really didn't want Melnick there, but he's coming and he's going to be there on Monday. So we're going to see what happens when Monday gets here. Let's see. If they have,
you might got to delete this from the trial. I mean, from the live, but honestly, truly, bro, I really don't believe Woody had a lawyer prior to coming into this, because he's an informant. He doesn't need a lawyer. I think that was really a play by the defense to help their case, and that's just what it's doing now. Because as an informant, you don't need a lawyer. You do not. I think that was truthfully a play by the defense. Just look to see, who represented the guy in the past. They got in cahoots with him, talked to him, and that's why we're seeing everything about YSL Bump and Melnick. Like, truthfully, allegedly.
I mean, well, we're going to see. If Melnick didn't represent him, Woody could have said it clear as day in front of everybody. It would have been on the court reporter's notes. He don't represent me.
India just said he's an unindicted co-conspirator. Do you know what that means? A co-conspirator means that you participated in whatever crimes the state is saying you participated in. You unindicted is saying that you helped them. That's what that means.
Yeah, basically what they're saying is you can be sitting in that same seat with Young Thug and the other co-defendants had we indicted.
Exactly, but because we fuck with you, like, you're not on that side.
But my thing is, I mean, and I'm just going down the rabbit hole with you for a little bit.
Yes, sir.
But I'm just saying,
let's do it. Yes, sir.
Let's
do it.
But I'm just saying that what you're saying is he's an informant. He doesn't need a lawyer. Okay, so if that's the case, why did he need the immunity to be given to him? Because without that immunity, he was sitting in a jail cell.
He didn't need the immunity, bro. That's why he was so befuddled by it. Like, he knew he didn't.
But he went to jail.
Like, oh, the state don't know what they're talking about. Like, that's why he said that, in my opinion. Allegedly.
But he went to jail for the weekend. You agree to that? Or he went somewhere. He didn't go home.
He went somewhere, but he wasn't in arm's length of any real people in jail. I'll say that much too. If he went anywhere, he was not in arm's length of anybody really in jail. If he went anywhere, quote unquote, if. In my opinion, allegedly.
Yes, say everybody. His sister is an unindicted co-conspirator. Anybody connected to this case is an unindicted co-conspirator.
Dolly is not an unindicted co-conspirator. Woody is. Sledge is. Like, who's the last person they said they might get to? Like, she said and that part confused me so much, bro. Like, them saying they have 2 witnesses left after Woody, that proves like that was their star witness. She said they got potentially Sledge and who else after, like another YSL member. Like, nah, bro, I'm not going for it. I genuinely thought when Miss Whitaker asked like who's the rest of your witnesses, I thought she was about to give off a list of about 5 people. For sure, I thought it was about to be Gaither, Dennis, and probably like 2 other cops and maybe Sledge. She said potentially Sledge and whatever the other name she is from the YSL dude. Like, that's alarming to me. I ain't gonna.
I mean, my thing is, in order to save time and expedite the trial, I don't think we should get caught up on facts.
Tell Andy. My fault, bro. Go ahead.
Yeah, I don't think we should get caught up on facts that's not going to determine the outcome of the trial. And now, if he's telling on tape, we got police interviews. Him talking, he's talking on the phone. I mean, without an official title, whether he's an informant or not, I don't think it's going to sway the trial, one way or the other. And I know you're saying the jury's going to look at him different if he's an informant. I mean, you can still be an informant and lie because you want to get yourself out of trouble. So I don't think that's going to affect anything.
Yes, sir. Excuse me. I'm saying though, if the state presents him as a civil witness as opposed to a federal informant, then it helps their case a little bit. And when they have no case, that helps a lot. That's what I'm saying, bro. They have no case right now. So him being a civil witness and saying what they need him to say, that helps a lot, as opposed to him being a federal informant and seeing him need to say. But I was gonna ask you, tell India pull up, because I'm not about to. I can't see the comments too much.
Right. The brand of this man. So okay, but you do got somebody that's hold on. Love and Hylton know Woody an informant is why they had the
exactly.
Okay, you got some
I really don't think, as a lawyer, I think like there's a difference between a federal informant and a state informant. Like it varies, man. Like there's different levels. Like I truthfully don't believe he was a state informant. I believe Hylton and Love knew he was a federal informant and just thought he was so scared of jail that he would just help them so much, but that just hasn't proven to be the case. I genuinely thought that's what they thought. They thought he was a federal informant. Say that again, bro.
No, but I mean, even if he is the federal informant, the feds work with the state. They partnerships, so they can easily call the. Hold on. They can easily call the. I'm gonna miss it. We don't cross over each other. They can easily call the state's attorney's office for the feds and say, "Hey, what kind of paperwork y'all got on Woody? He's gonna be a witness in one of our RICO trials. Give us everything y'all got." I mean, it's not hard. Go ahead.
Oh. My doggy. Let's role play for a second. If you work for the feds, right, you would care about anything Hylton Love saying about any shit, about any case.
Yeah.
Don't do that to me, Talk That Law. Be for real, bro. All right. You might. Oh no. I'm sorry. You might at first, but after 50 days of this trial, like, how you gonna feel about Hylton and Love?
I mean, you gotta remember they all going after the same
brother man.
Hold on. Let me finish the answer. Y'all gotta remember they all going after the same group of people. Woody done been in trouble with the state of Georgia. He also been in trouble with the state of Georgia by way of the feds for the gun charge. So they are working together. Matter of fact, when Woody was caught with the gun that sent him to federal prison for 5 years, the feds didn't catch him with the gun at the gym. Guess what? The local police caught him with the gun at the gym. And guess who sent? And guess? Oh, let me finish. And guess who sent that case to the feds? The state. So they work together. Go ahead,
bro. You said the state gave that case to the feds, right?
Right.
And they never got the gun, right?
How would the states find out about it when the local PD showed up at the gym? The ATF didn't show up to a local cop. Look, let me set it up right quick. It's alleged that Woody went to a gym with a gun in a bag. Guess what? Somebody called the police. The ATF didn't show up. The FBI didn't show up. Guess who showed up? The local Atlanta police show up. And guess
no. You're fake wrong.
Look, and guess how the feds find out about cases? The states pass it on to them. But go ahead.
Nah, I was gonna say you fake wrong, bro. Yes, I think Gaither and Dennis showed up for the whole
No. The local police show up first. The street police.
Let's all right. We're gonna say APD showed up first for the whole
regular cops.
Gun. Yes, sir. And then what he say though? They brought him to Turner Field, and when everybody pulled up, and then the next day get a 9-hour interview with. I'm not gonna say I don't know who was there, but to me, it would look like whatever cops was there, and he made a formal statement. That's what it looks like to me. and I've been saying that for months, bro. I really feel like that 9-hour interview with APD, with ATF, with fucking federal police. That's when he became an informant, bro.
Yeah, well, I will say this. I mean, you may not. You might dance around the argument, but we all know when you call the police, the feds are not showing up. The first people that's going to show up are going to be local officers. You know that. I mean, can we agree on that part?
Dog.
Can we agree on that part? Okay. So then they show up and they find a gun. Do the feds magically know that they have a gun?
Bro, it was after Nuts. That was after Nuts' murder. Like, and it's funny. Like at that time, I don't know where Funny was. I don't know if she was. I don't know even know she was now. But I don't think she was as high as she is now. But if a high-ranking official like has a murder that they know about, like they're gonna sway some type of way, bro. And I really did feel like that was what Funny did. I'm not gonna say I really faithfully believe the rumor of her and Nut was like romantic together, but I think they was friends. I'll say they was cordial.
Hey, I got you right here. Give me a second, and let me try to get through this so it don't the volume doesn't.
Yes, sir.
Here's the article, and once I'm done, then we can unmute it. Here's the article: felon sentenced to federal prison for gun possession. Let's go through it real quick. Kenneth Copeland, that's Woody, was sentenced to federal prison in 2018 for being a felon in possession of a firearm after bringing an assault rifle until the Dunbar Recreational Center gymnasium. And they say our community centers are designed to be a place where the public, especially our children, can safely play and gather together. This from the U.S. Attorney. This is the feds. By bringing a loaded assault rifle into
That's
a
the
gym.
feds, right, bro? That's the feds, right, bro?
Let me finish. By bringing a loaded assault rifle into the gym, Copeland put all those present in danger and took the community its sense of safety. Okay, but let's go. The illegal possession of a firearm is a crime in of itself or itself. And this ATL, that's the feds. So we got the U.S. attorney, the Fed lawyer, and then we got the Fed agent. However, taking a firearm into a place where children are present and leaving it in plain view, recklessly endangering everyone is shocking. Okay. So let's get right here. Let's get to this paragraph. There's no place on our streets for guns to be in the hands of convicted felons, and certainly no place for guns of any kind to be in a place that's supposed to be in a safe haven for many of our children. Said who? Said Atlanta Police Chief Erica Shields. She goes on to say, this is great. What? Teamwork by our officers in the U.S. Attorney Office to once again, so they've been doing it once again, assist us in getting dangerous and irresponsible individuals out of our community. So we got it right here that they partnership is teamwork, and once again, so they always assist each other. And that's the Atlanta Police Department who originally got the call, and they brought in the feds and also.
Why they bringing the feds for that, bro? Why they bringing the feds for that?
Because it's a federal crime to have a gun in a public.
Okay, yes, sir.
By a convicted felon, and you can get more bang for your buck because in federal prison you got to do there and there day for day. So and then look down here.
You think they wanted Woody to do mad time for that? You think that's what you think they wanted? You think they want Woody to do mad time for that?
I think the max penalty is 5, and they say Copeland, 27, Atlanta was sentenced by the judge to 5 years in federal prison. And not only that, to be followed by 3 years of supervised release.
No way. No way.
So, I mean, if we do the time, let me see. He pled guilty to 1 count on July 18th. So 18 plus 5 is 23, and 23 plus 3 years of federal probation. So right now, I'm gonna do the math with you. Federal probation.
I'm gonna do the math with you. As soon as he got out the feds, allegedly, that's when the YSL RICO came, right? I won't say as soon.
No, because he got out 23. The RICO was already going on because one of them was
he got on in 2023.
It's like 18 plus 5.
See this right here tells me he was not in the feds, bro. I'm not gonna lie to you. This tells me he was not in the feds.
But you gotta remember, Fonnie Willis was already working on that case. Because
Fonnie Willis, right? Yeah, and another thing, bro. I'm sorry, go on.
No, I said one of the defendants been in jail since December 2021. That was even before Woody was out.
I'm gonna say, bro, like this paperwork and media article shit, that could very much be just thrown to somebody by somebody. Like, I wholeheartedly believe this article, I'm not gonna say it's fake, but like
article fake.
An article can't be fake. And I'm gonna say,
let's look at the website. Let's see.
I worded it wrong. I ain't gonna say the article is fake.
It's an official website of the United States government.
Yes, sir.
It's the U.S. Attorney's Office of the Northern District of Georgia. Anybody can look this up. This is a justice.gov website.
Let me retract my statement. Let me retract my statement. I'm not gonna say the article is fake. The article is not fake, but I will say people could put fake shit in the article, bro. Like if they don't wanna, you heard numerous times. I'm sure you heard the interviews he was saying in, like, I don't want my name to be in no paperwork, X, Y, and Z. Like they do shit like that to help you out, bro. Like they do that really happens. I've seen it happen. So for them to put that out, that doesn't necessarily mean he's not a snitch, is what I'm saying.
Yeah, I hear what you're saying, Jiggy, but at the same time, we got no
So
paper. We can't change the facts.
Yes, sir. So Mr. Steele calls some informant and present evidence. You gonna bring me an apology?
What you mean?
What? Yeah. What? Now that's what you mean. All right, Woody. When
Oh,
Steele.
so now I'm a detective now. What Woody say? Now I'm a detective now. I'm Woody.
Detective Copeland. Detective
I'm
Copeland.
Woody.
Detective Copeland. When Steele present the evidence that show you've been working with these people for years, you gonna grant me an apology, right?
I don't think.
Oh, he not. Oh, he not. Oh, I thought you was my dog.
Bro, look, you're not understanding what I'm saying.
I promise you I do.
Or let me finish. I'm not saying he's an informant or not, but I'm saying what difference does it make? What significant difference does it make? And I'm not getting that answer from you.
I'm saying, in my opinion, I think if Hylton and Love put Woody on the stand as a federal informant, excuse me, as a federal informant, that means like that looks way differently as opposed if they put him on the stand as a witness to the crimes or a person I've been around. Like I genuinely feel that way.
Oh wow, what happened? Where he go? Hold on, y'all. We done lost Jiggy. Well, we got somebody else that's popping in. What's going on, India?
Hello.
Thank you for joining. What you got on your mind?
It's the conspiracy theories for me, like.
But don't do Jiggy. Hey, Jiggy been like this since he first been coming on. He always think outside the box, so I give him a lot of.
That's great.
Leeway.
That's fantastic. But it also has to be based in logic. Like it has to make sense. Like, first of all, him being a snitch, okay, anybody could be a snitch. Anybody who knows who knows something or is involved in something or whatever could be a snitch. Everybody that's snitch is not an informant.
Right, exactly.
Like a certified informant. Like that's like an actual, like, some of them actually get paid. Like there's all type of things like for an actual informant.
Right, you had a good comment.
And then number two, if he's knowingly an informant, knowing that they're trying to put together a RICO, there's no way he wouldn't have thought he had to testify. You wouldn't have to trick an informant into testifying. They already know they're setting somebody up. Like,
they know the jury, right?
Yes.
They know what they signed up for.
Yes, he was talking. It was self-preservation, period. It was self-preservation. That's it, and that's all. It wasn't like, I don't know. It's just not all these conspiracies. It's just not. And him being informed, like we all know, still uses colorful language. Something like him being an informant is not something that would need to be hidden. To be completely honest, if he was an informant, I feel like the state would have said it. It wouldn't be a secret.
Yeah, and I don't think Jiggy knows that.
It doesn't benefit or it doesn't help or hurt the state or the defense somebody's status as an informant.
Right, and I don't think a lot of people are aware that a lot of times the feds in the states they work together a lot. I mean, they do a lot of press conferences together, partnerships, because they want the same thing. If we can't get you with the state charges, then see what the feds can do. Right, and if the feds can't do it, the feds say, "No, this RICO is too sloppy for us." Fannie Willis, y'all, if y'all want to try, y'all take the chance. We don't want to lose as the feds because we keep our conviction rate high. But we assist y'all from behind the scenes. What can we do? Y'all need us to charge somebody to put pressure on them, and then they take an agreement, and then we'll drop our charges. I mean, it's all type of stuff that I see that go on. So for Jiggy to say that they don't work together, or Hylton or Love won't know about him being an informant, oh yeah, they would know, especially by now.
And then the thing about the gun, the reason why he got out in 2019 was because he already had time served. He was already he had already been arrested, so he was still in whatever jail he was in, but he was incarcerated until like he signed the plea, and basically he only had that. So he signed the plea in 18, and he got out in 19 because he already had time served. That's why he got out in 19. And then I don't even think he's on supervised release no more because that was 19. It's 24. So.
Well, I have heard in some of his like some of his Instagram lives, he does mention the fact that, hey, I gotta chill out. I'm on like some type of
He tells
paper.
lies.
He could be, but even if let's say his sentence is, and it could be different for the federal level. Let's say his sentence is 5 years and he get out early on parole. So you're on parole, you still gotta finish out your full 5. So it could be possible that his full 5 finish in 23, and then the supervised release starts from 23, 3 years after that to 26. So I don't think just because he got out in 19, if that's the case, his supervised release would start right away. He would be on parole, and once that full sentence is done, then his second part kicks in. But in any event, I mean, that's neither really here nor there.
Yeah, it's not either here nor there. Yeah,
because I don't see the difference as far as what we're trying to get to in this trial.
I personally don't think that it was nothing to hide. Like, I think he was just saying that because that's how he feels, that he was an informant, but he wasn't like an actual like informant on paper. He was just somebody who was cooperating with the police, had an ongoing relationship with the police. But he didn't. Hello?
Oh, yeah, I can hear you.
But he didn't have the ongoing relationship with them just because. He had the ongoing relationship with them because he was always in trouble. And he always had to use it as like collateral or leverage to get himself out of stuff.
So D, you're saying D said that he is still on the books to report to his PO.
How you know?
D, how do you know that? Probably his ties to his other channel. And and Woody stay over there on different channels, and so D got the inside.
But yeah, I just don't think that's nothing to like lie about or keep hidden. Like, that's not really his case in chief. It's not going to make or break his case whether or not their main witness was an informant. I think they would have been like, if they had proof of that, they would have been put it out there and been put it on the record. If you ask me, like, but who am I? I'm not a lawyer.
No, you're right. We just all just talking. We all just trying to quit.
But is that true though? What do you think? Well, what do you know? You're a lawyer.
Which part?
Do your clients have people that are informants, like real informants?
Do my clients have people that are informants?
That are testifying against them, that are actual informants? Like, is there like a paper trail? Like, do they sign some type of contract or some type of agreement? Like, how does it work?
No, I don't have any clients that's informants that work for the government.
No, that
what you're asking?
Testifying against them.
Oh, no. And if that was the case, we wouldn't know about it. Now, let's say somebody told on your client, my client, and I'm just talking in general terms, so we don't get too specific since I am practicing. If somebody tells, it will be part of the discovery. They have to turn that over to you, so it won't be a secret. But I haven't had a case yet where I have a secret informant or somebody that's telling behind the scenes. Oh, we got both of them popping up. Both of them coming. What's going on,
D?
What it do?
My dog.
What's up, family?
Nah, India though, for real. So if Woody, based on your logic, right? Do you not understand how would it look for a jury if Woody is a civilian witness as opposed to a federal informant?
I would think they would think the federal informant's more credible because the federal informant has some type of rapport or relationship with the police. They're basically a cop, literally. So
a federal informant.
I think they would consider them to be more credible than a civilian witness, to be honest, especially a civilian witness who has relationships with these people. Like, it's not like it's a random witness who just happened to see something. He knows these people. He was affiliated with these people. He called some of them his quote unquote friends, his bros.
ma'am.
So I think informant
my
that
bad.
would give him credibility.
Okay, go ahead, Jiggy. I'm just meaning not to silence you, but to put a feedback. Well, go ahead. Go, Jiggy. Jiggy.
And now I was gonna say yes, ma'am, but honestly, realistically though,
thank you, Kimberly.
He doesn't work with the state. Like, yeah, he helped Gaither and Dennis. They moved on from the department. He works with the state now. Like, that has nothing to do with Hylton and Love, in my opinion. So for him to be a
You mean the
federal
feds?
informant, say again?
You mean not the state but the feds?
Yes, ma'am. So for them to put him as a stand as a civilian witness, I think that helps their case as opposed to say, oh, this is a federal informant that's genuinely scared and threatened and intimidated by all the rest of the co-defendants of YSL. Like, I think that helps their case a little bit.
What's going on, D? What's your thoughts? Thank you for popping in. I ain't seen you in a while.
What's up, my lord?
At least not on at least not up. I know you've been in the chat.
Yeah, I ain't been popping out on my face. I be behind the scenes. I gotta stay in the chat, man.
Hey, but you got information. She was trying to figure out how you know that Woody's still on papers, if you know.
Well, first of all, he said it because before his birthday, he got the rolling around. He said that his PO was gonna have a problem with him going to the club drinking or whatever. So he alluded to that multiple times.
I thought so.
In the ex parte, it was Miss Hylton made him aware of the statute of limitations on some of his charges that he previously was fighting. So he didn't want to end up admitting to those same charges that were that the feds was gonna pick back up or whatever. So he didn't alluded to him being on papers many a time. So it wasn't. I think it was common sense for everybody that he was still on papers or whatever.
State papers or federal papers?
Huh?
You don't have to be on papers for them to come and charge you with something. If you do something, they can come back and charge you. You don't got to be on paper for you don't have to have a parole or probation violation.
The point of him being on papers was the point because he has rules and regulations of what he can and can't do.
I know that, but he's also a liar.
Yeah,
bro. I really don't.
All right, listen.
Hey, hold on, y'all. Let's do it one at a time, because the feedback is crazy.
What do we get out of him believing that he's lying about that? That just fits our narrative. Why can't he be telling the truth about that?
About being on papers?
Yeah. Well, what purpose do he serve
because
by?
That makes it seem like, you know, he's still in trouble, quote unquote. Like, I don't feel like that's the case. I don't think he's on no papers. If he's on any papers, it's because he's an informant. I don't think he's in trouble with the state. I don't think the Fed want to touch his case because he said too much to them. Like, I think
if you watch this whole interrogation, he alluded to well, why would I snitch again if Shannon didn't snitch and y'all got him locked back up? And they said Shannon been doing too much.
Say that again, bro.
When he was in the interrogation room, when he was when they was asking him for information or whatever in his 9-hour interrogation with the police or whatever, he was telling them, like, what about Shannon? Like, why would I continue to snitch to y'all if Shannon didn't snitch and he's locked back up? And they said, well, Shannon obviously did too much. Right after we let him out, he went and robbed somebody and all that. So I don't what? Speak your mind, what?
Nah, so now you don't think Woody a Fed no more? That's what you saying?
I don't think he a what?
You don't think he a federal informant no more? That's what you saying?
Yes, he's a federal informant. He's a state informant. Woody's already alluded to. He gonna say whatever he gotta say to get out of his situation. Now, I don't think that he had intentions on going on a stand, but at some point he knew
at all. The state, I don't even think the state had the intention of putting him on the stand. But I think yes, sir.
Okay, listen. You don't make someone your star witness and you never had intentions on using him on the stand. He is a star witness. You know what that means? The term star, that adjective is there for a reason. That means,
bro, they said they had 2 more witnesses after him that got nothing to do with nothing. He was their key to this case.
I agree with you about that because they wouldn't have given, if he wasn't a key witness, he would have never got immunity.
Correct.
They need his testimony.
Not even that though. They gave a lot of niggas.
It's exactly that. They need his testimony that bad.
No. I was saying
they were willing to give a criminal immunity.
No, I wasn't saying that specifically. I was saying I feel like they gave a lot of people that shouldn't have immunity like leeway. Not necessarily full immunity, but like slick, like every other person that claimed YSL that told, like I feel like they gave some type of deal to them. But no, his immunity is crazy because I feel like they know what he did, and that's why I feel like he's a federal informant. That just brings back to my
Well, I think they gave anybody immunity that has actually did a crime and was able to, when they were able to say, hey, you pled guilty to this X, Y, and Z beforehand, and now you know what I'm saying, you on this RICO case as a witness.
Okay, can I get something when y'all are done?
No. I'm saying though, like they didn't give everybody immunity though. They gave for whatever reason they gave the people that committed like the most heinous crimes immunity.
But that's why I think that was a smart tactic. If you got people who actually committed crimes convinced to go on the stand and say, hey, that's my boss, I'm YSL, and I did a crime. That's their whole little play that they wanted. That's why they gave the people with.
That's fair, but nobody has done that so far.
Hey, go ahead.
Now they banking on who's the person they said besides Sledge? Who's their last witness?
Well, I don't remember their last witnesses.
Hey, go ahead, India.
They said they got Sledge and somebody else.
Zachary, whoever's last name is
Zachary. That's the other Quaid. That's the other Quaid.
If I personally, I think that they expected Detective Dennis and Gaither to give them more than what they gave them.
Bro, I was saying that's really who I thought they was about to name as the two witnesses to come back to like just kind of quote unquote back up all Woody statements, and they didn't even say that. That's how I know, bro. This shit is finished, bro.
Yeah,
they're just trying to bring two other Woodies in that's gonna do the same shit. Like it's not gonna work.
let India jump in real quick. Go ahead, India. You had something to say?
Well, I was gonna ask, who else did they give immunity to? A plea agreement is not immunity.
No, yes, ma'am.
Especially not a 20-year plea agreement for a street person.
And
that's far from immunity.
Yes, ma'am. But now that's what leads me to believe Woody is a federal informant further, though. A state witness, a state co-conspirator, they don't need immunity at all. They're just working with the state. A federal informant, yes, they might need immunity for some shit.
So what case you think he's spilling tea on? What case you think they built in?
The murder of Donovan Thomas. Like that's all they trying to get in.
The feds ain't picking that up. That is a state case. The feds are not picking that up.
Well, I mean, the Fed, even though I think India is right, but the feds can pick it up, and that's his whole play that he was scared of.
But they're not. If they were going to, they would have already. That man been dead almost 10 years.
Listen, you're smarter than Woody. Woody's not, he doesn't have your brain cells. Woody is.
He ain't dumb either. That's why people falling for the okie doke. He ain't dumb.
Listen, if y'all think a man that sat in a 9-hour interview is not dumb, y'all are crazy. Like, he's been in the system long enough to where he knows more than the average person about what he's doing because he's been in it. But Woody is not smart at all. No man has to be in it. Should be.
He ain't dumb. He ain't dumb. He's
dumb.
He's smarter. He think he's smarter than what he is, but he also ain't dumb.
Woody is dumb. Any smart man would have got out of this situation without talking in front of the police for 10 hours and then getting mad because people calling you a snitch. Like, the logic is not there.
Not a person who thinks that they could finesse people.
In the history of the feds, who has finessed the police with a 9-hour interrogation video saying, I got who gonna kill Shell Kill tonight. I'm gonna help y'all.
Fed cases ain't televised, so we wouldn't know.
Fed cases don't have to be televised because they getting your time. They don't want you in there to snitch on nobody else. Once you in there on a Fed case, they got you. You they mans. The feds don't. Say that again.
You said an informant. What smart person or informant would sit in a 9-hour interview? People have done it. He ain't the only one. He ain't the first. Ain't gonna be the last.
I'm sorry for cutting you off. An informant would definitely.
We might not know about it, but if
became
you
the
think
informant during a 9-hour interview with Atlanta police, with ATV, with the feds, that's when he became the informant. Directly after the Nut murder. That's when when he got boomed on in front of his kid and baby mother, that's when he got scared and was like, "Oh, I'm telling on everybody." He was snitching before that, but when that happened, I was like, "Oh yeah,
Listen
I'm
to this,
telling
y'all.
everything."
Listen
Like,
to this, y'all.
That's what
Y'all,
happened.
This is the person y'all calling smart. After Nut died, Woody went back to a set of apartments and went live on Instagram.
That nigga is a.
He was probably establishing his alibi.
Bro, he not. I ain't gonna say
He went
on
dumb, but
Instagram live and
he's
bragged
not
about
as smart as people trying to make him out to be. Like he just knows how to play the system. I ain't gonna say he got a GED or I'm gonna say he got a master's degree in the street. He got a bachelor's, but he not as smart as people making him out to be, bro.
Well, I will add this.
He just knows how to finesse the system. I'll give him that much.
What'd you say?
Where is Woody at right now?
In Atlanta.
In a hotel surrounded by mad security. That's where he's at.
So, security, money in his pocket, and
unlimited security,
and 100,000 Instagram followers. But look, where are the other 6 people at?
Yo, bro.
Hold on, Gigi. We can't talk at the same time because of the feedback. But let me say this: where are the other people? They sitting at a defendant's table. There's 6 of them in jail for years. Not Woody. They could have got Woody if they wanted to, but guess what? They didn't. So Woody got some type of sense in his head, and that's my opinion. Go ahead.
Exactly, I agree.
You calling it sense in his head? That's what you calling it? You calling it sense in his head or snitch in his head?
Right. He ain't a rocket science, but he ain't no fool either.
I'm saying though, like I don't think he's not stupid, but he's definitely not as smart as people are trying to make him out to be. I just think he found a way to finesse the system. Like I said, I think he's a federal informant, and Hylton and Love try to use him as a state informant, and he wasn't rolling with it because that jeopardized everything he got going for him. I don't believe he was in the feds for the third time.
I got a rebuttal for.
Say again.
What you say, India?
No, I have a rebuttal for that when he's done.
Okay, but look, they gave the star witness immunity. So Woody, not only he did
the only person they gave immunity, right? That's the only person they gave immunity, as we know.
Right, but it wasn't a guilt; it was forced upon him.
Okay, so let me ask y'all this: if Woody is so smart, what was so confusing about the immunity to where he thought he was gonna get on the stand and not have to say nothing, and he gets sent to jail?
No, bro. He said himself the state don't know what they're talking about when they hand on the immunity sheet, and that's why I think this is a whole play from the defense, bro. This is a play from Melnick, Bumpus, and Steele's camp. Like they know the state did some wrongdoing, and they're just trying to exploit it beyond. And everybody keeps using the word dramatic. I think, they're trying to exploit it dramatically because they know it's wrong. Like they also know he's an informant, but they also know what the state did was kind of not how a court proceeding is supposed to go. And that's why they're trying to exploit it.
Jiggy, and everybody's talking about how Woody's smart because he's out and they free. But Woody has did so much time. These folks only been locked up since 2022. This is going on 2 years.
Woody did that much time, bro.
Woody ain't did much time for the shit that he's done. That nigga ain't did a lot of time at all by a long shot. That nigga ain't even did 10 years.
Listen,
how much time do you think he did?
He ain't even did 10 years
How much time do you think he did, India?
And let's try to, if we can, with the language so they don't pull the video. But go ahead.
What? I'm using bad language again?
No, you was good. I was trying to tell India with the.
Yeah, sorry.
No, you good. Go ahead.
But like I was saying, I lost my train of thought.
Let me
hear.
What
did you say?
Nah, you trying to say why would he?
I was saying he didn't. He did what, like from 2015 to 2019, and then his other little stints been a year or less, or a year give or take. Like he ain't did a lot of time compared to all the crimes he's done. He's been caught with multiple guns. He's did a lot of shit. He robbed or stole. He did all types of, he got a long rap sheet. He has not did a lot of time in comparison to his arrest record. He's not no federal informant. If anything, he was a state informant to build this RICO off of. If anything,
he's not a federal informant. He can't be a state informant. They would not need to do all this X, Y, and Z if he was a state informant. Hylton loved.
And you think they would if he was a federal one?
Say again.
You think he would have to do more as a state informant than a federal one?
I don't think he has to do shit if he's a federal informant. That's why he's acting this
way.
But
that's not true. That's not true.
That is true. If it's not a Fed case, he don't have to talk to these people about nothing, and they don't have to force him on the stand. But the fact they did, that shows they trying to be tricky. That shows they trying to trick him, and I'm not gonna say he's smart, but he just knows he doesn't have to put up with it. And also to add to that, I feel like he knows he snitched on these people back in the day. So now this is his saving grace period.
He's trying to redeem himself, but he can't. You
Hey,
already said.
He
You
could.
already said what you said.
He is because
You already. He's trying to, but he can't. You said
I
what you
think
said.
I'm not gonna say like he can't come back from snitching, but he really
He
might.
can't come back from snitching.
He cannot. You're absolutely right. I agree 1,000%.
Hey, let me say
Go
this.
ahead.
I will say that well, he possibly could come back. I mean, we've seen a good comeback with who that
It
got
depends on how you define a
This
comeback.
nigga talking about 6'9".
Hold on. Let me finish. So we came back 6'9". Who else? Gunna. When he first came out, he had snitched this and that. Now they lining up to go see Gunna. I know some people still say he might be a rapper. People are falling over themselves. Or they say, oh, he got a hot song out. What is it? F you mean? All that stuff.
Nah, bro. You absolutely right. But in their cases, Woody didn't have no career before this. Like his career was being a gangster. Like that was his career before this. So he was not a rapper.
People who ain't in the streets don't care about somebody being a snitch, or they don't really see. First of all, a lot of the people who support him don't even necessarily know him.
Who support him though?
Everybody.
Like YouTube, that don't count.
It's a lot. They love
YouTube
Woody.
don't count.
They love
baby.
Woody.
YouTube
You ain't been
don't
on TikTok.
count.
You ain't been on Instagram. They love
Yeah,
him.
He blocked me on Instagram, and now I'm being on
selling his
TikTok.
little shirts. He
They-
had his
yeah,
little
they
birthday
shit now?
party.
Listen,
selling merch.
Let me say this.
Go ahead.
Hold
on, Jiggy. Go ahead.
In my opinion, Young Thug, until Young Thug say something, it's gonna be what's going on. The only reason why people are still at Gunna is because he signed to YSL, because ain't nobody said nothing about Woody. The whole angle about Caleb being cool with Thug and still being his lawyer, that's what's saving face right now. Until Thug say something, all this gonna go on. This ain't famous. This is just clout. When you really get money, the industry gonna help you.
Jeff already said. I'm gonna say one thing before I say the next thing.
I'm gonna say his Young Thug's dad is going to the concerts of.
He went to one don't do that.
And they
bro.
dance, and not only when they dance, but hold on, hear me out. I want to say this: not only dancing, but my thing is, what if Young Thug had an agreement with Gunna, like, hey, you get out, because even if you take a plea deal, you're not gonna be able to come on. You're not gonna come on the stand and say nothing against me. You go out and make some money for the camp, bring it back, and then help me keep on fighting so I can get out. I mean, that's logical.
On my mama, that sound mad good. On my mama, that
That's all I do is sound good.
But
Why?
hold on though, when Lil Baby like
that's what I say, Jiggy.
Disgracing this dude like every chance. I don't think every chance he get, but often he done did it more than twice. And then Young Thug double back and said whatever Wham said goes. Like I don't think he rocking with Gunna, bro. And Dolly said too. They really can't like. Based on the case they got, they can't.
Jiggy. I'm gonna help you out, Jiggy. Jiggy, I'm gonna help you out. Let's just use our common sense. If Young Thug kids are making a song, putting these people names in it, that goes to show you the conversation.
Smoking on nut. That's wild.
I mean, but yeah, you got the kids and you got the dad. I mean, so it's all
No, but I'm saying if to put that out there, like that they were able to get a hold of that. Like that was streaming. I mean, that was going around the internet for a second, and some of the lyrics in there, it mentioned Gunna, mentioned Nut, and all that. So they heard this in some privacy, in the what I'm saying, in the rooms of private conversations.
Well, we don't know that, right? They could be watching. They could be watching social media. We don't.
Okay, but listen, it's just use your common sense. If you in jail, your kids outside making a whole diss song about this dude. Everybody know Lil Baby is the only one that's really backing Thug up while he's doing the groundwork right now. If Lil Baby has came out and said Gunna is X, Y, and Z, why wouldn't we also adopt that? If Young Thug hasn't said nothing but Wham says go.
But we got to remember
I'm sorry, bro.
No, I'm saying this all when it first happened. Everybody seen the tape of Gunna saying yes, ma'am, yes, ma'am. Everybody thought he was, but now it's more understanding. And of course, Young Thug is not going to come out and say, "Hey, me and Gunna cool." In front of the DA's office, that don't make sense.
Why not? And Gunna defense, like he did bad, but he didn't do as bad as Woody. Like he did bad though.
Listen,
he definitely did bad, but he didn't do as bad as Woody.
Listen to this, because I'm from Memphis. When these boys, before they went to jail, Young Thug, Yak Gotti, and Gunna, they got a song called "Take It to Trial."
And that's my shit. That's the joint.
Do you know what that song means? Does anybody know what "Take It to Trial" means?
Yo, bro, I've been saying for so long.
You've been talking to somebody that have been to trial many a times. But go ahead, Jiggy. I know what it means.
Nah, bro. I was gonna say when like the whole time the Slime Language project and Doug's last project, what was it called? I think Punk. I think he genuinely knew, bro, like this was coming, and a lot of songs kind of paint it in that light, and even still trying to introduce the Dropping Jewels video as evidence, and them not letting him. That told me a lot. Like Young Thug knew this shit was coming. Like he has Brian Stale as his lawyer for like damn near 10 years. If you're not encountering or dealing with no real quote unquote real street problems, like or crime problems or legal problems, I'm not gonna say crime or street. I want to say legal problems. Why do you need Brian Stale as your lawyer for like on a retainer for 10 years?
Wait, what? Why everybody want Jiggy to come down? They saying he's drunk and on a beam. Jiggy, you ain't drunk.
Like, what's up with them?
Wow.
They mad.
You don't look drunk to me.
They mad I'm presenting a shining light. That's all. I'm cool with it though. I told you I'm not coming.
Right, you got it right. Yeah,
I'm chilling. I'm chilling. But yeah, back to what I was saying though. I really feel like still he fake knew. Like he knew what this was gonna turn into. There's no way you have a lawyer on retainer for 10 years and you're not dealing with no legal problems. Like, it's no way.
I found it.
Most celebrities or even people who have a certain amount of wealth or whatever keep a lawyer on retainer. That's not out of the ordinary.
Young Thug is not gonna get Brian Stale on a retainer unless he has some like
why not
serious shit going on.
I found it interesting though in the transcript. Woody was trying to find out not only about state immunity but federal immunity because he want to make sure that the feds can't come back.
Because
hold on. Let me finish. Let me try quick. Because he want to make sure the feds gonna come after him from that gun charge when he was shooting back in self-defense. But my thing is, why is Woody concerned about getting a federal charge if he's a federal informant? I mean, obviously they're not going to charge. Hold on, they're not going to charge their own witness if he's working for them. But Woody is concerned about getting charged with that gun when he shot back at the people that shot at him and his family. So that's my point on that.
I love that you asked that question. I genuinely believe that's a case that he didn't tell them about. Like that could be the only logical reason. Like
he don't even tell them. They would already know.
They would know.
What you mean they would know? No, they wouldn't. What the fuck?
Just how we can look it up and see people's arrests. The feds have even more information than that. You think they just run your ID because they like your picture?
You think because why do you think they knew instantly who he was shooting at or shooting back? Like, why do you think the feds know that?
No, he at work. I don't think he's at home. That's not his ceiling. They say yeah. I'm helping you out, bro.
I'm in an establishment.
Yeah, I'm helping you out, bro. They trying to say that's your house.
So y'all think Woody was being smart when he was in his girlfriend's car by himself with a gun that he had previously got on the streets because he knew he had already had a gun case. So he was being followed by the police, got away from them, parked his girlfriend's car, left the gun in there, and got to walking down the street past the police.
That sound real miraculous, don't it?
So what's that point? What is that proving?
That he's not smart for one.
They've been following Buddy, bro. Like he's been working with them.
Nobody said the nigga is Mensa. Nobody said he's a Harvard graduate.
No, like he ran from that gun case of him going into the gym and pretending like he was already there with the bag over there across the room away from him. He did all that for a reason because once they got him, they was able to use that and hang it over his head for a Fed case to get whatever information they wanted out of him. So I don't understand how, for one, Woody's not a snitch. I don't understand how he ain't dumb. I don't understand, like, this case wouldn't be here. We wouldn't be here. Woody is Rico. We wouldn't be here.
Literally.
I don't know, because look, Woody convinced the state to build their whole case around him, to put their trust in him. I'm going to be y'all star witness. He built it up. He propped it up so good. And let me finish. And guess what? He's going to be the same person to, not only did he get immunity to protect himself, but he's going to be the same person to go into court and say I'm lying, and he's going to be potentially the reason that the other 6 go free. So you can't tell me that's not logic. That's really good.
It's not. See, look, the
Pete, bro, Pete, that's how I feel,
state,
right?
the state,
Go ahead, D, go ahead.
Hold on, one at a time. Yeah.
The state set him up from the beginning. The state told the jury after she got to talking about the Jungle Book, she said it's gonna be many YSL witnesses that come in here and they gonna corroborate what we're saying. How they act, I don't know. So she already knew that she was calling these YSL members in here who had already been through stuff, and that they probably was gonna not cooperate with her. So that was their whole play from the get-go. So the fact that Woody got here and all and did that, that's not smart on his end. They already knew he was gonna do that. All they needed was Donovan Thomas' family to be in there. The promises that they gonna find the killer. They didn't want Woody to say he actually did it because they know he did it. They want Nut family to know Woody did it. They just want to prove that he did it for these folks.
Nah, they just want closure. They don't care. They don't care who did it. They just want to give their logic was to give the Thomas family closure, and they never did that. That's why I was in the comments earlier.
Okay, so
this whole case is fucked up.
Who's gonna be held responsible at the end of the day? That's what I want to know. Who's going to
Say that again, bro?
Thug. They want Thug.
Woody won't be in jail.
Woody not. So who else?
Nah, what was your question, bro?
No, I'm asking D. I said, who's gonna go to jail at the end of this? I mean, we got all this.
Shannon, Yak, and Thug. That's who they really want to go to jail.
No, I'm saying, but who's going to go to jail?
Oh, nobody's going to end up going to jail for it.
Not nobody. Not nobody going.
Why do y'all think
you go?
Why do y'all think it was such a big thing that Nut's father heard his son say who killed him and all that? Like, all that was a part of it, but it didn't come in because it really wasn't true.
So cap, bro.
But, hold on. My thing is, if that's true, they put on a big show just for the family gets some closure. At the end of the day, who's going to jail for it? Who's going to get found guilty?
Bro, that's what I was saying. This is
nobody.
Nobody. The family. What I said earlier. I said
they wasted millions of dollars for what? For nobody to go to jail. But go ahead.
I'll wait for y'all to be done, and then I got something to say.
Go ahead, India. You go first. And
after this, Woody is not. Y'all think Woody's gonna get left alone? Woody is never gonna get left alone. Woody is the one who did it, and they know it. So it won't be proven on paper who did it to him. But trust me, after this trial, they going to mess with Woody, bro. Somebody going to mess with Woody.
Yo, bro, I didn't even think about it now. But why is show? Go ahead, bro.
No, go. It's your turn. Go ahead.
I'm saying though, I was just thinking about it now. Why is the only conflict they have with Thomas's brother Shelkel compared to Woody? Like they know he did something, and now I feel like they know he lied about it, but they like their lies. They like his lies so much that they're trying to get him to ride on it. They're trying to say, oh, he sent us to Florida after. It was me, SB. It was X, Y, and Z. Like I feel like the state likes that lie so much. They know he's lying. They know he probably did it, and that's why he said in the next part, say like, "Yeah, I killed him." But I feel like they like that lie. They need that lie so much that they just ride in with it.
Oh, go ahead, India, so we can just keep a rotation.
Well, I was gonna talk about the nut thing. Because I don't know, like, if it's the same in y'all state or not. But like in my state, if like you're dying and you say who did it, it's called like a dying declaration, and they put a lot of weight on that. Like that could send somebody to jail. Like literally, that could give somebody a life sentence, just that alone. I don't know when his dad claimed, like when he began to claim that that's what he said, because I don't think he was saying that from the beginning, but he said it in court or whatever. But nobody who was actually at the scene or any of that said he said that or anything like that. So I don't know. Like I don't know. He said that in court for whatever reason. I think they I think they only put the parents up there for like an emotional, to get emotions out of the jury. Like, but I honestly don't think he said that to his dad or anything like that. Like I think they was putting 20 on him because they want somebody to pay the price for their child's murder or whatever. But
yeah,
I just ain't down what they selling, and I feel like they've been trying to convict somebody of that Donovan Thomas murder for forever, and they don't have enough evidence. It keeps getting dropped, so now they're just wrapping it up in a bow and putting it in this RICO. Like this RICO is full of stuff that either people serve time for, or cases that they couldn't stand up on their own. So now we're gonna wrap it all up in this RICO.
Bro, there's no charges in this RICO that they haven't been. Oh, I'm lying a little bit. I was gonna say there's no charges in this RICO that they haven't been charged with before, but I'm lying a little bit because the Gunna and Young Thug, that's the only new arrest. Everything other than that has been between 2012 and 2016. That's insane. They're basically, technically, it's not double jeopardy in a RICO, but they're technically using double jeopardy to charge all these people again in a RICO, and that's sick.
Hey,
And
I'm
they
gonna
still
jump.
don't know who did it. I really thought when they brought the Thomas family up and brought up the whole murder, I really thought they knew who did it.
Well,
Them doing all that shows to me they still have no clue who did it, and that's so fucked up.
Hold on, let me say this because let D tell it. They know who did it. They know it was Woody. But I will say this. Hold on, Jig. I'm gonna say this. Okay. I will say this. I'm gonna say it's gonna be hard for the prosecutors to say Woody did this in a later trial. You said they're gonna come get Woody maybe a year later, 2 years later. They're gonna say, hey, they're gonna try to get Woody for the murder of Nut. Yeah, good luck doing that because we're gonna pull all these transcripts of the state accusing other people of doing it and not Woody. They said in the transcript, Woody, we know you didn't do it. So I find it hard for them to try to come back and prosecute Woody for the same crime in the future. I don't see it. But do you have something to say about that?
No, I don't think. I think the Nut murder would go down as a cold case. I think when they gonna harass Woody on to be something else, just like the OJ trial, like he did that, but they wouldn't got him on the trophies. Like I think it's gonna be that type of thing because you know what I'm saying. Like we all know OJ didn't deserve all that time for trying to steal his trophies back, but use your common sense. So that's where I'm at with that. But listen to this. If Woody admitted to before Nut got killed, he was in the club. He admitted to the police he got jumped and all this X, Y, and Z. Then days later, Nut get killed. Like he admitted to them that this has happened.
He admitted to him being like mad at and what he said on stand, bro. He said if he alive, I don't got a problem with him. That says a lot too.
Like he admitted to on the stand that yes, I robbed Nut and gave it back to him the next day. Like if anybody watching this trial and study what's going on, he has already admitted to it. I do not think they're gonna go back and get him for Nut's murder after that. But I think they biggest fish is that Woody is collateral damage. He was used by these folks because Woody gonna die regardless. Just like they just got Threat. They know Woody can die. That's why they willing to let him go as long as he talking or whatever. They want the big fish, which is Young Thug. Yak Gotti even bigger than Woody. They want Yak Gotti. They want Yak Gotti more than they want Woody.
They do. Well, they want Yak and they want the name. They want Yak and Thug. That's who they want.
Even though Woody
that's why y'all see say that again.
Even though Woody is the one that put all of the leg work in, just like DK and Woody put all of the leg work in.
DK did a little less, man. He was just trying.
He did a little less, but he still put his work in. He did his thing.
Hey, but let's go back to what we talked about. You said they had this big trial, right? And it was all for show. They just wanted people to know Woody did it, and they're gonna come back to get Woody with something else. What was the purpose of this trial?
To get Thug, to get the big money. You got to realize Thug has actively said
unlimited money, bro. That nigga got unlimited money.
Thug has actively said how he feels about the Atlanta Police Department. He's going viral for throwing the finger signs at them.
And he got acres of land that he just bought in Atlanta.
Yeah, Thug is one of the Atlanta natives that still live in Atlanta and has so much connections to the, you know what I'm saying, the streets or whatever. So they feel like there's a power struggle there. That's why they trying to get at him. Even if they don't even get Thug, they done wasted a lot of money and a lot of his time and all that. So their objective is you know what I'm saying. That's my whole that's my opinion. I ain't gonna say what I'm saying is facts and all that because I just know this Woody angle y'all wrong is it.
But hey, I will say though, I mean, you said that or whatever, and we know that this trial, nobody's likely to be found guilty. So at the end of the day, if all 6 of them go home, Young Thug and the rest of them, and Woody go home as well, they may try to get them later on with something else. But if they all go home, tell me how Woody is, so dumb, and he set all his homeboys free, including himself.
All right.
Woody not dumb, bro. I don't think he got a 4.0.
Hold on, y'all. Hold on, Jiggy. Hold on.
Let me tell him why. Because as great as Woody is, we never heard about him until we heard about his snitch allegations. If Woody was so smart, he would be in the lane that he's in now before he had to hit the stand. He wouldn't have had to get on the stand to get in the lane that he's in. And Woody been dropped songs and all this stuff before he went to trial.
Hey, D, real quick. Hey, they saying that it's hard to understand with all the overtalk, so we can do it one at a time, and then y'all respond after he's done, and then I just unmute this to keep the lines clear because it's hard. Go ahead, D.
Yeah, but I was saying, that's why Woody, he definitely gonna go home and all that, but he's dumb because when Thug is free, he gonna go back into hide. He going right back in the house just like Threat was in the house. I promise you. Like, it's not gonna be all this 20 versus 1, him going to these different podcasts and all this, and he's gonna be in the airport every 2 seconds in Atlanta. He was able, like, him and Kayla ran into each other in the airport on accident. Dude going back in the house, trust me. So that's the only thing. That's the only reason why I wouldn't say he's smart. Yeah, he's gonna be the one to get them out of this situation. But Woody is also the one that got them in this situation. So let's not give him too much credit.
Not necessarily. I mean, because even without Woody, we got to remember Woody didn't take a plea deal. What about all the other people that took a plea deal that testified? We can't forget about Tick.
Woody didn't get a plea deal though, bro.
No, right. I'm not talking about Woody. I'm talking about the other people besides Woody. So even without Woody, this case still could have came forward.
Why is Woody the star witness then?
Because they need the bigger charge. They need the conversation about Nut murder, and Woody is supposedly heard about Nut's murder at the McDonald's. That's why they need Woody.
Without Nut being murdered and his family in that courtroom, there is no RICO.
Well, I mean, you can say that, but it's more than one. It's what? How many counts? It's only one murder count.
Listen, but
all the other counts have
no, bro. Yo, talk.
And then I can speak, but go ahead.
Go ahead.
No, India, go ahead, India.
Okay, go ahead, India.
There's more than one murder charge. There's the Nut murder. There's the Chanel murder, and then I don't know, is Lil Rod's murder wrapped up in this, or is that completely separate, or is it one of the acts?
Completely separate.
Yeah, I think it's separate.
It's not even an act.
Oh yeah, because his only charge is the RICO. Okay,
Yes,
so
sir.
yeah, there's the 2 murders, and to me, that's what's bolstering this whole RICO, because it's not like. Can I?
No, go ahead.
Because it's like the mob where we're dealing with like millions of dollars and stuff like that. The only reason why this is a RICO case is because of these homicides that are bolstering the whole thing.
So even without Woody, they still have a homicide. So they could have brought this case without Woody.
They wouldn't have both. They wouldn't have both. They would only have the one. And I believe somebody read the law or whatever, and I think they needed to have. I don't know. There has to be certain acts within a certain amount of time or something for it to, I guess, be a RICO or something. I'm not sure. I'm not a lawyer. But
there is. That's what they were saying earlier.
And that's why those things. That's why they made those cases a part of this RICO. But like I said, the homicides are what's bolstering this case. We're not talking about a big drug ring. Everything we heard about drugs was personal use. Like, there's no big drug ring. There's not money laundering or like anything like that.
But didn't they have Tick for like robbing women? She getting
it was
robbed
all
by Tick.
It's all small petty stuff.
But a lot of that is not even in the indictment as well. But like she's saying though, there's 2 different murders in the trial.
And they only had the carjacking of the girl who was at the apartment complex.
Say again?
They had the carjacking of the girl at the apartment complex. Was that Tick?
Yeah, she testified.
Was that Tick? Wasn't that
Tick? You talking about the shooting at Shooty crib?
No, the girl, she was at the beginning, and she was coming home from work, and her baby was in the car, and like her baby had just got out the car, and like they basically like pulled up and drove off with her car, and then the other car was following.
Right.
Nah, I don't know what that was. I remember what you're talking about, but I can't bridge the gaps between the 2. But I'm saying though, like you're saying, the real what's it called? The meat and potatoes of this trial is the 2 murders. One is Nut, and the one is that YSL Ponytail client's charged with. He's the other Quay. And that's what I was arguing with you about earlier. I think that's why YSL Ponytail, his argument seems to kind of differ from the rest of the defense, but he got a little bit of a different motive because, like I said, his client is charged with a completely different murder.
Go ahead, D.
they pulling on the heartstrings, and this will be the last time I say about it because it's for sake of argument. I love it, whatever. But without Nut and that girl who when I ain't even gonna say who was shooting at him, but when they missed Shannon and shot that girl in the face, those are the murders that are they using for the emotions and all of this, and nobody's even been convicted on it. Like,
no,
Nut.
bro, they not though. They just using that to say Shannon, like that's why he's a part of YSL. Like that's why he
Yeah, that's what I'm saying. But and that's my whole, and that's why it brings me to the conclusion that without Nut dying, even though they still don't know who did it, we wouldn't have a RICO case right here. Just
That's
that
what I'm
one
saying.
murder.
It's Woody saying that the Nut shit started all this extra shit, and it's crazy because he snitched on all the extra shit.
He snitched on all the extra shit.
Like, let's say he lied about the Nut murder, which I think he did. I don't know who did it. I ain't gonna say who did it. It's all speculation. I think he told the police whatever he thought. Anywho, I think he didn't lie about all the other retaliations following that murder. He did not, and that's why he was granted federal immunity. And that's why he also know he don't gotta fuck with the state because the state don't fuck with him.
Hey, talk that law. To say that
Hey,
Woody
all this gonna get edited out. But go ahead.
it's all gonna get edited out.
Bro, my fault.
You
Nah,
good.
that ass,
They're
my
gonna cut
fault.
it
Oh well,
out.
I'm definitely gonna get edited out. We wasting time. But listen,
I mean, at least we can have a discussion for us right now. But
yeah, it's just talking then. But for
well, not really, because it gives us some understanding. Because obviously we're not on the same page.
right, but for once you said that shit, it is what it is.
I mean, but at the end of the day, I think they tried to use the RICO to group everybody together because they couldn't do the murder on its own. But they all finna get ready to go home. If everything goes as planned, and not only that, all of these charges, not only Nuts murder, but all these other charges will forever be barred by double jeopardy. So they all can never be prosecuted again. And guess what? Woody go home and they all get to go home, and the state can never get them again for these crimes. Now, if they stay in Atlanta and they keep it up, then of course they're going to come back and try to get them again. But Woody already said that that's his home. He don't plan on leaving. I think they should get out the whole state, me personally, but I don't think, that's their home.
Yeah, like literally, this is the state's last hurrah. All of this.
But salute y'all, bro.
Thanks a lot, D. Appreciate that.
All right, Jig in India.
Now go ahead, bro.
No, we're just saying he was getting out of here. Go ahead.
Oh no, I was just saying and that's why I feel like the state is they're invested in this case. They know this is their last hurrah at it. Like they know if nothing comes from this, then this shit's done. Like the feds are not gonna pick it up. Like they have to get them this time around. That's how they feel about it. And like I said before, it's all technically. It's not double jeopardy because of the RICO laws in Atlanta, but it is double jeopardy as opposed to our stating the fact that these are crimes that they already been charged for and already did time for, or already been prosecuted for, shit like that. Like, so for the state to say this is not anything new is kind of wild. It's really wild.
Yeah, I mean, and just to be clear, we all kind of just giving our own different opinions. There's no right or wrong answer. We all just feeling our way through the dark. So, ain't nobody right or wrong. So I do want to thank D for coming up, and we got to see how it play out. This case has taken so many twists and turns, a roller coaster. So we don't know which way it's gonna go next. But somebody said it's a weak case. That's why Paul Howard, and we don't know. That's my biggest deal. If this case happened in 2015, then I think the DA of that time should have handled it. I don't think it's right for a new DA to come in 10 years later and try to file charges on, maybe it's somebody she's connected to, or maybe it's one of her friends, or she want to get justice. That's why she ran for DA. But I don't think she should be able to reach back. Now, if it was a murder that happened and nobody knew about it, they found the body when she was in office, that's different. But this was known. The feds knew about it, and Paul Howard knew it, and they all passed it up. So I don't think it's right for prosecutors to have so much reach back authority for known crimes.
And that's the crazier part about waiting 10 years to prosecute a whole alleged gang on a RICO charge. Like you had all this evidence. What were you waiting for? For something else to happen? Like I don't get it. Like why Why wait 10 years for a RICO charge if you're gonna use all the same charges that you used 10 years ago? Like that doesn't make any sense.
Right, and it's so much harder because 10 years pass. I mean, memories fade. People feel different. Yeah, I mean, imagine when people get into a fight, they may call the police right away. Say, "Oh yeah, I want him in jail. He assaulted me." But then a year later, when time for trial, "Oh, he didn't do that. I made it up." They want to file the affidavit, non-prosecute. They backtracking. Imagine 10 years. It's so old. Even a woman that was robbed, she came to court. She was backtracking. Oh, you know, I don't remember. I don't want nothing to happen to them. I don't want him to go to jail.
Bruh, even buddy that got his whip stolen when they allegedly did the crime or had the flying car shit, he said, "Nah, like I don't know what y'all talking about. Like what? This is all me." Like
she say Woody. Somebody saying Jason Hodges said Woody might plead the fifth. I'm here. Woody don't.
Like he said before. No, he ain't. No, he
nah,
ain't.
he not. Yeah,
Right.
he not pleading the fifth again. He gonna say whatever they want him to say. Not the state, the defense. He's just gonna give the state a hard time, but he gonna say whatever the defense want him to say. I see that happening vividly.
I mean, Miss Teresa Jones had a good point. Could it be that Fannie had a close relationship with Nutt? Now she wants the case to reopen. Yeah.
In hindsight, though, I think that was part of it. I don't think that was all of it, though. Like, yeah, that definitely helped. But she got a lot of ulterior motives. Like, yeah, I don't know what relationship she might have had with him, but they had one for sure. Secondly, she's trying to run for AGA right now, and thirdly, like she about to lose the Trump case. She got to win something. Like I see a lot of ulterior motives for her.
That's what I was thinking because she came out. It seemed like she liked these big cases. She wanted to do press conferences. Most DAs, they file the indictment. They may give a little press release to the press, a note, a letter, and they done with it. But she's always in front of somebody's camera trying to elevate herself. Maybe she want to run for state office or maybe the Senate or something like that, or get picked for, to go to the White House and work there like Keisha Lance Bottom. But that's not in her cards. I mean, she fumbled this case bad, and then in the Trump case, it found out she's using the money that she was paying Nathan Wade to go on trips with. They hide the money in her mattress.
Did you see the
I mean, it's a lot going on.
Did you watch the hearing with the
Tricking is a habit. I'm sorry, India.
Talked a lot. Did you watch the hearing with the young lady who worked at the she worked under Paul Howard, but then under Fonnie, and she had said something about the like misappropriation of funds, and like they started treating her bad and stuff. Like, did you see that hearing?
Yeah, from my understanding, she worked in a division that they received a grant from the government, and that grant was specifically for like the youth and to keep them out of trouble, so they don't keep getting into trouble. To keep recidivism. I mean, they want to keep them from going back into the system over and over again and getting out of jail, going back. But Fonnie was using the money for a totally different purpose. And then the prosecutor said, "Hey, you can't do that." And then next thing you know, they start messing with her, moving her around, demoting her, and then finally they just kicked her out altogether. So it's a lot of corruption going on in that office. And somebody say, "Why y'all keep talking about it?" Well, if they quit doing it, we won't have nothing to talk about.
And I still wanted to say
that ain't how it
works. Can I say something else?
Oh, yeah.
Okay, and then also, I just think Fonnie in general, she came into the office, like you said, with big aspirations. Like this wasn't her final stop. Like she had some goals. So she wanted to make it look like she was tough on crime by cleaning up the street, the gangs and stuff like that. She wanted to make it like she was tough on crime. She wanted to make it like she was just no nonsense, whatever. And she basically like jumped the gun. Like it would have been better for you to take your time and build a case properly versus just hopping out. And regardless of what happens, because I honestly, unless it's like a mistrial or a dismissal due to like a technicality or something like that, I honestly don't think all of those guys are going to go home scot-free. I really don't. They're not going to. They might not get life sentences, but I don't think they're going to get off scot-free.
No, I'm sorry. Go ahead.
Yeah, I mean, I don't see them splitting up the verdict. Like, oh yeah, count 37 guilty, but count rest of the count.
Don't they have to do that when they fill out the forms and stuff though?
Yeah, but I don't see them splitting it like that. Somebody say Fonnie wasn't going with him because of the age difference. Nah, don't get caught up on no age.
Yeah, that don't mean nothing. And she's not that old. She's not that old.
Oh, that's different now. You say you got personal knowledge and you know them, that's different. But if you just going by their age difference,
Tell
that's a
him join.
different story.
You got personal knowledge about them.
I do think she have it out for like Thug and like people that are affiliated with him, though, like his family and stuff. I do think like there's a personal element to it. I ain't saying she messed with the guy or whatever, but there's definitely like I don't know, there's other things at play versus just I want to clean up the streets.
Yeah. Hey Nick, you want to join? Let me know.
What you say, bro?
And I was telling Nick if he wanted to join, let me know. He said he know them.
He don't want to join. He want to chat.
He want to chat.
Nah, I'm playing. Anywho, what I was saying.
He want to chat.
Nah, I was saying if Fonnie really had that relationship with Nut, it would make sense as opposed to or why all this is going on. But even if she didn't, I think she's just the type of attorney general that she just wants a big case. And like y'all said, I think she just thought she bit off more than she could chew for it to a certain extent. She thought after getting the YFN pleas and shit that the same thing would happen in this trial, and that just hasn't.
Hey, Nick said he coming up. Well, keep going. I dropped the link for you, Nick. Go ahead, G.
Join up, Nick. I'm saying though, I have mixed feelings about Fonnie. I don't think she's solid in any sense of the word, but I don't know if I believed her and Nut rumor like that. But I'm saying though, her whole stance in all of this though is to get a lot of big name trial and hope just go in her favor. The Trump shit didn't work for her. The YFN shit only worked because they pleaded out, and this YSL shit just looking bad for her. They had to recuse the judge. It's slow. So her plane is going
Wait
a
minute. Wait. Keys Mobile. Wait, who father was just arrested? Keys Mobile?
Not Big Jeff. Don't say that.
Right. What's she talking about?
Podcast.
Yeah, I don't know what she meant by that.
Check Thugger Daily. Here, no.
But I don't know. I don't believe the whole relationship thing because I feel like somebody would have spilled some tea about it already. Like there would have been some pictures. There would have been something already.
I frankly do believe that though, man. Like it's not far. It's not
far fetched, but I think somebody would have leaked something about it.
Nah, that's valid.
Hey, Nick.
There would have been a little more proof as to now.
Wait, they say Big Jeff was. He was just on a podcast.
Stop.
Wait, she said it happened a couple of days ago. Well, he was just on a podcast, so.
Big Jeff was arrested.
Hey, when was he arrested, y'all?
I think Nick's backstage.
Yeah, hey Nick, can you pop your camera on real quick? We just want to make sure.
Yeah, why ain't your camera on though?
You're real.
I don't want to be on camera.
Put your camera on for a second.
Okay, all right. I see, Nick.
Oh no, Nick said he.
No, yeah, Nick good. Okay, let me let him. I'm gonna let him up. I just making sure hey, we got a lot of bots and all this. Go ahead, Nick.
Yeah, what's down, bro? I done been on your show before, homie.
You have?
Yeah, bro. I done talked to you a minute. It was a few.
Nah, you cap. You ain't been on here before.
Hey,
man.
bro,
We
come
would've
on. I ain't gonna
remembered
do
you.
that, bro. I ain't looking for no clout, bro. I ain't doing all that, dog.
When
Hey,
did
look,
we talk?
Big Jeff did just get Miss Sylvia, the one who told everybody last night. Big Jeff got locked up a few weeks ago, bro. He got pulled over for a light on some shit, and some more shit happened. But make a long story
he bonded
short.
out since then. Okay.
Yeah, like he out. He out. He doing his podcast, bro. He was just on his podcast earlier today, bro. He just had Kayla bump.
Oh, so he free now though.
But yeah, bro, like a lot of people saying, like, yeah, Nut Fanny went together. Man, not them folk then, bro. Not
What you say?
Fanny and Nut did not go together, bro. I know both parties.
Not at all.
I know both parties. May Nut rest in peace, bro.
Like never even
Come
laid
on,
down
bro.
with each
If
other,
I
you
tell
think?
you this, bro, you ain't gotta constantly keep asking me, dog.
Nah, like I ain't gonna say they was in a.
Listen
I
to
ain't,
me, bro.
listen, bro. No,
To
listen
me.
to me real quick. I ain't gonna say
You
they was
over
boyfriend.
talking everybody already, bro. Like,
I
listen
don't
to me.
think
Listen
so.
to me, bro. I'm gonna say it one time only. The man didn't go with that lady, bro.
But now I'm saying
this got something to do with if game, bro. This is
yes, sir.
if
But
game.
now I'm
This
saying
is if game business, bro.
Let him finish,
Like,
then he'll respond.
like Fanny came from California, bro. Fanny
you said Fonny
family.
came from Cali.
Listen to me, bro.
Hold on, Jig. Let him finish, and then respond after he done. So we don't
Fanny
talk.
family came from Inglewood family. Fanny's from California. Fanny's not from Atlanta, Georgia. I'm from Fulton County. I'm from Atlanta, Georgia. Born and raised here. Like, she even gave the RICO to the APS, the Atlanta Public School teachers. If y'all pay attention to it. Like, this lady, it was somewhere she had to fix. This with Inglewood family, bro. Like, Nut was a part of Inglewood family.
Okay, so
it's something to prove a point on. This is proving a point what she's doing the thug. She got a thing to prove a point for this Inglewood family, bro. Her family is Inglewood family, like these folk gang members.
Yes, sir.
Like,
so you saying she locked in with IF, but not necessarily not.
it's not necessarily that she's locked in with his mama now because she told his mama she was gonna get justice for her son.
Yeah, but no, but you saying like she got some type of quote unquote relationship with IF, no?
Bro, that ain't my business, bro.
Yeah, no,
I'm
no,
telling
I
you
thought,
details. I'm
yeah,
telling you.
You just got up on here talking about it. Now it's
1,000%. It's
Hey,
not your
baby
business.
girl, chill.
On my mother, it's
This
not.
is a
On my mother,
talk
it's not.
show. Listen, this is a talk show. This ain't for you to get up on here and yeah, this ain't your platform, baby. You can't do that. This man,
Wait, who you talking to?
I'm talking to you. I ain't
I
talking
don't
to
know.
you right now. I'm talking to the girl who just yelled. Listen to what I'm
I'm
telling
not
you, bro.
yelling. I'm just saying
Nah,
you got
Hold
up
up, baby.
on
Let
here.
me
having
finish. Let me
dialogue, bro.
finish. We can all talk. We can all sing together, but we can't talk together.
We having dialogue, bro.
The thing is,
let him finish, and then we can respond.
the
He got some
thing is
insight.
right now, bro. Fulton County has messed up 36 million of taxpayers' money.
Wow, that
What
much?
Fanny did with 3 cases: Trump, Thug, and Lucci.
Yes, sir. So I now can I talk now?
Let me finish talking, bro. Let me
Okay,
finish
my fault.
talking. The reason why Judge is doing what she's doing now is because she gotta fix what Fulton County just messed up. She ain't trying to throw Glanville under the bus, but she's throwing him under the bus. It's a lot what people don't know, and they just talking. Everybody can say allegedly. What I'm saying can be allegedly. But the whole thing is, bro, it's way bigger than what everybody seems it may be. No, she got a thing for Thug family. The whole family. You see, the brother, he can't even get out. He deaf. He deaf. He can't hear. He can't do nothing. He can't even get out of jail. You know what I mean? So you got to go back on everything. The nephew got a life sentence for killing a girl. Like, she got a thing for his family, bro. So she's trying to show what she can do. Like she just said, I cleaned up Cleveland Avenue. I did, man. 3 folks just got shot over there on Cleveland Avenue today. Today.
Rest in peace, them young brothers.
They ain't dead. I don't know if they dead, but 3 people just got shot today on Cleveland Avenue.
Oh, you from the A?
Bro, I just told you I was born and raised there, bro. I'm from Fulton County.
Can I talk now or nah? You done yet?
I'm listening, bro.
Huh?
Go ahead, Jiggy. I'm gonna mute the mic so we don't have the
Now I was gonna ask though, like, so you saying that she might have not have been like romantically involved with Nut, but she got quote unquote certain ties to his gang. That's what you saying?
Correct, bro.
Yes, sir. So now I'm saying you sound like a man to me. I'm saying like you know how certain relationships go with women and men and shit. Like you saying even if they're not quote unquote in a relationship, boyfriend, girlfriend, like giving each other titles, like there couldn't be any romantic relationship.
That, bro. Nut was a club popper, bro.
He was a club popper, not a lawyer popper. That's what you're saying.
Listen to me.
Yes, sir.
Nut was a club popper, bro.
Yes, sir.
Nut was with his old lady before he got killed. His baby mama.
Wait, my fault. I missed that, bro. Say that again. My fault, bro. I missed that. Say that again.
Nut was still with his baby mama before he got killed.
Okay.
The same girl who got his little boy and his little girl.
Yes, sir.
You know what I mean? So like, it just.
Hey, man to man, though, like you got a big lying on. I don't know what you got, but I ain't gonna get to that. Never mind. I'm just saying though, I'm not gonna say like they was giving each other titles, but like I just think there's too many rumors around that for it not to have any type of foundation, in my opinion. But like you said, you from Atlanta, you way in more in the mix than me. But I'm saying on the outside looking in, like.
Paul Howard didn't want that case,
I'm gonna
bro.
say this, like what
let me tell you something. Paul Howard didn't want that case.